Good morning, everybody. Happy Monday. Welcome back. It's day 26. How do you guys think Trooper Paul slept this weekend? Do you think he got a lot of rest? Do you think he's ready for today? Oh man, if I were Trooper Paul, I think I probably might have had a few stiff ones this weekend. And yes, I mean alcohol, guys. I mean alcohol. Well, we can assume we're going to start the day with Judge Bev's ruling because the Commonwealth has to finish their direct examination. So we need to know if he's going to be able to bring in this brand new opinion of, I looked at the video and I just really don't think that her taillight could have broken from that impact. Why? Materials analysis, force calculations. No, I just don't think so. Did you take measurements? No, it just doesn't look like it to me. Need to see if he's going to be able to get that in front of the jury. The irony in all of this, of course, is that we're coming tomorrow for voir dire of defense experts because the Commonwealth is complaining they aren't qualified to do accident reconstruction. They aren't qualified. The guys with the PhDs in biomechanics and stuff like that, they're not qualified to do accident reconstruction. But this guy, he can look at a couple videos. He can look at a couple videos and he knows. He can tell us. It's just crazy. This case, it just gets crazier and crazier. All I can really say is that we seem to be in the final days of the Commonwealth's case. And I'm sure I'm probably not the only person who's going to have a little champagne on ice, just ready for those glorious words, Your Honor, the Commonwealth rests, and we are going to celebrate. We are going to celebrate. Thank heavens. Then we're going to get to experience Lally on cross. I'm hoping it won't be as horrible as I am afraid it will be. But gotta say, I don't have high hopes. Don't have high hopes. Just haven't seen the kind of trial skills from this guy that would suggest to me he knows how to do an effective, tight, disciplined cross. Not expecting to see that from him. Well, we got jury instructions over the weekend as well. That was kind of interesting. We got the Commonwealth's proposed jury instructions. So I put that up on my Substack, just a short write-up on what I saw when I looked at them. A lot of things caught people's attention. I know that some folks saw they hadn't proposed an instruction on reasonable doubt and stuff like that. Well, I looked over the way that Massachusetts kind of sets out their form instructions and how it works, and I'm not sure that's a fair criticism of what the Commonwealth has proposed here, because what it looks like to me is that there's a standard script that Massachusetts courts uses that has all of that preliminary type of stuff about it. Here's how you're to consider the evidence. Here's what the deliberations process looks like. Here's what these terms mean. And so there is definition of reasonable doubt in there, along with, just a variety of other kind of general instructions about how the decision-making process works. But there are still some things in there that are, little eye-opening, little intriguing, big tell to me in all of it. Why are you asking for lessers on involuntary manslaughter if you've got such a rock-solid case for intentional murder? Intentional murder all the way down to involuntary manslaughter, negligence, a negligence standard. Negligence is it's the lowest possible mental state for criminal culpability, and it just basically means, well, you weren't careful. A reasonable person would have been more careful, and you weren't. You did something that was imprudent, and it led to his death. And so negligence is often comes up in the traffic context because it's things like you didn't check your mirrors before you changed lanes. didn't use your signal. You were traveling a little fast for the conditions. Things like that, just ordinary things that people do. You know, you do. It's not ideal. Of course, in a perfect world, everybody would drive perfectly every moment of every day. But, you know, people make mistakes. It happens. But they're not trying to create a hazard or to be dangerous out there. That's what negligence is. Okay, so a massive downgrade from the Commonwealth here, because they're not sure. They're not sure the jury is even going to buy. They are not sure. They know. They think there's a decent chance the jury is not going to buy, despite all this Aruba stuff, despite, you know, trying to get this toxic relationship stuff out there. This idea that she's a whack job. She's a whack job. She's a psycho, jealous ex-girlfriend. Except they weren't exes, right? They'd reconciled. Just don't know where we're at with this motive. Really don't. And so the Commonwealth knows. They know that the jury has a pretty good chance of looking at this and going, I don't see anything intentional here. I don't see it. We're putting just a lot of weight on this vehicle data analysis. These conclusions about what it shows that don't take into account the conditions that are, frankly, we don't even know that we're dealing with the right time frame, because these aren't data points that are associated with a time. They're associated with a mileage. So we've had to go back and calculate back. Trooper Paul had to go into Google Maps and calculate the mileage for all of the known destinations, from 34 Fairview back to One Meadows Ave, from One Meadows Ave to the waterfall in the morning, from the waterfall to Jen McCabe's house, from Jen McCabe's house to John's house, and from John's house to her parents' house in Dighton. Had to calculate all of that mileage and still barely make it fit. Right? The key cycles that they're interested in, they can just barely make it fit if Karen takes the shortest, most direct possible route between all of these different locations. So what happened to going back to 34 Fairview in the morning? We literally just were hearing that from Tully. Just hearing that from Tully. This implication that they caught her on the cameras. Right? And she would have been heading back in that direction, and in the ping, you know, she would have been headed back in that direction, because they're trying to suggest, I don't know why. I mean, I don't know why they're trying to suggest she already knew he was there. And that's their explanation for why she was able to see him in the front yard of 34 Fairview when Carrie and Jen didn't. I don't know, maybe she was looking out the window. Maybe she knew where she'd been parked. But so they're really trying to put her back there that morning for some reason, and yet putting her back there in that time frame, it destroys their reconstruction. It destroys that vehicle data, because now your mileage is off, and that's not the point in the mileage when she would have been in front of 34 Fairview. So it's just crazy to me how all over the place the Commonwealth is with all of these different theories in their case. They can't give us a consistent timeline. They can't give us a consistent motive. They're just throwing all this stuff out there. They can't even really give us a consistent account from 34 Fairview, from all of these different witnesses. We don't know where Brian Higgins' snowplow was parked. We don't know when Colin left. We don't know when the SUV pulled away. I mean, Jim McCabe says it's about 12:45, right? It has to be, because she's got to explain those texts and phone calls that she was making to John's phone, that the defense is like, that looks like you're looking for his phone, doesn't it? 12:45, she says she sees the car pull away from the front of 34 Fairview. But then we hear Trooper DeChico is reviewing the ring camera video, and he's got a note that she's arriving home at 12:41. She wasn't leaving 34 Fairview at 12:45 if she's getting home at 12:41. So all of this is just all over the place. They're throwing all these facts out there, and I have no idea which version I am supposed to believe and why. The Commonwealth seems to think, well, I'm just going to sort it all out for myself. And they don't appear to recognize that if you leave it to me to sort it out for myself, we're going to sort it out as not guilty, because it's your job. It is your job to explain that. It is your job to reconcile these conflicts and tell me, which one of these am I supposed to believe, and why am I supposed to believe it beyond a reasonable doubt? And by the way, how does that prove the crime that you've charged? The crime of murder. Well, we know now that they realize, yeah, maybe it's not murder. Maybe it isn't. Maybe the best we can hope for here is that the jury just believes that she hit him with her car. Not on purpose. Not on purpose. She backed up too fast, trying to get away. Maybe didn't even know she hit him. Something like that. Leaving that door open for the jury. Involuntary manslaughter. It just, what a contrast. What a contrast with all this commentary out there about how we really don't even need to be having this trial. Like, she's so obviously guilty. She murdered him. End of. End of. And here we are looking at involuntary manslaughter. Just tells me a lot. It tells me a lot. Now, there's no law against the prosecution asking for lesser included offenses. There's no law against that. Of course not. Of course not. They're entitled to, although in fairness, in every state they're not always entitled to, but in Massachusetts they are. In my state they are as well. And either party can, if it's supported by the evidence, if the evidence is such that a jury could conclude only this lesser crime was committed, not the greater crime, then yeah, it can be given at the request of either party. But it just speaks to the mindset, because normally it's the defense that's asking. And the reason why is because the prosecutor has so much control over what's gotten charged in the first place. They're the one who are there they're at the grand jury, presenting the case, telling the grand jurors what they think it means when they have no opposition from the defense at all. So they have every opportunity to charge whatever they think the evidence will support. And it's perfectly reasonable, perfectly consistent, perfectly common to charge crimes in the alternative. Right? We think it's this, but in the alternative, it might be this other thing. Very common to do that. They didn't do that here. No, they charged her very specifically with second-degree murder, operating under the influence and causing death, and leaving the scene of a crime. And the reason why they did that, in my opinion, is because these are independent crimes. These are not lesser included offenses of each other. And so it means they can convict her of all three for the same act. She can be separately punished for all three for the same act, and it doesn't create a double jeopardy problem. Double jeopardy is one of these constitutional protections that's kind of been defined down to very little. I mean, it means very little, because basically the way the courts have interpreted it is to say that, well, if crimes have different elements, if they define different wrongs, then you can be convicted of all of them. The legislature is intending for them to be separate crimes by requiring proof of different facts. So you can be convicted of multiple different offenses for the same action, and it's not a double jeopardy problem. It's only when you're dealing with lesser included offenses, ones that All of the elements are the same, except then you add one for the greater, or you add another, you know, for a greater above that. Because then the lesser crime is just necessarily included when you prove the greater crime. So that one would be a double jeopardy problem. But if they're not lesser included offenses, no double jeopardy problem. So that's why they charged it the way they did, is because they wanted to max out the risk here for Karen to go forward, right? This is what Trooper Proctor was talking about. There's going to be very serious charges brought against the girl because they wanted to lean on her, because they really wanted her to just plead guilty. And most people in that situation, most people that they're used to dealing with, they probably would. They probably would, because they don't have $500,000 or so, $1 million, whatever, that they can spend on a defense, on being able to bring in a lawyer who's going to fight, bring in the experts who are going to be able to do this work for her, and to pick apart, put in the time to really review and pick apart the Commonwealth's case. Not a whole lot of people in the criminal justice system in that position. So I don't think they anticipated that. I don't think they realized that she not only had the means, but she had the motive to clear her name, to see this thing through, to take it all the way. So no, they thought she's just like anybody else. We'll lean on her. She'll be scared. She'll take a plea to something, and that will be that. They had control over the charges. So yeah, back when they're presenting it to the grand jury, back when it's just their show, just Michael Proctor's case, just the case that Michael Proctor built, with those taillight pieces and those statements from the witnesses they talked to. Not all the witnesses, of course, but just those early ones, right? Jen McCabe, Matt McCabe, Julian Chris Albert, Brian Albert, Nicole Albert, just those ones. Then, then they think it's second degree murder, and that's what they push for. But now, gosh, you get a little bit of pushback from the defense. Look at that. Your case starts to crumble. Now you're backpedaling pretty hard. Backpedaling all the way to involuntary manslaughter, because you're hoping so much that the jury wants to convict her of something. I mean, I think you, the Commonwealth, know there's going to be people on that jury. Murder's a no-go. Absolutely not convinced beyond a reasonable doubt. I'd like to think it's all of them. I really would, but you don't know. You don't know. Jury is a mix. It's always a mix. You get people with just different sympathies, different alignments. Some people are going to walk into that jury box and they identify with the prosecution, and so they're going to look at things in that light. They're going to try to give the prosecution the benefit of the doubt. They're going to try to see things that way. Other people, they're going to walk into that jury box and they're going to feel like they're on the defense side. They're going to feel like that's my natural inclination. So I'm going to be very skeptical of the Commonwealth's case. You really don't know what you're going to get, but most of the time you're going to get a mix. I mean, it's just nobody is really typically lucky enough to get all of their own people, 12 of them sitting in that jury box. So the Commonwealth's got to know there's at least a couple people on here. They walked in thinking, I'm going to be paying special attention to the defense in this case. Yeah, murder's a no-go. It's a no-go for those people. And so now you're just desperately trying to pitch something to them, something palatable, something that will save this case, save you guys, save your reputation, save them from the civil rights suit that can be coming? I got some stuff I can talk about that. Well, it looks like they're getting ready to go, guys. Let's get the sound on here. I think they're at sidebar right now to start. But yeah, boy, the civil rights suit. I kind of think that's coming. I was doing some research this weekend.
All right, so we can bring the jurors in. Good morning.
Good morning, Judge.
Tori.
So I don't know that we're getting the ruling on the record. We'll just find out. We'll just find out when Trooper Paul gets back on the stand if he's going to get to do it or not. Mr. Jackson doesn't look happy.
You are unmuted.
Hear ye, hear ye, hear ye. All parties having anything to do before the Honorable First Justice Beverly Benoni, now sitting in the Norfolk Superior Court within and for the County of Norfolk, draw near and give your attendance, which shall be heard. God save the Commonwealth, Mr. Court, but thank you be seated for the now session
Good morning again, Counsel and Ms. Reed. Good morning, jurors. I hope you all enjoyed this gorgeous weekend. I have those 3 questions to ask you. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left here on Friday?
Yes.
Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here? Everyone said no or shook their heads. Thank you very much. Could we please have Trooper Paul?
I said last week, guys, and I'll say it again. If they let it in, this could very well be an own goal by the Commonwealth.
So, Mr. The evidence being recorded during the case now in here and the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Morning, Trooper. All right, Mr. Lally, whenever you're ready.
Good morning, sir.
Good morning.
If you could just again, please state your name and spell your last name for the jury.
Yes, it's Trooper Joe Paul. That's Paul.
And sir, if I could just take you back to a couple different portions of your testimony from Friday. With respect to the acceleration and braking tests that you conducted in the driveway area or outside of Camden Police Department, was that before or after Ms. Hartnett from Crime Scene Services Section had
Somebody
processed
watched my stream?
After.
And so as far as anything that was removed by her, that was done prior to you conducting any of your tests, is that correct?
Correct.
Now, you've investigated approximately 191 crashes over your time with the cars unit with the state police, correct?
Correct.
Now, I'm going to ask you just some general questions with regard to a number of those crashes have involved motor vehicles, collisions with other motor vehicles, correct?
Yeah,
Yes.
she's letting it in.
Now, in general terms, with respect to motor vehicle collision, what, if any, you talked a little bit last week about sort of area of impact and point of impact, correct?
Correct.
Now, that's with regard to the roadway, is that correct?
Yes, it is.
So with regard to the vehicles coming in contact with each other, what, if anything, regarding damage would you expect or anticipate based on your experience in general terms when vehicles come in contact or touch with each other in a collision sequence?
Objection.
No, I'm going to allow it. In general terms, what do you look for?
So we look, well, it's two times of damage onto a vehicle. One's contact damage and one's induced damage. So when we look at vehicles, we are looking for what's called as contact damage. And the induced damage is basically, start from the beginning. So contact damage is the damage that is actually made direct contact with another vehicle. And induced damage is the damage that did not make direct contact. So for example, if you push in one piece of metal to make contact, the rest of the metal will make a rippling effect that would more cause induced damage.
And just again, in general terms, as far as vehicles coming in contact with each other in a collision sequence, what, if anything, would you expect or anticipate based on your experience to sort of transfer from one vehicle to the other event?
It's possible when you transfer, you can have paint transfers that come from one vehicle to another. You got tire rub off that go from one vehicle to another. Scratches that would come from one vehicle to another.
And again, sir, just in general terms, when it comes to vehicles interacting with each other in a collision sequence, what, if any, role does the respective heights of those vehicles play in respect to contact damage or inducement?
Yeah, it depends on their heights and how they relate to each other. So that kind of shows if one vehicle is taller, one smaller, it's going to show where the contact damage would be from one vehicle to another based on their height.
So based on respective heights, contact or induced damage could be in a different location from a bigger vehicle to a smaller vehicle, correct?
Correct.
Now, if I could turn you back to the text stream analysis that you conducted with respect to the defendant's vehicle. Now, there were two events
I think
that
that's a
occurred,
good point, Tim Cat. That's her being even-handed.
On that 12,629 miles deep, there were two events that occurred within that trigger, within that mileage. Is that correct?
Correct.
And based on your analysis with respect to the odometer readings and the mileage, where is it what is your belief as to where the vehicle was when those two events, being the 3-point turn and the backup straight for approximately 60 some odd feet, where did those occur within the travel path of the defendant's vehicle?
So the first one with the 3-point turn, in this case, it appeared to be possibly on to, it was a Cedar Crest, which, because we know based on testimonies that she missed the exit to Fairview and had to make a U-turn onto Cedar Crest, and that would make sense to why they would occur with close proximity to each other.
Gosh, I gotta wind up
They're
with
within the
this morning.
same odometer mileage and on the same key cycle.
And so that reversed 24.2 miles per hour for 60 some odd feet. Where would that have occurred geographically from your review of the odometer reading?
It should occur probably on Fairview.
Now, sir, based on the totality of your analysis and your investigation in this case, what, if any, conclusions did you come to as to how this collision sequence occurred or how this crash occurred?
Yes. Should I show my report for that, or should you want me to just kind of go off
You
the?
guys want to look at your report? Is that what-
Yes.
Sure, go ahead.
Okay.
Thank you.
Let me continue.
If you could, please.
Okay.
What, if any, conclusions did you come to through the course of your investigation?
So on Saturday, January 29th, 2022, at approximately 12:45,
So you can look at your report, but you can't read your report.
I
So,
read my conclusions based on what they asked me to do. Okay.
yeah. So I can't hear you.
Sorry.
Okay. So just take your time, read your report, and then answer Mr. Lally's question. And if you need to look at your report, we'll see about that again.
All right.
Ask the question, Mr. Lally.
Based on the totality of your investigation, what, if any, conclusions did you come to with regard to how this collision occurred?
So this collision occurred on Saturday, January 29, 2022 at approximately 12:45 hours. A 2021 Lexus LX570 was traveling southbound on Fairview Road, in Area 34 Fairview Road.
Yeah.
It appears that.
So,
Sorry, I'm trying to
so
upload it.
you know what? I don't, Mr. Lally, break this down. Ask simple questions so that the witness can answer your questions.
Ask simple
We
questions.
don't need a narrative.
This late in the day.
From your investigation, what, if any, conclusions did you come to as to where this collision occurred?
So, all right. So, on the night of Saturday, January 2022, at approximately 12:45 hours, a 2021 Lexus LX570.
Can you slow down, sir?
So, yes.
So forget all that part,
Okay.
Trooper.
All
Just
right.
answer the
Just answer
question.
the
Where
question.
did it occur?
It occurred in the Area 34 Fairview Road.
And who, if anyone, were the participants in this collision scene?
The operator appeared to be Karen Reed, and the pedestrian was John O'Keefe.
And where was the vehicle located in reference to the residents of 34 Fairview?
It was located along the southbound travel lane and to the left side of the house as you look at it from the front.
And as far as the vehicle, what, if any, directionality did it head in, and what, if any, interaction
Directionality
did it
again.
have with Mr. O'Keefe?
So the vehicle was traveling in reverse along the southbound travel lane, traveling north.
And how fast was the vehicle traveling and over what distance?
The vehicle traveled up to 24 miles per hour and approximately 62 feet.
And at the time that the vehicle was traveling approximately 24 miles per hour over approximately 62 feet, what, if anything, occurred then?
The right rear of the Lexus struck the pedestrian John O'Keefe.
And post-collision, what, if anything, occurred with regard to Mr. O'Keefe?
Mr. O'Keefe was projected forward and to the left along the front yard of 34 Fairview Road.
And post-collision with Mr. O'Keefe, what, if anything, did the defendant's vehicle?
The Lexus continued traveling in reverse before they left the area.
Now, as far as the vehicle itself, from your inspection, what, if any, role did any mechanical aspects of the vehicle play in this collision?
There were no mechanical defects.
As far as your analysis of the roadway and other factors related to that, what, if any, role did they play in this collision sequence?
There were no roadway or environmental factors that contributed to this collision.
No
Sir,
environmental
with
factors.
respect to your investigation, what, if any, opinions did you draw based on your training and experience in regard to this collision and how it occurred?
May I look at my report real quick? Just to make sure.
Yes.
Thank you.
We've been hearing all about the snow starting to stick, but now there
Right.
can't be any environmental factors. Please.
So throughout my investigation, this appeared to be a single car collision involving a pedestrian. The vehicle was traveling at a higher acceleration when, sorry.
Oh, man.
The vehicle
wow.
accelerated at a high rate of speed before he
He's
struck the
nervous. He
pedestrian
knows
John
what's
O'Keefe
coming.
on the roadway and subsequently left him at the scene.
And with respect to the backup safety system that you observed in this vehicle and made use of in the course of your visibility analysis, what, if any, role do you, is it your opinion that played in how this crash occurred?
Based on the visibility analysis. So even if the camera systems were covered in snow, even the systems were defective anyway, and even the mirrors were blocked, an attentive and a reasonable operator would not travel in reverse, especially at a high rate of speed. They would have cleaned the mirrors off. They would have made the cameras and systems, if they worked, if they didn't work, they would have done all this prior to accelerating in reverse.
The objection sustained.
Move to strike.
I'm going to strike that.
Now, with respect to your observations during the course of the visibility analysis, the exemplar pedestrian that you placed in the right rear of the vehicle, was that exemplar pedestrian visible to you at the time that you conducted that visibility analysis?
Why didn't they
Yes, it was.
video that one?
you, sir. I have no further questions.
Oh, so
Okay,
no.
cross-examination?
Thank you, Your Honor.
No, nothing about the tail light.
So
Take
do
a
you
big
have
old
any,
drink.
do you hold any degrees in the scientific discipline of mathematics?
I do not.
Do you hold any degrees in the scientific discipline of physics?
I do not.
Hold any degrees in the scientific discipline of biomechanics?
No.
How about in engineering?
No.
How about in kinematics?
No.
What's the highest degree that you do hold, sir?
I have an associate's degree.
In what?
Administration of justice.
Ooh.
You mentioned kinematics on Friday. Do you hold any certificates in the specific area of kinematics?
Yes, it's covered in the basic crash investigation classes.
Okay, so you took a class, in other words, correct?
At multiple classes.
You introduced the idea of what kinematics is, right?
Correct.
Testified about that on Friday.
Yes.
Define kinematics, it's yours.
It deals with the aspect of motion.
It's a subfield of what broader
Oh,
field?
God.
Kinematics.
Kinematics is a subfield of what broader discipline of science?
I'm not sure.
Physics, correct?
Yes.
And it describes how points and objects, systems of objects, how they move, and how the rate they move and the rate of their velocity, correct?
It deals with emotions.
What's that called? The rate of velocity. What's another word for that?
The rate of velocity.
Right.
I mean, it deals with the motion. It deals with forward, and also deals with speed. It deals with travel and speed. If something's moving, it also has a speed to it.
Right. The word you're looking for is acceleration, correct?
Sure.
What role does acceleration play in the field of kinematics?
What role does acceleration play with in
Yes.
kinematics?
Correct.
It talks about, like you just said, it talks about the speed and talks about motion.
Is kinematics also known as the geometry of motion? Is that correct?
I have not heard that.
Never heard that. What's the difference between constrained and unconstrained motion?
Constrained and unconstrained motion.
That's what I asked.
Constrained motion. I can't recollect at the moment.
Constrained motion is motion on a predetermined path, isn't it?
Yes.
Unconstrained motion is what?
One doesn't have a predetermined path.
Free movement, correct?
Correct.
You couldn't remember that from your class?
For the most part, we don't go that in depth, constrained and unconstrained.
Constrained and unconstrained, not restrained.
Sorry, unconstrained. Yes.
Kinematics uses algebraic formula to model these motions, right? Motions of these points, systems of points, correct?
Yes.
And it includes concepts like displacement and speed, velocity, distance, acceleration, which we've talked about, correct?
Correct.
And it looks at how these things, these values vary over a point in time, or duration in time. Is that right?
Yes.
Do you actually understand the physics behind the study of kinematics?
Yes.
The word you learned in class.
Yes, we had to go over the physics part of it.
On Friday, you said that this incident is a pedestrian strike from a vehicle. You reiterated that again this morning. Is that right?
Correct.
I want to be clear. That is your opinion based on your training and experience, correct?
Yes.
And on Friday, you said you based that opinion on the fact that you noted a half-mile-an-hour decrease in speed and a steering input of less than 10 degrees at some point in that reverse motion, correct?
I said that was consistent. That data point in general was consistent with something that you would see within data of a pedestrian striker striking something else. I do go on my report saying I can't say that's definitely where a pedestrian was struck, But
I'm sorry, I can barely.
it wasn't definitively, sorry, in my report, I do say, I can't say that is definitively where the pedestrian struck.
Cannot say this.
Definitively, yes.
Okay, so you're going to have to slow down and speak up, okay?
All right,
You just said, I just want to make sure I'm hearing you correctly, and I apologize.
okay.
You said you cannot say definitively that that resulted in a pedestrian strike.
That data point within the text stream data is what I'm talking about.
Okay.
That specific point, that time frame.
Because there's a multitude of reasons why when someone is driving in reverse, they might slow down by a half a mile an hour, right?
It's when I say when it's consistent, it's because there's the other aspects of it is the fact that the accelerator is consistently strong.
Let him answer. Finish your answer.
So the accelerator is I think a constant rate, and then it just drops by half a mile, and the steering wheel all of a sudden abruptly goes to the right. That's what I'm talking about when I say it is consistent with a pedestrian strike. That's something that you would see. It's not going to be a huge change of speed during this collision.
You also note that at the time, it had begun to snow, correct?
Yes,
There would be snow on the lawn, right?
correct.
There would be snow on the cars,
Yes,
snow on the trees,
yes,
snow on the roadway.
yes,
Snow on the roadway could impact how tires move over the roadway, correct?
in a way.
In a way.
And obviously, there are a multitude of reasons why somebody might input a 10-degree input on a steering wheel, correct?
Correct. That's why I said I couldn't definitively say it.
Right. So every time somebody slows down, going in reverse or forward, and introduces a 10-degree input on the steering wheel, doesn't mean they're looking to hit a pedestrian, correct?
Correct.
You testified that you determined the
guy's
area
not
of
bright.
impact by basically following, if I heard your testimony correctly, basically following the debris field from the body from where you believed John O'Keefe's body's final resting place was, almost linearly to the furthermost piece of debris that was found. Did I get that right?
Yes.
In other words, you established what in your mind, or what you were told was his final resting place, and what you were told was the debris field. And you indicated that the furthermost piece of debris would basically be the area of impact, right?
It's within that line. I didn't say that is the area impact where the furthermost piece of evidence is.
All right.
It's just the linear, like you said earlier, it's that linear. We're going that path. That's the path that he traveled post impact with the vehicle.
And that is on which, that fact that you stated is on which it's a terrible question. That's the basis for your opinion of where the area of impact was, correct?
Yes.
Let's take a look at exhibit, with the court's permission, 587. It's your diagram 3. If I may approach Your Honor, just for...
Okay?
He's not even listening to the questions. When Jackson's like, that means you're hitting a pedestrian every time you reverse and turn 10 degrees, he's like, yes. No. No, it does not mean
May I
that.
approach?
Yes.
So you can see it. Your Honor, may we publish exhibit 587?
Yes.
Diagram 3? Okay. Sir, you see diagram 3 on the board. You also have it in front of you, correct?
Yes.
It's easier for you to refer to what's in front of you because that's a little bit further away. Just let me know.
Okay.
The red arrows adjacent to the blue writing, where I'm highlighting right now, indicate basically the debris field that you explained to the jurors on Friday, correct?
Yes.
And then there's a point of an arrow that comes back to a wording that says pedestrian's final rest, basically right there, correct?
Yes.
And the debris field ends right in the middle of that spotlight, correct?
Yes.
All right. So that's the area of impact that you indicated to Mr. Lally you believe occurred because of the debris field and the linear portion of that debris field going from the pedestrian's final rest all the way out to that final little red arrow that says red plastic B in parentheses, correct?
Yes.
Donna, can we have Exhibit 492 published to the jury, please?
Okay?
Approach.
Yes.
While that's coming up, have you ever seen this?
No, I haven't.
Take a look just above the arrow. Your Honor, with the court's permission, maybe highlight or magnify the area just above the arrow.
Okay.
You see that?
Yes, I do.
Right underneath fire hydrant, correct?
Correct.
What does that look like to you?
Piece of plastic.
It's debris, correct?
Correct.
All right. Can we go back with the court's permission to Exhibit 87?
Okay.
Diagram 3.
Yeah, now put that on your diagram, and it's kind of out of place, isn't it?
Just the fire hydrant?
Yes.
Fire hydrant's right there, correct?
Correct.
That's another, according to your scale, that's probably a good 30 feet from the pedestrian's final rest, correct?
Yeah, that's about right.
That is the furthermost in this diagram, the furthermost piece of debris on the diagram, correct?
Correct.
So now your testimony changed that this, in fact, is the area of impact.
No,
Why not?
because it's just a piece of debris. I'm talking about the path. You follow the path of debris field. Debris can move and change.
The debris doesn't fly backward, does it?
I'm saying you pointed to like just the fire hydrant as the area impact where the debris, where that one piece of plastic was, saying that's the area impact is right next to the fire hydrant.
Are you asking me a question?
Yeah, that's what you said, right?
I'm asking you,
I'm making sure I'm
How
understanding
does
what
the
you're
path
saying,
work?
so I can answer the right.
Ask the question again, Mr. Jackson.
in fact, you indicated on Friday that your analysis of the area of impact was predicated on, based on, the furthermost piece of debris from the pedestrian's body that you were aware of, which is right there. Red plastic B, correct?
I said I said you said earlier with the linear equation. I mean, it might have moved it over more, but it's the debris, the start of that debris, and where that is. I can't say that's definitely the point of area impact or the point of impact.
Can't.
I cannot say that is the point of impact right there. You just kind of follow the linear path because they have to follow in a direct path that way.
Okay, so now your testimony is that's not the area of impact.
I never said that was the area impact. I said it's after that.
Trooper, we were all here on Friday.
Okay.
That's exactly what you said under questioning by Mr. Lally, wasn't it?
Objection.
Sustained.
Didn't you say on Friday that you determined the area of impact for Mr. O'Keefe, the point of impact, was red plastic B because that was the furthermost piece of debris you were aware of from the final point of rest from Mr. O'Keefe's body. Isn't that what you said?
I don't believe that's my exact words.
Okay, I'm not asking if it was your exact words. I don't have
And
a
Mr.
transcript of
Jackson's
it.
math is
I'm asking you,
mathing.
Is that what you tried to impart to the jurors?
What I said to the jury, I said after that. That's the start of, that's the last point of evidence that I had. I said the area impact is probably along the roadway after that point. I mean, like before it, you have
I
to
mean
walk
before,
towards him.
after, I mean before.
I'm sorry, I keep doing that because I think you're done. Are you done?
I am done now. So.
Now you're aware that there's a piece of debris, looks like taillight material, right under the fire hydrant, correct?
Correct.
If the area of impact, which you indicated on Friday was where this red plastic B is, you would be wrong, right? Your analysis would be flawed.
No, because that's not what I said. I said it's along the roadway and it's going to be after that point.
Okay, so is the area of impact now where the fire hydrant is?
Objection.
Ask it differently.
are you now indicating, because now you realize that there's a piece of debris directly under the fire hydrant, are you now indicating that that's the area of impact where John O'Keefe's body was struck?
Objection.
Sustained.
If we're
Let's
supposed
take a
to
look at
follow the
exhibit.
line, where should we follow it to now?
With the court's permission, 279.
Okay.
Taking a look at exhibit 279, I want to draw your attention to that piece right there, okay, of plastic. You see it?
Yes.
You describe it for me. Just physically, what does that look like?
Looks like clear plastic with a little bit of red and the black on the top part.
Okay. Maybe in a triangular shape, is that
Looks
fair?
like a shark tooth.
Okay. Now, if we could go back to, with the court's permission, exhibit 492,
Okay.
and highlight just above the ruler.
Sure looks like that shark tooth.
How would you describe that piece of material?
It looks like the same piece.
Does that, based on that, does that appear to be part of the taillight material that was found at the scene?
Correct.
Okay. Now, based on that, are you now suggesting, if we could go with the court's permission, if we could go back to 587, I'll stop jumping around just a second. I think we
Okay.
just get back to 587.
This is killing me. Of course he can leave. I don't know why
Sorry,
she's not
the
allowing
guidance
it.
diagram for space. Okay. Now, seeing what you just now seen in terms of that piece of plastic that appears to be from the taillight, does that appear to be under the fire hydrant, which is highlighted? Same piece.
Yes.
Okay. Based on that, does that change your opinion? Is that now, the fire hydrant now, the point of impact?
No.
Where is the point of impact now?
It's along the roadway. I don't know the exact point of impact.
So you don't know the area of impact?
I said the area of impact is along the roadway after the debris.
Okay.
I mean, only thing it would change, only thing it would change is maybe it's a little further away. But besides that, it's a linear field. I'm not talking about like one point. You kind of follow the middle of the debris field, and that should be the path.
Well, if the point of impact is along the roadway, where along the roadway, if you can show the jurors, where along the roadway, in your expert opinion, was the point of impact?
It should be within, if you follow from pedestrians, find a rest here, just kind of follow it back. That's what I'm talking about, linear field. I can,
Just kind of follow it
So-
back to
So
where?
now you've indicated an area, I can follow your laser pointer, an area along here, correct?
yes, somewhere in there.
All right, if I have my spotlight, is that, if I leave it right there, is that about where the middle of the spotlight, about where you believe the area of impact is?
It's within, I guess you can say it's within that area. I don't know definitely, there's nothing on the roadway that has a definitive point that says this is the area impact right here. It's within the roadway based on the evidence at the scene.
Okay. Trooper Paul, I'm asking you, based on your expert opinion and your conclusions, based on your full analysis, can you point me to within an area of 5 feet or so on the roadway where you believe the area of impact is? Is my spotlight basically highlighting the area that you believe, in your opinion, is the area of impact?
You have that laser pointer?
I do.
Why don't we let him show you? It'd be easier for the jury to see.
So what I'm trying to say is, so we follow the linear path back around this area.
Look at those shaky hands.
And sorry, I'm trying to keep it straight as much as I can. Follow back to here. I can't say like if this definitely is, but it's possibly based on also vehicle damage to the back of the vehicle. So if you follow all the way back to here, that could be a possible area impact.
So when you say that area there, I want to be very clear for the record that what you highlighted is an area basically just to the left of an X that's on the roadway, on the bottom of
Yeah.
diagram 3, toward the lower
His
part of diagram
50-foot
3.
markers.
Correct?
You would use your circle almost to kind of be a good area around.
Sorry,
You can use a circle around here. This would be around the area.
Okay.
Okay.
So using your scale, That scale is going from full left to full right. It's plus or minus 40 feet, right?
Switch, can't see it. So say again, say the question.
That scale is 40 feet, going full left, full right, 40 feet.
It's 40 feet. It's a 10-foot scale.
Okay, sorry, 20 feet, my mistake.
Okay.
I was terrible. 20 feet, thank you. All right, so if you use that scale, can you estimate the jurors? I'm just going to use this X as a starting point. You estimate the jurors from this X that I've highlighted. The pedestrian's final rest.
Yeah, good 30
What's that
feet.
number? Doesn't have to be exact. Give me an estimate.
So, I mean, it could be within 30 feet because I tell you this, also on my scale, this 2 and 3 is 50 feet from each other.
Is how much?
50,
Okay.
50.
50.
So would you agree that from this X down here to pedestrian's final rest, as the crow flies, that's probably a good 35, 40 feet.
I mean, I could try to use the scale, but it's me as a scale.
If you wouldn't mind.
If you wouldn't mind.
You need a piece of paper?
Yes, please.
Would you like a ruler? Have a ruler ready, Ellen.
Permission?
Okay.
Just a blank piece of paper.
Thank you. Yes, thank you.
You need a
Oh,
pen?
man.
I got one, thank you.
You've only just gotten started.
It's a little around, it's approximately 30 feet.
We're up approximately 30 feet.
Yes.
Can you place, with the court's permission, can you estimate 30 feet in here?
Can I ask?
Can you point to a place in the courtroom that looks like it's 30 feet from you?
Objection.
No.
No?
Next
Why
question.
not?
Does the court have a diagram of a diagram of distances?
In this courtroom? No.
You indicated just now, and I'm finished with this. Thank you. Thanks.
It's 3
You indicated
stories.
just now, in answer to Mr. Lowry's last couple of questions, that in your expert opinion, when the SUV struck pedestrian John O'Keefe, he was, quote, projected forward and to the left to the front yard to his final place of rest.
Yes.
So your expert testimony is that John O'Keefe was hit with the SUV and flew 30 feet.
Projected mean like I don't say he flew all the way there. He was projected in that way. He got pushed forward in that direction.
Which he was rendered incapacitated, landed there, had to sort of fly there, right? Didn't walk there.
I mean, would you definitely flying like literally off the ground the whole entire time, or?
Well, you tell me, you're the expert.
Well, how did he hit the
I mean, he
curb
got-
and still go
When we say
another?
projected, we mean he gets projected, and they usually have a
28
landing
feet.
phase, and they land, and then they either roll or tumble to final rest.
Okay, how far do you think he landed? How far was it until he landed of that 30 feet?
I don't know. There's no indication of where his exact landing
Where's
spot
the
was.
impact injury when he
Is there any
landed?
evidence whatsoever that he landed and rolled?
And there was no evidence that he landed or rolled. Or no, rolled.
According to you, the evidence that you have in front of you is that you get hit, fly 30 feet, land where he ended up at his final rest, right?
Objection.
Sustained. Ask it differently.
Based on your expert opinion, you believe that he was projected through the air to his final rest place.
That's not what I'm saying.
But you said there's no evidence that he rolled.
And there's no evidence that he flew through the air either.
Exactly. Right? Exactly.
Objection.
Sustained.
How did he get hit and end up that far?
You said
Did-
on
did he
Friday that in your
sprint?
experience, people tend to lose objects that are not strapped to them. Is that right?
Yes.
In other words, get hit by something, car, truck, bus, whatever, train, and if you have something in your hand, boom.
Like your
You lose it,
phone
you
in your
drop it.
cup.
If it's not strapped to you, correct?
Correct.
How do you suppose that Mr. O'Keefe, in your opinion, held on to that glass cup that was found right next to him over the course of 30 feet being projected?
Objection.
I'll allow it. Do you have a theory on that?
I don't know. I mean, it just could have been with him the whole way. I don't
It just
have
could have been with him.
I don't know. I wasn't there, so I don't know how the glass stayed with his body and went with him to the final rest.
So I mean, it's just common sense. You have to believe that it was in his hand. He held on to it the entire
No,
time. it was
I
being
wasn't
projected.
there.
Right.
It's possibly, it could have been in his hand. It could have been tucked next to his clothing. Could,
Did you say tucked in?
I mean, like, could have been next to his body. So when he projected, maybe the glass was with his body as it was also flying. So there's a number of reasons why the glass, because it
But I
also got
thought we
projected
didn't know
with the
it was
body
flying now. There was
while he
no
was holding
evidence.
it.
I thought you said on Friday, and you disagreed with me, that people drop things when they're hit.
Yes, body think not everything it tends to fly off. I mean, some stuff flies off, some stuff will stay on.
I see.
It's not uncommon to find piece of clothing and stuff, that you find at the scene.
Piece of clothing.
Like clothing, like shoes, like shoes and stuff like that to come off the body during a pedestrian crash.
Well, that's not what I asked.
I know, I'm just saying, you asked me, you said what I'm just responding to what you said. And trying to make sure you
No,
understand what I'm saying.
Word salading.
No, I don't, but I'll
Yeah.
ask another question. Shoes are strapped on by definition, right?
Yes, but it's very common for shoes to come off.
How about a cell phone?
Cell phone, yeah. Yeah, it depends on where it is.
It was under his body.
Okay.
How do you account for that? He held
Okay.
onto his cell phone with one hand
Oh,
and
my
holds onto his
Lord.
cup with the other.
Objection.
Sustained. Ask it differently.
If the cell phone was found under his torso, under his body, what's your theory on how that cell phone ended up flying 30 feet with him?
It just did.
Just
It
did.
just did.
And somehow, as he landed, tucked that cell phone underneath his body, so he landed on top of it.
It just did. That's the evidence at the scene. I didn't put the evidence there. So
Well, you didn't.
Objection.
All right, so jurors, I've told you before, lawyers cannot make comments, so disregard it. Mr. Jackson, don't do it
I
again.
understand. So in
You
one-
understand, but don't
The
do it. Your answer's
contempt
always, I understand.
Jackson.
Don't do it.
Yes, Your Honor. Cell phone in one hand, cup in the other hand, flew through the air, right?
Objection.
Sustained.
You were informed of this incident on January 29th, 2022 at about 2:30 in the afternoon. Is that right?
yes,
At the time, you were working out of the CARS facility, which is located on West Grove Street in Middleborough. Is that right?
yes,
By the way, that's a facility that has multiple garages. Sally ports, I don't know if they're called Sally ports, but garage bays, correct?
the mechanic shop are there.
The mechanic shop
Yes,
is, if you're going to review, for instance, for purposes of reconstruction, if you're going to review a vehicle, is the vehicle placed in those mechanics bays?
no, not there. That's for state police vehicles.
Okay, so where are the mechanics bays, sorry, reverse that. Where are the Sally ports where you do your analysis, your reconstruction, your review of the vehicle, inspections, things of that nature?
We don't have Sally ports for that.
You don't have anything
Do
dedicated
you
to
have a
that?
garage bay?
No, the only time we would use a Sally port is the crime scene would have some Sally ports that they would do to document their crime scene stuff. And I've gone there to do my inspections, but most of our inspections are done either at the tow yard or some type of facility for that.
Ultimately, was this SUV ever taken to the Middleborough facility?
Yes, it was.
Where was it placed?
There's a fenced in area it's a fenced in area
Is it outside or inside?
outside.
Okay. Did it remain outside in that fenced-in area the whole time?
I don't know the exact time. It was there for a while, then it got moved.
Where did it get moved to?
I'm not sure exactly where they moved it immediately after it left Middleborough.
Are you familiar with the Foxborough location at MSD?
Yes.
Does that have sally ports or bays for inspection and evaluation?
It has garages in it, but we wouldn't use them. We don't normally use those garages for inspections.
Is it possible to use those garages for inspections?
It is possible.
Okay. It's happened before, correct?
I've not used the inspection in the garages.
But if,
I'm going to ask you to keep your voice up and
Sorry,
speak
yes.
slowly.
but you know they could be used.
Sorry.
You know that those bays could be used for inspections or analysis or evaluation if needed, correct?
Yes.
All right. Given the fact that the SUV that was being seized on January 29th was being seized as potential evidence, best practices would suggest that you'd want to get it in and out of the bad weather, the inclement weather, as quickly as possible, correct? You wouldn't want to subject it to continued forces from nature like rain, wind, snow, sleet, hail, right?
That would be beneficial, yes.
All right. You're aware that the Foxborough location and the Middleborough location with the mechanics bays are all closer to Dighton than Canton, right?
Both Foxborough and
Foxborough and Middleborough are both closer to Dighton than Canton. In other words, you have to pass by, depending on which way you go, pass by Middleborough, pass by Foxborough to get to Canton.
so from where?
From Dighton.
From
sorry.
Dighton.
From Dighton.
Where the vehicle was seized in
Yeah.
all going toward Canton, you pass by either Middleborough or Foxborough.
If you can't
To get to
follow this
Canton,
question,
I don't believe you'd pass by Middleborough to get to Canton, but you've passed by Foxborough.
All right. The car was not taken to Foxborough, was it?
No.
As a matter of fact, the car was taken basically double the distance all the way to Canton to that Sally Port, correct?
Objection.
Do you know that? Is that double the distance?
I don't know the exact distance. I know it was in Canton.
And you know it's fine to Canton,
From Dighton, yes.
right? And you're also aware that because you've been to the scene, assuming correct, at the 34 Fairview,
Yes. Yes, I have.
and you've been to Canton PD,
Yes, I have.
you know that those two locations are about 3-4 minutes apart.
Yeah, I can say that.
When you started let me ask this a little bit different way. Before you began any review on this case, any physical review on this case or analysis on the case, you were told that there had been a crash, correct?
Yes.
You testified to that at the state court grand jury in this matter. Is that right? That you've been told in advance this was a vehicle pedestrian
make it
crash?
work.
And you were asked to analyze it, right?
make
Yes.
it work.
You wrote in your report that it was a single vehicle collision involving a pedestrian, and you were, quote, assigned to reconstruct that collision, correct?
Yes.
So when you began your analysis, Trooper Paul, you were told conclusively by the lead investigator, Michael Proctor, that the deceased was hit by a car, and your job was to
Yeah. And that's why the
reconstruct
reason
it.
the stuff was
that
where
right?
it was.
Objection.
It just
Okay, so there are
did.
lots of parts to that. Break it down.
Sure. Were you told by Michael Proctor to reconstruct this incident?
Objection.
So were you told that by Trooper Proctor?
I was not.
Okay, next question.
Sure. Who were you told, who were you given your instructions by
Instructions for what?
to reconstruct this incident?
I wasn't given instructions to reconstruct it. It's just I was assigned to it.
Right.
That was requested. My assistance was requested to reconstruct it.
That's my question. Who assigned you to it?
I talked to my sergeant at the time who gave me the phone call.
And you were told some basics about that reconstruction, the event that you were asked to reconstruct, correct?
Yes.
The information that you were told came from the case officer, is that right?
Who's the case officer?
The information that this was a pedestrian vehicle incident, as opposed to motor vehicle incident, pedestrian bicycle, motor vehicle motorcycle. You were told it was a motor vehicle pedestrian incident that you were asked to reconstruct, correct?
Yeah, I was told that, yes.
All right, and you had to be given some basic parameters of what that incident, how that incident occurred, car was going in reverse, it's got a damaged taillight, things like that.
Some basic stuff, yeah.
What I'm asking is, I'm trying to get to is, who gave you that information? Where'd it come from?
That the car was traveling in reverse. Like, which part of the information? You asked me several different things just now.
Were you given information from multiple sources?
Is he actually dumb or
Or did
just
someone
playing
give you a
dumb?
summary?
Because
of
he's
what you were
trying to
being
not
asked
say
do?
Proctor.
At the very beginning,
Yep.
who gave you the summary?
Summary of the whole entire, of what?
Of the event that you were asked to reconstruct?
I was passed down when I got to the garage. That there was nobody that sat there and gave me the summary, like, that I can remember. I was told that it was a pedestrian crash. I knew it was a Boston police officer involved.
And who told
That
you
this
that?
was a vehicle, and that it was traveling in reverse. That's all they had.
Okay. What I'm asking is, that's great. Thank you for the summary. Who gave you that summary?
Yes.
I don't know if it was definitely anybody from the get-go that was like I talked to.
From where?
I don't know if
You
it's anybody that I
said
could definitely say that was
you were
the
given that
person.
info.
There was multiple people going around when I got there. I think I talked to Trooper Zach Clark. He was doing the crime scene. I think he was Zach Clark. He was the crime scene photos at the time. I knew him from past crashes. He just said this is the vehicle, and I think he kind of gave me a little bit of a lowdown on what the vehicle was.
Okay.
So
My question is this. When you got that, did you call it a lowdown? He gave you the lowdown?
he gave me
Yes, he
information.
did.
Yes.
Right. When you got the lowdown, you were told Boston police officer was involved, the vehicle pedestrian incident, car was going in reverse, ultimately led to the death of the pedestrian. Struck the pedestrian in reverse, correct?
Correct.
All right. And you were assigned specifically to try to reconstruct that incident.
Yes.
Have you ever heard of the phrase confirmation bias?
I know the phrase. Yes.
You know what it means?
I can't definitely say what it means.
Oh, boy.
Developing a conclusion and then trying to find evidence to fit that conclusion. Does that sound right?
You say so.
You noted in your direct examination that there were scratches on the passenger side rear bumper of the Lexus, correct?
Yes.
How exactly were you able to scientifically determine that any of those scratches were from an incident on January 29th, 2022, as opposed to any other time?
I didn't have anything else on the time. Is that those scratches happened prior to this collision?
I'm sorry.
I didn't have any information that those scratches were caused from a prior collision. And so when I looked at the evidence, I knew it was in that same area, the right rear tail light. So when I looked at it, it didn't quite fit the pedestrian thing. So when you showed me the video, or I saw the video like a year ago on Court TV, I said that could be.
You asked the question, so next,
I
keep
did.
going.
Responsive.
He's answering. Next
trying to-
question.
You
Then
guys
go
how
ahead.
scientifically
Hold on.
thought the scratches were.
Hold on. Ask your
Sorry.
question, Mr. Jackson.
You know what normal wear and tear on a vehicle is, right?
Yes.
Bumpers get scratched myriad ways, correct?
Correct.
Get scratched in a grocery store parking lot, right?
Yes.
Shopping cart can bounce off the back of the car and scratch the bumper, scratch the side of the car, quarter panel or something, right?
Sure.
I mean, I don't want to go through it, but there's thousands and thousands and thousands of ways that a car can get a scratch, correct?
Correct.
My question is, as you sit here, do you have any scientific evidence that those scratches occurred on January 29th at approximately 12:45 a.m.?
What do you mean by scientific evidence?
Well,
No, you tell us.
do you
You're the
have any
expert.
evidence whatsoever that you can point to that those scratches occurred on that date and at that time, rather than any other time in the history of that vehicle?
Like I said earlier, the video seems to appear that's what it looks like that could have been from.
Well, you said on Friday, let's talk about those scratches for a second.
Okay.
When you testified Friday, you were pretty clear. You said that If I can find it exactly. I may have just a moment, Your Honor.
Sure.
What do you mean by scientific evidence?
You said,
Oof.
quote, "The dent and scratches for his hand could be, those are consistent with striking the Lexus." Remember saying that?
Yes, on the tailgate.
Okay, so the dent and scratches we talked about on Friday, you said were from his hand.
Yes, hand in the glass cup.
Okay. Then are those the same scratches you're talking about in terms of the bumper?
No.
No.
So,
What are you talking about? The scratch inside the bumper that we've been talking about?
correct.
Okay,
That's what I'm
no.
talking about. Okay. Is there any way to scientifically date a scratch?
No.
If you go out in the parking lot right now, even as an accident reconstructionist, if you walk out in the parking lot right now and look at a Toyota Camry sitting there, it's got a scratch on it. There's no analysis that you can engage in to date that
You can get
scratch.
some oxidation of the
Objection.
metal, but that's about
So you can
it.
ask it differently,
If it's
Mr.
a deep
Jackson.
scratch.
Is there any way that you could, in general, look at a scratch and say, that scratch is from such and such date?
Objection.
I'll allow it.
Nothing more.
I'll allow it.
You cannot say, you can look at evidence and shows that it may have been older than what the newer evidence would be, but there's no way to say that specific date and time and that a scratch would come from.
Right. And it's possible that any or all of those scratches on the Lexus could have predated January 29th, correct?
No.
That's not possible.
The ones that are on from the taillight and the other parts of it,
Scratches anywhere on the car.
depends on what you got to pick the other scratches. You got to show me other scratches on the car.
I'm saying it's possible, since you can't date the scratch. It's
Now he's
possible that
going
any or
full
all
Jen
of those
McCabe.
scratches
Show
could
me.
predate January 29th.
Show me.
Right? It's possible.
You're being pretty broad on your scratches here.
I'm not being brought it. Let me ask it a different way. Let me ask it again. Is it possible that any or all of the scratches noted on that car predate January 29th?
Any and all of the scratches? See, that's what I'm saying. You're being pretty broad. Any and all scratches on the car.
Answer that question.
Go ahead
That
and
it
break it
predate.
down. If you think specific ones,
Objection.
I don't know every single scratch on that car. I could mean,
Overruled. So
Didn't you
if-
inspect
can
the
you answer
car?
that question?
no.
Testify that you noted glass on the rear bumper of the SUV, correct?
Yes.
And you said something about that glass coming from the cup.
Correct.
you wear it didn't
You also
match.
said that you did not see anything on that SUV that could be the source of those glass pieces on the bumper, right?
Yes.
When you did your reconstruction and your analysis, were you informed that none of the glass pieces, not one of them, would be matched to the cup?
I don't know anything about that. I don't know that.
So if you knew that the glass pieces on the bumper do not match the cup, that change your opinion
Objection.
about that glass?
Can you answer that question?
I cannot.
You can't answer the question.
It's what was told to me as evidence
Got it. By whom?
by the crime scene.
Who told you?
As crime scene that was there, it says it's glass from the cup. When I did my initial inspection, that's what it was on from.
That's not what you just said. You said that's what was told to me.
Yeah, by crime. No, yeah, I said by crime scene.
Ooh.
While I was at my inspection,
Wait, what?
it was told to me by the crime scene when I was at my inspection, at the initial inspection.
So what you meant by that's what was told to me is the crime scene talked to you.
Yes.
Crime scene say anything else?
I don't know what else you want me to say.
Anything else they said? That was the question.
Trooper Proctor tell you that those pieces of glass on the bumper are somehow associated with the cup?
No,
No.
Just the crime scene told you.
correct.
But if you knew that the crime scene was incorrect, and in fact those glass pieces don't match the cup, would that change your opinion?
Objection.
Sustained.
Would it change your
Can't
opinion in
answer
any
if
way
it would change his
if you
opinion.
knew that the glass pieces do not match the cup?
Objection.
I'll allow that. Can you answer that question?
No.
I'm sorry, no,
It
I don't-
still
I don't-
came from the cup, even if the glass pieces didn't
It's a glass
come
from a
it.
cup. It's a glass. It's not, it doesn't belong to the vehicle.
right.
It's glass.
But if I told you it didn't match that cup,
What,
your opinion?
Objection.
Does that change your opinion?
are we talking, which cup are we, we never established which cup we're talking about.
How many cups
Are there
have
more
we been
cups?
talking about, Trooper?
You said that cup, one from the scene? Okay.
That cup, I'm talking.
I just want to make sure that we're on the clear path here.
No.
On the clear what we're talking about.
No, you're trying
Okay.
to wiggle.
All I said, it's
You
glass.
are on the
next
hook,
to John
Trooper.
O'Keefe's body in the snow at 34 Fairview on January 29, 2022. You got the cup in mind?
Yes.
Okay. That's the cup. When I say cup, that's the cup.
Okay.
Would it change your opinion if I told you that the glass pieces on the bumper don't match that cup?
What's my opinion on it? All I said was glass from a cup. That's the only opinion I had. It's glass from a cup that was on a bumper.
Are you saying a cup?
A cup. A cup.
So just
It's
a
not
different
glass
cup.
from the car.
So
That's,
when was
that was
that
my opinion
cup
on it.
broken?
I didn't never said it matched
By the
to
bumper?
the scene.
You didn't.
I never said that. My thing. I said it's glass from a cup.
I never said it matched the scene. Oh
Okay.
my God.
It's safe to say you didn't do any testing to determine the forces necessary to shatter a taillight on a 2021 Lexus 570, right?
I did not do testing.
Your report indicates, we've talked about this a little bit, I'm going to go back to something we talked about earlier this morning. Your report indicates that John O'Keefe came into his final resting place about 7 feet from the roadway, and that's what you based your diagram on, correct?
Yes.
Who told you that number?
I measured it from my diagram.
You should say that again?
I measured it from the diagram.
Okay, what I'm asking is how did it get on the diagram? In other words, who told you that his body was 7 feet from the roadway?
Well, wait, I was told by Lieutenant, was it Gallagher, Paul Gallagher, Captain PT. He told me this is where the body was found.
Okay.
So I used my devices to mark that location.
Okay, but before you used your devices, he just pointed someplace on the ground and said he was about here, correct?
Yeah, that's correct.
Did Lieutenant Gallagher tell you that Lieutenant Gallagher never saw John O'Keefe in place at the scene? Did he say that?
No.
Did Lieutenant Gallagher tell you that the first officer on the scene estimated his body at being approximately 15 to 20 feet from the roadway?
No.
If he had told you that, then it changed your diagram?
Objection.
Overruled.
That's okay.
He told me this is where he was found. I marked that location. That's all that was.
And you marked basically every other piece of item, sorry, that was a terrible question. Every other item you marked based on a distance from where you were told John O'Keefe's body came to rest, correct?
Yes.
Yeah, and that was by Lieutenant Gallagher just pointing at the ground and saying it was about here.
Correct.
Was there a single member of the team that was out when you were being shown where the body came to rest? Was there a single member of that team who actually said they saw John O'Keefe's body in place?
Objection.
I'll allow it.
What do you mean team? Canton PD?
Whoever was there, who was there with you when you started doing your measurements, et cetera, or therapy?
To Lieutenant Gallagher, that too.
Just you and him?
And myself, and I was training a trooper at the time. She was there.
You were training a trooper at the time?
Yes.
Okay, so my mistake. I assumed that there were several people out there, just you and Lieutenant Gallagher.
Yes, that's why I was confused by the team.
All right. And again, Lieutenant Gallagher didn't tell you that he never saw John O'Keefe's body in place.
No, I don't think so.
You did document in your report that the items that you noted on your diagram that we just looked at a few minutes ago, those were found by the CERT team, correct?
Yes.
And you indicated in your report that the members of the CERT team located a single Nike sneaker that was noted on your report. Is that right? On your
Correct.
diagram, right?
Yes.
You also indicated that, quote, in the same area, 2 red plastic pieces and 1 clear piece of plastic of a taillight was discovered.
Yes.
Just
So
3,
your
not
report
5.
is clear that in total, the items discovered by the CERT team on January 29th were a shoe, right?
Yes.
A partial glass cup broken, correct?
Well,
No, that was
it was that on
before.
there. I can remember if that's on their diagram or if that's what I was told at the scene. But yes.
Sure.
Yes.
You knew that a cup was found.
Yes.
You were told a cup was found.
Yes.
And 3 pieces of plastic, 2 red, 1 clear.
Yes.
Not 5 pieces of plastic, correct?
Correct.
You then measured those items, is that right?
I didn't. What do you mean measure them? Like
Measured
at
them
this?
relative to John O'Keefe's final place of rest. 10 feet from it, 12 feet from it, we're going to go over those numbers.
Yes, I used their report to place those items onto my diagram.
So, and I'm going to get to that question in just a second. I want to make sure that we walk through it sort of methodically. You then use some calculation, some tool or something to measure distances. Like there's where I assume John O'Keefe's body was. There's a final rest place. I'm going to use that as point A, and then I'm going to measure from there and go 7 feet to where the shoe was found, or the first red plastic piece was found, or whatever, right?
Yes.
Who told you where the pieces were found?
They were in Lieutenant Tully's report. He put measurements in his report.
Okay. And
To make
you
it
noted
look
that
good
the
and
shoe was
sciencey.
9 feet.
Yes.
And you put that in your diagram.
Correct.
You noted that the glass cup was 1 foot from John O'Keefe's body, correct?
Correct.
1 foot is about that long, right?
Yes. It was. They basically said it was found next to him.
Right.
Yes.
A piece of red plastic 7 feet from John O'Keefe's body, correct?
Correct.
A clear plastic piece 10 feet from John O'Keefe's body, right?
Yes.
And a red plastic piece 12 feet from John O'Keefe's body, correct?
Correct.
What part of his body were you measuring from?
Like center of mass.
So he's 6'2".
Yes.
Did Lieutenant Gallagher tell you where his center mass was?
No, I measured from. He just said he was here, so I tried to put like where his head, where his feet, and try to measure the middle between those two.
So
Well, where's that on your
ultimately,
diagram?
Because Lieutenant Gallagher was not at the scene when he was found, Lieutenant Gallagher had to sort of guess where the body was found, correct?
Objection.
Sustained.
You had no photographs of John O'Keefe in place, correct?
Correct.
There were no establishing shots, there were no perspective shots, correct?
Correct.
There were no relative shots, meaning this is relative to that, I can measure that and figure out distances, correct?
What, like from the picture?
Yeah, so you know how that's done in science, right? You want to find out a relative position of something, so you take 2 or 3 or 4 shots. You know that something is never going to move, like, I don't know, a flagpole. You can measure from there.
Sure.
You get cross coordinates, right?
Sure.
Left and right, and where the 2 coordinates match, that's where the item is, right?
Correct.
None of that was done, right?
From the pictures?
None of that was done to do your measurements.
I used, like I said, I used the measurements from. I measured on my diagram in itself, and I measured from those points off my diagram.
Right, but the starting point was a guess, wasn't it?
Objection.
Sustained.
Did you have to sort of guess at where you thought John O'Keefe's body was?
I didn't guess where his body was.
Did you guess at his center of mass?
Objection.
Did you guess?
I did not guess.
Next question.
Where is it on your diagram?
You stated in your report that you Google
Helen,
Maps.
give him the diagram and ask him,
misreads
where's the
path
head,
of
where's the
travel.
feet?
Well, let me ask you a different question. If I could withdraw that question with the court's permission.
Yes.
Your diagram has all those arrows pointing
Yes,
at
please.
specific locations. Very, very specific, very thin arrows point, correct?
Yes.
If you start off with an incorrect assumption about where John O'Keefe's body was, right? Hypothetically, if you were to start off with an incorrect assumption where John O'Keefe's body was, every single item that you note on that diagram would then be off as well, wouldn't it?
Objection.
Is that true?
I mean, I guess hypothetically, depends on how off you want to be.
But the answer is yes, right?
Hypothetically.
You stated in your report that you Google mapped Ms. Reed's path of travel on January 29th based on what you determined to be, quote, it's likely the two, and you said that it's, quote, it's likely that the two events, meaning the triggering events, occurred at the same time the Lexus was at 34 Fairview at the time of the collision, correct?
Yes.
The first triggering event was what? Was it a 3-point turn or a U-turn? I thought I heard you say both.
I guess it would be more, 3-point turns, essentially, I guess it's a 3-point turn.
Okay.
Yes.
Well, did you say U-turn on Friday? I could have sworn I heard that.
It could have been a U-turn. I mean, it's still turning around. So you had to make a U-turn when it's a 3-point turn or not, but it's still.
Okay, but I mean, not to be picky, but sort of my job.
Okay.
A U-turn,
Should be your
traveling
job too, the
one
technical
direction.
guy.
turn it, right? Turning the wheel, never changing gear, since it's reverse or anything, just turn it, right? A 3-point turn requires moving forward, stopping, changing gears, moving backward, stopping, changing gears, using the steering input, and then moving off, correct?
Correct.
Well, those are two very different maneuvers, right? You'd agree?
It's, in a sense, I was trying to say she made a U-turn. Like you can say they made a U-turn. It's a 3-point turn. They're still making a U-turn. And it's, I didn't mean it as like she literally had to make a direct U-turn. She was turning around. And obviously the diagram, or the trigger shows a 3-point turn.
Well, I mean, I guess you could have said reversing direction, right?
That could be a better way to say it, yes.
You didn't say that. You said U-turn. So are you changing your testimony from Friday that it was a 3-point turn, or could it possibly have been a U-turn? Which is it?
It's a 3-point turn.
Okay, because you have evidence of the starting, stopping, changing gears, reversing, stopping, changing gears, turning.
That's correct.
So when you said U-turn, that was inaccurate.
Objection, Your Honor.
The objection sustained.
Let's get back to the path of travel when you began your analysis. How did you know what the Lexus's path of travel was that day?
I got the directions from Trooper Proctor.
And what did Trooper Proctor tell you in terms of the path of travel specifically? Starting point and an ending point, tell you the exact path Lexus traveled.
No, all I got was mostly just the addresses.
Okay, so if you've got 2 points on a map,
Did you work
and Trooper
34
Proctor told you
Fairview back
Lexus
in there the
traveled
following
from
morning?
Point A to point B.
Did he ask you if that would
There
work?
are multiple ways to get from point A to point B. You'd agree with that, right?
Yes.
You picked one of those, right? The path of travel includes freeways, et cetera, right?
Yes.
But as you sit here, you don't know what her actual path of travel was, because it could have been something different, right?
It could have been something. That's why I gave a range on my diagram.
Do you have any scientific evidence to establish what her actual path of travel is, or did you just guess at the path of travel?
Like
I
the
got the
location
addresses
data?
from Trooper Proctor. I put them into the thing, and then one of the possibilities of 36 miles, and that was after looking at all of them, at 36 miles is a possibility.
Right, understood. So that's what I'm trying to get to, Trooper Paul.
Okay.
That's one possibility. It was 36 miles,
Mhm.
one route of travel, right?
Correct.
There were other possibilities, right?
Yes.
So between and among the possibility that you picked and the other possibilities, you just sort of had to guess. And there's no science to it. You just said, I'm going to pick that one. You put it in my report, right?
No, that's not how that worked.
Okay, why don't you tell me how that works?
Her odometer mileage on the car from the download and the time we had the vehicle shows 36 miles. So when I plugged
So you had to make that
those
fit?
addresses into Google, it came up as 36 miles as a possibility.
It was actually
And you knew
36.1,
that there was
wasn't
another
it?
route of travel to the same location, correct?
What do you mean?
There were alternative routes of travel to the same 2 points, from and to the same points, correct?
Yes. Yes.
You could have tried to extract the location data from Ms. Reed's cell phone to determine the exact route of travel, correct?
I don't know. I don't have access to the cell phone extractions.
So that answers my next question. You did not even attempt to do that, did you?
No.
You did attempt to analyze the key cycles for the Lexus in order to determine placement of that vehicle. You just talked about that with Mr. Lauper, right?
Yes.
I want to be clear for the jurors because most people have probably never heard of key cycles. A key cycle does not have any location data associated with it whatsoever, does it?
Correct.
It just shows you when a vehicle is turned on, the ignition is on and off. That's one cycle, correct?
No.
Tell me what I've got wrong.
Key cycle, the car doesn't have to be turned on.
Say that again.
It goes from off to run. The engine does not have to be started to off.
Understood. So if it turns on, well, every single ignition is a key cycle. Every time the engine turns on, that's absolutely a key cycle. Once it's turned off again, right?
That gets recorded as an ignition cycle.
Right. So a key cycle can be an ignition cycle, but it doesn't have to be an ignition cycle. It also can be just turning the sort of accessory on, right?
The key cycles turn the accessories on.
All right. But it does, my question was, and where we started with this conversation is, it does not have any location data on it whatsoever.
Correct.
All right. So when you drive your car, you walk out, get in the car, turn the ignition on, start to drive, get to your location, turn it off. That's one key cycle, right?
One ignition cycle.
But and I'm going to use the word key cycles because you use the word key cycles in your report. That's what we're talking about.
I'm using that because that's how the trigger was read.
That's how what?
The triggers were read on the text stream. That's how they read them, key cycles.
By key cycles.
Yes.
I'm going to use that phrase key cycle.
Okay.
We're talking about the same thing. It's an ignition on, ignition off cycle.
Doesn't have to be on.
So you mean the engine doesn't have to be turned on?
Correct.
Right. But if you're seeing triggering events, not trying to be tricky here, seeing triggering events, the car's in motion, what does that tell you? The ignition's on or off?
The ignition is on.
Right. That's what I'm getting to. But it has no location data associated with whatsoever. It could be here, it could be in Wyoming. The car wouldn't know the difference. It's not going to report the difference to you, correct?
On the key cycle,
Right.
on just the key cycle. The key cycle does not give out locations.
Say that again?
The key cycle does not give a location.
Right. So your analysis is trying to go from a known key cycle that you can figure out and then work backward from there to try to figure out where the car was on a particular ignition cycle or key cycle, correct?
I didn't use the key cycle to put it back.
Say that again?
I did not use the key cycle to place the car back in its location. The key cycles were, all I got from the key cycles is that they occurred close
Because if
within
you did, you'd have a
proximity
problem,
to the time
huh?
we've had the vehicle, not basically saying that this was the location based off the key cycle.
Well, let's look at Exhibit 591 with the court's permission.
Okay?
Of course you didn't, because it wouldn't work if you actually counted the key cycles. That's the point he's getting at.
You
He's smart
testified
enough
on
to know
Friday
that. Danger. Danger.
This is a copy of the exhibit that was put in 591. This is part of your report, correct?
Yes, it is.
And this is a chart that shows when
Because it's only 2 key cycles later that
this
they're
arrow- that
doing all their
arrow
testing.
indicates top and bottom where your testing occurred, correct?
Yes.
And when we move over to the left, that is key cycle what?
So we
1164.
count back
Right.
Dighton to
So
Dighton to
you've
John's.
testified, and we can turn the lights on.
Jen to
Your Honor, I don't
John's.
mind if that stays up.
That's where we're
we
at.
can turn the lights on. I don't think it hurts anything. You stated in your report that there were, quote, 2 triggers recorded on odometer 12629 and key cycle 1162, correct?
Yes.
These events were prior to the testing triggers on odometer readings 12665/12666 and at key cycle 1164. Is that right?
Yes.
Okay. So what we're saying, what you're saying in that report is the triggering events were at 1162, going in reverse in order. 1162 comes before 1164. They're numerical. Is that right?
Yes.
Every single key cycle just tags another number on top of it, right? There's no formula.
Correct.
After 1 comes 2, after 2 comes 3, 4, 5, 6, and then move on, right?
Yes.
So by the time you got the vehicle, there had been 1,164 key cycles on the history of that car, correct?
Correct.
All right. And you knew, when you put in your report, or you know, that the triggering events that you see under 1164, those are yours,
Yes.
right? I mean, that's your testing.
Yes.
And you were very clear that the triggers that you recorded, that you talked to Mr. Lally about, were 2 cycles before that,
Yes.
meaning ignition cycles at least, right?
Yes.
All right.
For that.
Your report, let me finish your point. You said that the mileage difference between these 2 triggers and the triggers that occurred while testing was 36 miles. You just said that, right?
Yes.
And the key cycle difference was exactly 2 key cycles, right?
Yes.
1164, 1163, 1162. That's the triggering events, correct?
That's correct.
You also reiterated in your report in paragraph 23, 24, 26, and 29, and also in this exhibit in your CARS report, that the triggers occurred at key cycle 1162, right?
Yes.
You were assisted in your CARS report, I think you mentioned Trooper Zach Clark, is that right?
Yes.
Trooper Proctor assisted to a certain degree, correct?
Yes.
Trooper Larini, Carol Larini, is that right?
Yes.
Also Sergeant Sean Good of Canton PD assisted as well, correct?
Yes, in a sense.
Did they all read the report before it was finalized?
No.
Did you have any supervisor read the report before it was finalized?
Yes.
And he agreed with the assessments in the report?
Yes.
So in summary, everybody that read the report and you who authored the report believed, and it's reflected in that report, that key cycle 1162 contained the 2 triggers that you're talking about, right?
Yes.
That's the 3-point turn, I guess now a 3-point turn, right? Changing direction, and then
Yes.
the reverse at 24 miles per hour, correct?
Correct.
And you even went on and testified to that exact thing under oath in front of the state grand jury, correct?
Yes. Wait, hold on. I need the text streams?
On the key cycles.
Not in grand jury.
Okay. Testified to it on direct examination on Friday and again this morning.
Yes, correct.
If your testing occurred at key cycle 1164, that means you turned the engine on, the ignition on to start your testing, correct?
Correct.
And that triggering event that we see up there at 1164 initiated your testing, all right?
Yes.
All right. So that 1164 is where you That's where there's no more unknowns, in other words. Right? You know exactly where the car is, who's in the car, who turned the car on, and what the triggering events were and what they reflected, because you did it, correct?
Correct.
It's you.
Yes.
So that would be the cornerstone, basically, of your entire analysis of key cycles.
Ooh, nailing it.
Say again.
The cornerstone, in
Like-
other words, the one known that is immovable, it's immutable, is 1164 began your testing. Is that right?
Objection.
Is that right? I'm going to allow the question.
Yeah, that's when the car was in state custody.
All right. So starting at 1164 and counting backward, before you started your testing, you know that the SUV had to be started, the ignition had to be turned over, and it was driven to the Sally Port in Canton at 5:31 p.m. from a tow truck on January 29th, correct?
I didn't know that.
You did or did not?
Did not know that.
Okay. Assuming that the car had to be started and put on a tow truck, that would be key cycle what?
I don't know how. I can't speak to the fact that recorded a key cycle at that time.
I can't hear you.
I can't speak to the fact that we record a key cycle at that time.
Okay. If the car was turned on and driven onto a tow truck, would that be a key cycle?
I don't know because these keys record different ways, so I can't speak to how or why it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing.
Trooper Paul, you just said unequivocally, when a car is turned on and then turned off, there's a key cycle.
I said when the car without the ignition on, that's a key cycle.
Right.
That's correct.
That's what I mean, when it's turned on, when the engine turns on.
That's the definition of what it is. I can't speak to why it didn't go on, why it did not record.
Well,
Why it didn't? You assume it didn't record because that wouldn't work.
let's talk about the ignition cycles
Okay.
before 1164, okay?
Okay.
Obviously, the car had to get to Canton PD. because
Key
you saw
cycles
it,
are now
right?
wrong.
Correct.
Assume for purposes of my question, the car was turned on, and there's a video of it turning on, driving up onto a flatbed tow truck.
Yes.
That would be ignition cycle, I'm gonna use your word, key cycle, ignition cycle, 1163, correct?
Again, ignition cycle, key cycles are two different things.
Which word do you want me to use?
If you want to talk about key cycles, key cycles. If you want to talk about ignition cycles, it's ignition cycles when the vehicle gets turned on. A key cycle does not mean to be turned on.
But every single ignition cycle includes a key cycle. You
Is a
can't
key
have an
cycle.
ignition cycle without a
Yeah.
key cycle, correct?
Well, if you want to talk about it, just use the key cycles or ignition cycles. I'm trying to make sure this gets out. I'm sorry. I'm trying to make sure that this gets put out the correct way.
No, you're not. You're speaking to confuse.
Every ignition
Because-
cycle includes a key
You
cycle.
can't have
correct?
an ignition cycle that doesn't
In a
involve
sense.
turning
By
the power to
definition.
on.
Has to.
You need the battery
have to.
to start your car.
They record multiple different ways.
You
This
can
is
have
not
an ignition cycle
A manual,
without a
pop
key
the
cycle.
clutch.
I don't know how it recorded, but it could happen.
Explain that. How could that possibly happen?
Because a key cycle is when it turns on, not engine running, and then turns off.
Okay, so work with me here.
Ignition cycle is when it turns on, engine running for 2 seconds, and then comes off.
Okay, so
2 seconds.
Or the 2 seconds, if it's not on long enough, it might not record one.
okay, let's ignore the 2 seconds.
Okay.
That's not what we're doing.
Okay.
All right. Let's assume
my
that
God.
it's an old-fashioned type of key.
Okay.
It would take more than 2
Halfway
seconds
on,
to drive it onto the
The
flatbed,
electricity is
yes.
on. It's like
And to drive it off the flatbed.
Yes.
Right?
Yep.
That's a key cycle, correct?
For that intensive purpose, yes. This vehicle's not a key cycle. So they're not a
It
thing.
keep turning,
Okay.
and that turns the engine on, right?
It turns the engine on, correct.
An ignition cycle, right?
Yes. Well, then turns off.
So ignition cycle necessarily includes the precursor key cycle, correct? Even though every key cycle might not include an ignition cycle. Would you agree with that?
In that scenario, yes.
Fine.
Finally.
With that definition, we're
Finally.
going to talk about ignition cycles, because I don't want to get confused about accessories. Just assume the engine.
Okay.
turns on, right?
Okay.
If you started your testing at 11:64, then if the engine was turned on, thereby initiating a key cycle, driving the car onto a flatbed truck, and then hauling it over to Canton PD, that would be key cycle 1163 in that hypothetical, correct?
You got to get it off the truck.
It could be.
Okay. Then going backward from there, if the SUV was, I'm sorry, let me
Yeah, yeah.
Let
You got to
me
get it
add
off
one-
the truck.
event that I just forgot. It had to get off the tow truck in Canton and be driven into the Sally Port. Did you ever see that video?
No.
Being driven in?
No.
If there was a video showing that the car was actually driven into the Sally Port, that would necessarily be
I
a
don't
key
trust
cycle,
this
correct?
guy to be able to tell us.
Possibly.
Okay, so that would be key cycle 1163. My mistake, I was missing one, right?
Okay.
Before that, if the car was turned on and driven onto the flatbed to get to Canton, that would be key cycle 1162 in order, correct? We're going backward,
It's possible.
all right? Before that, if the car was started and the car was driven from One Meadows Avenue to Karen Reed's parents' home in Dighton, that would be another key cycle, 1161, correct?
They're possible.
Before that, if the SUV was started and driven by Miss Reed from the garage at John O'Keefe's house to Jennifer McCabe's house at 5:07 in the morning, that would be another key cycle, correct? 1160. Is that right?
It's possible.
And before that, if the SUV was started and driven by Miss Reed to the waterfall, from the waterfall to 34 Fairview at approximately 12:15 a.m., that would be another key cycle, 1159, right?
It's possible.
I want to be clear. The reason that these numbers skip in your diagram, they don't go directly in order, right? Not every single number is in order on this left-hand column, because this is only a diagram of when triggering events occur, right?
Yes.
Something unusual about the operation of the vehicle, correct?
Yes.
And it's clear that from the data, there was no triggering event at key cycle 1159, was there?
No.
So assuming the driving events that I just told you, right? Assuming for purposes of my question, that the driving events started at 11:59, driving over to 34 Fairview from the waterfall. Then driving at 5:07 in the morning over to Jen McCabe's house, 11:60. Then driving to Dighton, her parents' house, 11:61. Then the car being seized in Dighton by Trooper Proctor, 11:62. Then the car being taken off the flatbed and driven into the Sally Port at Canton, 11:63. Your testing starts at 11:64. That would mean that at 11:62, that key cycle would include the time in which Trooper Proctor had possession of that car. Correct?
No.
Assuming my hypothetical.
Your hypothetical?
Yes.
If that's hypothetically how it works, then yes.
Then what?
If that's hypothetically how it works, then yes.
That's right.
On June 9th, 2022, you were asked by a grand jury whether you knew or had done any scientific testing to determine the distance a body would actually travel struck by a vehicle. Remember that?
Not that specifically. Not in that way.
Do you remember answering that you had not, I'm just paraphrasing, that you had not done you hadn't finished your report yet?
Why don't you show him? He said he didn't remember it that way.
May I?
Yes.
Take a look at middle of the page. Your answer starts at about line 12, but the question above it is probably informative. You have that in mind?
Yep.
May I approach?
Yes.
You were asked, does that remind you that you were asked by a grand juror if you could calculate how far a body would move having been struck by a vehicle?
Yes.
And you indicated, quote, yeah, there's certain calculations we can do with that, would figure out if the car backed up, hit somebody, and then they go a certain amount of distance, and it's based on miles per hour, the speed of the vehicle, the striking vehicle, and stuff. Remember saying that?
Yes.
What did you mean by stuff?
I don't know.
You said that the calculations would be based on miles per hour and stuff. Did you ever do
Yeah. What's the stuff in the calculation?
to test that? The grand juror's question.
No, we cannot calculate anything from this collision.
Say that one more time.
We cannot calculate anything from this collision.
Who's we?
Me, the role me.
Well, you know John O'Keefe's weight, right?
What's that?
You know John O'Keefe's weight, 217 pounds, right?
Yes.
Did you know that?
I don't know his weight, no.
You know the weight of the vehicle?
Yes.
What's the weight of the vehicle, gross weight?
What's the gross weight?
Yeah.
I think it's approximately 7,300 pounds.
Okay. Were you able to calculate the mass of the vehicle?
I did not calculate the mass of the vehicle.
Well, you told the grand juror that you were planning on doing that kind of stuff to calculate how far a person would travel being struck at that speed with a car of that weight. You didn't do those calculations?
No, because the calculations would vastly underestimate the speed of the vehicle.
You testified,
What?
again, my report isn't done yet. I'm going to look into it. I'm looking into all that stuff, end quote, correct?
Yes.
There's that word again. It's been more than 2 years since that statement at the grand jury. Is your report finished?
Yes, it is.
Did you engage in any of those calculations?
I looked into it. This type of collision I would not be able to use the formulas for this type of collision.
Well, let's talk about those formulas. How would you calculate how far a body at rest would travel after being struck by an object in motion? How would you calculate that?
In pedestrian collisions, I use a Searle throw formula.
A what formula?
Searle.
What does that mean?
It's a type of formula that would use for a calculation of post-impact
So
How do you
speeds for
spell that?
pedestrians.
that includes certain principles of physics to calculate that, right?
What do you mean?
I'm sorry?
What do you mean by certain forms of physics?
There would be physics calculations that would be required to figure out how far a body at rest would move having been struck by an object in motion.
Right.
That's a basic principle of
Yeah, I guess you could say though.
All right. Can you describe for the jurors exactly what calculations you would need to employ to determine how far a body at rest would travel, having been struck by an object in motion?
So, in this scenario, in this collision,
I think
it's
maybe
more of
it
a
was.
side swipe. So he did not ascertain. He did not get enough speed of the vehicle post impact with the vehicle to be able calculations. His center of mass was offset from the vehicle. So we would vastly underestimate his speed. So that's why I did not do a formula. If he was more in line with behind the vehicle, he
So you
would have been
couldn't
projected forward.
calculate it at different
And using
angles
that
of
projection
incidence?
forward, he would have been able to get more closer to the actual speed of the vehicle during that post-impact travels.
Well, that presumes a couple of things, Trooper Paul. That presumes that he was quote unquote sideswiped, right?
Presumed,
Presumed by you. You didn't see how he was hit, did you?
based on the evidence, it appeared to be a side swipe.
That's your opinion.
That's disputing the evidence.
You're saying that the principles of physics as we know them today in modern mathematics is thwarted by a sideswipe?
Objection.
Is that what you're saying?
The calculations that are out there, you can get a speed, it'll just underestimate the speed.
You would have to know what the initial momentum of the object is that's in motion, correct?
Of what object?
The truck, Paul.
I would have to know that speed.
Yeah, you'd have to know what the initial momentum is, not speed, momentum. There's a difference,
Okay.
right? Would you agree with that?
No.
Oh boy.
You wouldn't have to calculate what the initial momentum is of the object in motion to determine the distance of the body at rest would move?
Well, in that sense, are we talking about, I'm trying to find the speed of the vehicle? That's usually what we're trying to do.
Right, okay, well.
But
let's
we're not
put the
trying
speed
to
of the
do
vehicle
that
aside.
here.
Let's talk about initial
So
momentum.
you take
What's
the mass
formula
of the
for
vehicle
calculating
moving
initial
at that speed.
There's different types of momentum formulas.
Well, there's actually one type of momentum formula. It's to calculate momentum.
Objection.
Sustained.
To calculate momentum, there is a single.
So sustained. Ask it differently.
Isn't it true, Trooper Paul, that there is a singular calculation for determining initial momentum? That is P equals M times V, where P is the momentum. You're solving for that. M is mass. You multiply that by velocity. Is that right? Pretty simple.
You wouldn't use that in a pedestrian collision.
Oh, because the pedestrians
Different physics?
somehow magically out of the realm of physics?
Objection.
Sustained.
Is the pedestrian out of the realm of physics and calculations?
No, it's the weight differential between the pedestrian and the vehicle.
So if the vehicle is too heavy and the body is too light, you can't calculate the initial momentum of the vehicle?
Yes.
Got it. Where'd you learn that?
It's in my math class.
I
We
didn't
only use
take
momentum
physics
for a
since
vehicle to
8th
vehicle.
grade,
The
and I
math-
know some
but
of
the-
these.
The crash reconstruction classes I have taken.
Got it. Would you need to apply the theory of conservation of momentum in calculating these data?
Do I need to calculate the conservation of momentum?
Or calculation,
No.
of conservation of momentum?
Yes.
You even know what that is? There's an equation for that as well, right?
Do you know what
Yes.
that is?
You know what that is?
Not off the top of my head, but yes.
Based on the basic principles of physics, is the total momentum of the collision greater or less than the total momentum after the collision? Total momentum before the collision, is it greater or less than the total momentum after the collision? Basic question.
What type of collision?
Paul,
Oh
They're
my
exactly
God, he's trying
equal.
so hard.
in all respects under the principles of physics, right? That's the theory of the conservation of momentum. Momentum doesn't change. It's
Yes.
transferred from one body to another,
Yes.
correct?
Correct.
Why didn't you say that to the jurors?
Objection.
Sustained.
Trooper Paul, if you were qualified to quote, look into all this stuff, you would
Oh,
probably know
my
these answers,
Lord.
wouldn't you?
Objection.
Sustained.
Are there any other calculations that you need to figure out the stuff that you were talking to about with the grand jury?
Objection.
Sustained.
How about calculating the final velocity of the objects after the collision? Would that be important?
What objects?
That would be John O'Keefe's body, sir.
You,
Object
I don't.
that you claim was flying through the air 30 feet.
Okay,
Objection.
sustained.
How about calculating the displacement using kinematic equations? Would you be able to do that?
The displacement of the body.
In order to calculate how far the body would move based on the mass of the object striking the body, could you use displacement using kinematic
I'd say not
equations?
off the top of my head.
So, like I said before, the side swipe, he would not have gotten 100% of the vehicle, 100% of the speed of the striking vehicle. It would have vastly underestimated this vehicle. You couldn't hit a person and side swipe them, spin them off to the side,
So you
and
can
have that and
take
get that speed
various
from those
percentages
calculations.
So you're
based on different
saying
angles of
that-
incidence.
the discipline of physics cannot figure out how far John O'Keefe's body would move. But you personally figured out that he would have flown now somewhat, or been projected somewhat 30 feet.
Objection.
Sustained.
Are you saying that the principles of physics are incapable of determining with the proper calculations how far John O'Keefe's body would have moved given the collision at issue?
Objection.
Is that what you're saying, Trooper?
No.
Okay, next question.
Well, you just said because it was a sideswipe, all these calculations, these physics calculations are inapplicable, right?
I'm saying it would underestimate the speed and the distance.
The truth is, Trooper Paul, you have no idea what all these physics calculations mean, do you?
Objection.
Sustained.
You've not been trained in physics formally, have you?
Yes.
You have been,
It's incorporated into the classes.
right? You have a few classes that use the word physics, but you haven't been formally trained in physics, have you?
Objection.
Sustained.
You haven't been formally trained in kinematics,
I took some classes.
correct?
It's in the aspects of all our crash reconstruction classes.
You haven't been formally trained and hold no degrees in biomechanics, do you?
I do not have a degree in biomechanics.
In fact, basically what you did in this case was calculated emission cycles. And you even got those wrong, right?
Objection.
Sustained. Come on,
Ouch.
Mr. Jackson, ask the appropriate part of the question, you'll get it.
Let me ask you this. Based on your reconstruction, nearly 2-year investigation, exactly how was that taillight shattered? Explain it to us.
How does the taillight, what do you, it gets, so the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
Based on what I saw for his injuries was from the upper part of his arm down.
Was his arm out? It just struck the arm like a hinge? Was it in front of him? You did the reconstruction?
It looked,
Here's exactly how his body was positioned when he was struck by that.
so it looks like his arm was more kind of like this, if I can try to get that.
You're indicating out by his side, correct?
Yes.
All right. And the taillight would have struck his arm, right?
Yes.
Not his torso.
Yes.
Okay. So
How would that even work?
the full mass, the full weight of that truck hit him basically at the elbow. Is that right?
No,
Missing his
no.
torso.
But I said it, yeah, from upper part of the arm
Right.
down.
The
Yeah.
elbow and the biceps.
I didn't see anything that shows an indication that this lower torso was struck, but
Okay. So his torso,
it's not saying it could not have been a possibility, but I just didn't see anything.
Would have
so his
ripped his
torso
arm
was
off.
spared from being hit, but the arm took the brunt, the full force of the vehicle, correct?
Like arm and shoulder, yes.
Okay. And you said he then did a
Arm and
spin,
shoulder.
like a sort of a pirouette.
He got spun around possibly the way it struck, it looked like it could have turned around counterclockwise.
Okay. So if he turns around counterclockwise, is he turning around in the air counterclockwise?
Yes, initially.
So he gets hit on the upper biceps, shoulder area, and down to the forearm, right?
Yes.
By an unbroken taillight.
And his
Right?
arm doesn't
Yes.
come
In
into
other
his
words, it's
torso.
nice and smooth. Nothing, no shards of plastic or anything broken at the time that it made contact with his arm, right?
Correct.
Okay. So how did his arm get all cut up?
Because when his arm struck the taillight then cracked, and as the car is driving past him, the taillight could scratch it.
Got it. So
It
gets
dragged
hit by
him.
the car, not his torso, just the arm. The taillight cracks, and as it passes by, his arm stays with it long enough to get striations, those scratches that you see, those lacerations, I'm sorry, those abrasions that you see, right?
In a sense, yes.
And at the same time,
At the same
does a
time, he's
pirouette.
pirouetting.
and flies 30 feet to his final point of rest.
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise. I don't know how far he ran counterclockwise, but he started rotating. According to that, would push him to rotate
Which would be away
counterclockwise.
from
Whether he
the
went
taillight.
counterclockwise all the way to his back toward the ground, it seems like a most likely possibility.
Got it. Did you account for the fact that his arm is on a hinge?
It's what? Say again?
Did you account for the fact in this scenario that you just told the jurors that his arm is on a hinge?
On a
Called his
hinge.
shoulder?
Okay.
Okay, so the arm got hit. Didn't his arm just swing?
I said arm and shoulder area, so his arm could have been considered part of it.
Even if his shoulder got the upper,
Okay.
you're pointing to his upper biceps,
Mhm.
right? There's no injuries on his shoulder, not a single one, not even a bruise, right?
Not even a bruise.
Like I said, it looked like to me it was from up here. I don't know how far I can up back here, but it was up here.
Well,
So
you're the one that talked about his injuries on his arm.
yes.
That's limited to about mid biceps, to about mid forearm, correct?
Okay.
Right?
With no bruising.
Yes.
No injuries on the shoulder, no injuries on the torso, no injuries on the ribs, no injuries on the back, correct? Is that right?
Yes.
So your theory is you got hit on the arm, took the brunt of the force from the taillight on the arm, stayed with the vehicle long enough for the taillight to explode, basically, to shatter. Then these striations get on his arm, abrasions. Does a pirouette, spin, counterclockwise, and flies 30 feet in the air to his point of rest.
Yeah, it happened probably a little faster than that though.
So when did his head hit the curbing?
I thought you said he hit his head on the curb.
I said that's one of the possibilities of when you look at the roadway as he gets spun around kind of clockwise. It's a possibility that the curb is there, any blunt force object on the ground, as the ground is pretty blunt.
Well, except in your scenario that you just told us, you flew through the air onto the light dusting of snow, grass, and dirt.
I didn't say through the air.
Say that again?
I didn't say he got thrown through the air.
Okay, I'll use your word. You got projected. Like
Projected doesn't mean it's not incorporating just throw. Project just means you get pushed forward. There's two parts of that. There's the air, then there's the
So
ground.
he did a Roadrunner
Like I said earlier,
cartoon
the
with
tumbling,
his
the
blurry
rolling, whatever.
feet.
That part of the crash would happen. Projecting is just what we call what happens to a pedestrian post-impact with a crash.
Okay, so a couple questions. If his arm, elbow, took the brunt of that entire impact, how do you account for the fact that he didn't suffer a broken bone?
I don't know.
How do you account for the fact that he didn't have a fracture?
Objection.
Sustained.
How do you account for the fact
Didn't even have a
that he didn't even
bruise.
have a bruise on the arm?
Objection.
That's sustained.
They reproach.
Yes.
Yeah, he should be able to ask that. He should be able to ask that. Trooper Paul, in your experience investigating pedestrian vehicle collisions, and how many occasions was somebody struck by a vehicle at 24 miles an hour and did not sustain a bruise at the point of the impact? How many times has that happened? He is murdering this guy. I mean, we knew there was going to be blood on the floor, but he's like smearing it on his face. He's going full Braveheart on this guy. I mean, no. I want to know. I want to know what the jury's expressions are in all of this, because this is just beyond dumb. This is just beyond dumb. You hit his arm. His arm is going to hit his body. His arm is going to hit his body. That's the whole momentum thing, right? His arm hinges, it moves. Your body doesn't start to move yet until it absorbs the force from the car going to your arm into your body. The whole thing is going to be all smashed up. And he sticks to the car long enough to cut up his arm, but still gets flipped counterclockwise away from the car. It's just idiocy.
May I inquire, Your Honor?
Yes.
The truth is, Trooper Paul, you know, having investigated auto pedestrian accidents in the past, But John O'Keefe's injuries do not look anything like an automobile pedestrian accident, do they?
Yes, they do.
Isn't it true, Trooper Paul, you came to these opinions and conclusions because Trooper Proctor told you to come to these opinions and conclusions in furtherance of his investigation?
That is not true.
That's why you have these opinions and conclusions that just don't make sense, correct?
That is not true.
And you're just trying to fit a square peg into a round hole.
Action.
Sustained. All right, jurors will take the morning recess.
All rise for the court, please.
And I'll see counsel at sidebar about scheduling.
About scheduling. More about scheduling. Wow. Wow. Now, I'm not going to blame him for not knowing the actual conservation of momentum formula off the top of his head, although it's not that complicated. Mass 1, velocity 1, plus mass 2, velocity 2 equals the same thing. That's the whole. He needs to know. Yes, conservation of momentum. That's the whole point. The momentum, it stays the same. That's literally what it means. Literally what it means. How does he not know that? I mean, he could barely spit out Newton's first law, so why would he know the third? Wow. Wow. The key cycles, man, the key cycles. That was pretty brutal. Let's count them. Let's count them down. Let's count them down, because, yeah, that's what we're left with, is the one at 1162. That's when Proctor had it. That's when Proctor had it. Might have gone through and generated some data. All right, it's fan time, so we'll go ahead and and
hey there,
take our
Karen
pause
Reed,
from all
trial
that.
watchers. This is another law and
Oops.
crime.
Quiet, Jesse. Holy crap, that was even more brutal than I thought it was going to be. That was so extremely brutal. Brutal, bloody. Yikes. Yikes. I mean, you could not have made this guy look less qualified. You couldn't. You couldn't make him look less qualified. Basic stuff. Basic stuff that he doesn't know. So he's sloppy with his language when he wants to be sloppy with his language, but then very precise when he wants to try to pick apart the question because it's a dangerous question. Right? He'll just generally throw out U-turn to mean 3-point turn, but we need to really distinguish between ignition cycles and key cycles. Even though you can't turn on the ignition without powering the key to on, you need the battery. You need the battery to start your car. Not alleging she popped the clutch here, right? It's not that kind of car. Didn't get it started off the flatbed that way. Just roll it off, pop the clutch. No, this ain't that vehicle. So when your math doesn't math, if we're precise with our language, then we'll be vague and confusing. Then we'll try to create confusion where there isn't any. We all understand. A key cycle is not necessarily an ignition cycle, but an ignition cycle is necessarily a key cycle. We understood that long before you did. If we are to take your confusion here as being in good faith, No, he didn't do it from the key cycles because it doesn't work if he does it from the key cycles. That's why he has to go through and do the mileage calculation. You don't have access to the cell extraction. Nobody buys that. Nobody buys that. They're going to say you need to do this reconstruction, but we can't provide you with relevant information from the rest of the investigation. Of course not. That is one of the dumbest things I've ever heard somebody say on the stand. Of course you can get that information. Why didn't you? That's what we want to know. Why didn't you? Or did you have it and it didn't work? So you pretended like you never had it. No, you probably didn't even bother because they already knew. They already knew it wasn't going to add up. So they just didn't even give it to you. And you didn't ask. The piece of taillight in front of the fire hydrant, yeah, that's a problem. That's a problem. Because how's that change your line now? How does that change the whole physics of all of it? You according to you didn't have that information, so you did your projection, your figuring out, your reconstruction, which apparently involves no math. The math doesn't work, so you just do it in your head. You just do it in your fever dream. Okay, I imagine this is what it looked like. That's your reconstruction. Well, no wonder his opinion doesn't have to change if the debris field changes. And there's actually this other piece that's like, 15 to 20 feet from these other pieces that you diagrammed. Of course, that doesn't change anything because you didn't do any math. It would change math. It would change math. But it doesn't have to change your fever dream. That can remain consistent. That was one of the most brutal cross-examinations I have ever seen. And with an expert. Oh, my Lord. I mean, I could practically see Jackson like wiping the drool off his chin. He was tasting the blood. That was absolutely brutal. What have you guys had to say about this? WM Penguin, I don't know. I think it's fair. I look at videos and pretend I know about what's happening all the time. Yeah, well now you know you can be an expert in court. Get your profile out there because that's the bar. That's the bar in this court. You took some classes and then you looked at some videos and pretended to know what's happening. That's enough to qualify as an expert in this courtroom. Solo YOLO, it's been a clown car of Commonwealth witnesses. No, not a serious person. Not a serious person. No, I take it back. Who is the serious guy? The guy from Dighton? He seemed pretty serious. No problem with that guy. Nothing obvious. Certainly didn't have the same incentive to play the game that the rest of these guys did. Snap. Do we even know if Trooper Paul even did any wheel rotation ratio tests on Karen's vehicle since the steering data was part of his opinion? No, he didn't say anything about that. He didn't say anything about that. And that's something somebody pointed out last week, is that normally it's not 180 degree, your wheel turns 180 degrees and your steering wheel, and that rotates the drivetrain 180 degrees. They're not equivalent. It's like usually at least double. So he's saying a 4-degree angle in the steering wheel, it's like a 2-degree angle in the car. Like best case scenario on average, maybe. But we don't know because, no, he didn't tell us about any of this testing. He didn't tell us they did anything like that. A 2-degree angle on the wheels, I mean, is nothing. It's nothing. And Cat Mayer, did anyone else catch that the how long to digest food Apple search suggestion. Wonder what made it suggest that. You know, I did. I saw that was the suggested search. That was the explanation for what all of those cell phone, fragments, the data fragments meant. That she was Googling the Haas long to die in cold, and Google suggested how long to digest food. She rejected that and searched the Haas long to die in cold instead. The only reason I can think of is just because Apple is woke, and so they're not gonna, if you misspell something and it's suggesting, it's not going to suggest die, how long to die, anything, no, that might be, dangerous or offensive or triggering or something like that. So let's just suggest something a little bit, more innocuous. That's all I can really come up with. I'm sure that's an Apple algorithm type of question, but yeah, it was, I would say it's because of the die. Cheeky Kitty, I found you late, my town brain. Well, welcome. Better late than never. We're just having quite a time here. Trying to trying to figure out what the hell we're watching. Did I take a wrong turn and end up at Barnum and Bailey? Am I in a circus? Or is this a courtroom in Massachusetts? Did I get misplaced somewhere? Absolute train wreck. Jason Sorensen, tell us again how he bounced off the curb 10 feet into the lawn. He flew, he didn't fly, he was projected, his head hit the curb, but he, how would that affect his rotation? I mean, nuts. It just left, but there's no dent on the curb. I mean, asphalt's not that hard, not that solid. It's not that hard to gouge out the asphalt. Broke his skull. A lot more solid than asphalt. Didn't chip the asphalt, didn't leave any tissue, no blood, nothing like that. Didn't abrade his head, didn't abrade it. He just hit it exactly perfect, just like his arm dragged on the taillight while he was being rotated away from the taillight. Insanity. Horror vibes. Are we in Intro to Law 101 today? I think, we're at just like basic life functioning skills today. Okay. I feel like we're back in kindergarten learning how to feed ourselves level of education today. Basic stuff. Absolutely basic stuff. Yeah, Judge let him stick with that opinion that he gave last week, didn't strike it. Let him stick with it. Let him explain it some more. Well, because you'd expect to see paint transfer and relative heights and stuff like that. Yeah. It's driving me nuts how she won't let him ask a leading question. This is cross. You are allowed to put words in their mouth. You are allowed to confront them with your theory and require them to answer it. That is what confrontation is. Not letting him do that, making him ask these open questions. There's no basis for that. Dude McGuy, Trooper Paul has never been a witness before. I wouldn't know. Wouldn't know, but he is not an impressive one. He is not going to be on the top of the list for the prosecutors in Southern Massachusetts. Oh, accident? Let's get that guy? No, this is so bad. This is so bad. I mean, the wriggling he's doing. He looks like a trout on the line. He's trying so hard to throw that hook and he just can't. He just can't. No, Jackson's got ya. He's got you on your own arrogance here. You thought you were going to be able to bluff your way through this reconstruction and nobody was going to check your work. It's all just adding to they thought they would lean on her and get her to plead. That's it. They thought they were going to pile all this stuff on her and get her to plead because most people don't have the money to go out and hire their own accident reconstructionist to look at this and laugh. I can't wait to see the chuckles on the defense experts when this is put to them. I can't wait. I mean, just the contempt we got just from Jackson. Oh, you don't know what any of this means, do you? No, we can see that. We don't even need him to answer. We can already see that. He doesn't know what any of this means. He didn't know Newton's third law. He could barely spit out the first, and he didn't know the third. Unbelievable. The crypto tax lawyer. Karma sucks, Bev. Bad evidentiary ruling leads to confusing, ineffective testimony. Good morning, y'all. It's been a circumstance of be careful what you wish for because you might get it good and hard. Be careful what you wish for. You might get it good and hard. Bird Fam Bam. This man is lying and it makes him so nervous. He knows he's out of his depth and he's just struggling to try to cover that up. He doesn't want to be exposed as the know-nothing that he is up there. But he knows that he is. He knows that he doesn't know much at all. And he knows that there's all kinds of people who know a lot more than he does about this type of thing. So he's just scrambling to try to save face. That's really all it is. No, please don't make me look like an idiot. You know, I'll try to draw these distinctions that don't matter between key cycles and ignition cycles to try to put up a shield to protect me from how dumb you're making me look. I mean, lying. He's just making shit up and trying to defend it is what it is. Did Trooper Proctor tell you that? No. Did that sound like a 5-year-old getting caught red-handed or not? No. Stephanie H. Cross will be so brutal he can't even speak. Well, I mean, he tried. There were words that came out, but did they edify us? No. Jason Sorensen. 24 miles an hour in 62 feet at 75% throttle. Sir, did you even do the math to see if it's possible? Does the Lexus have the horsepower and torque to the wheels to even do that? Amen. Amen. Yes. This is what we need to know. This is all verifiable. You can close this circle. You can do this math. I mean, this car doesn't look like it's been modded. It should be factory with these capabilities. So yes, you can translate. You look at the volume, cubic volume of the engine. It's all of this stuff. Okay, and I hate to tell you this, but a lot of people who work on cars, they didn't go to college to do that. They know all this stuff and they don't even need an associate's in criminal administration. It's not rocket science. It's not that complicated. Most of this is basic arithmetic. So yeah, you figure out how much force, how much volume, how much force is created by that engine, given the volume of the engine, and the piston size, all this type of stuff. And that turns the drivetrain at this, and transfers that into the wheels, and then given the wheel size and the weight of the thing, I mean, yes, they can figure all this stuff out. What's the horsepower of the engine, and how does that translate into torque at the wheels? And the torque at the wheels is that ability to get it going from 0 to whatever speed at whatever distance. It's not complicated math, but even basic math seems to be a pretty big problem for this guy. Just because, did Trooper Paul spend the entire weekend expecting this is going to be excluded? Hasn't he ever heard expect for the worst but hope for the best? I mean, he sure came in all freshly shaved and ready to go, didn't he? He thought, if nothing else, he was going to go to the guillotine in style. He was going to hold his head high. Take it like a man. I'll give him props for that. He took it like a man. Kinda. He complained a little, but, you know. I can't imagine he slept well this weekend. I really can't. But on the other hand, you know, I don't... He knows he's not that smart. He knows he doesn't know that much, but does he know enough to know? Does he know what he doesn't know? Is he smart enough to have a sense of what he doesn't know, to understand the magnitude of his own ignorance and how that was going to be thrown in his face today? I'm not sure that he actually knew. He doesn't even know Newton's third law. And his explanation, well, it was a side swipe. It was a side swipe, so you can't calculate. Unbelievable. Like that can't be accounted for. They don't have to account for that all the time in things like, I don't know, jet travel, you know. They occasionally run into things in the air, you know, debris, birds, stuff like that. Oh, just an absolute nightmare. Michelle Johans 1. If you didn't hear it from EDB, AJ worked as a mechanical engineer for the U.S. Air Force before becoming an attorney. My understanding is he was a jet mechanic. I don't know if he was actually an engineer. I'm sure that, I mean, a jet mechanic, to be able to work on a jet, you have to have some understanding about how jets work. And so there may be kind of some engineering like involved with that. I'm just not sure it is technically an engineering position, but it might be. I don't know. I would be interested to know exactly what did Mr. Jackson do with jet engines? Exactly what does he know? I mean, he certainly had a lot of felicity with these Reconstruction terms. He's a smart man. All right. Oops. Looks like we're back. Let me get us back up here. Get our sound back.
You see, close back a session.
Yes. Very important point here. Because the torque will make your wheels spin. It's the problem I have with my little sports car and why it doesn't drive well in the
All right,
snow.
Mr. Lally,
Too much
whenever you're
torque is
ready.
bad in slippery conditions.
Now, with regard to your testimony as far as that triggering event, well, the two events on 12,629B, you testified that was consistent with the pedestrian collision, is that correct?
That's correct.
Again, if you could tell the jury, why is that consistent with pedestrian collision?
The one specifically with the speeds and everything that we're referring to.
24.2 miles per hour in reverse for about
Right.
62 feet.
Okay, yeah, so why I think that's consistent with a pedestrian strike is because of the sudden change in the speed. It drops down by half mile per hour. The accelerator pedal is staying constant at the same percentage, and the steering wheel angle also turns to the right.
Now, your overall opinion is based on what you did as far as your construction, correct?
Yes.
Other information that you had at your disposal in formulating your opinion?
Like from other reports and stuff?
Yes.
Yes.
And that would include physical evidence, is that correct?
Correct.
And that would include witness statements, correct?
Sustain is to form.
What, if anything else, would that include?
The roadway evidence, witness statements.
In witness statements, would that also include statements of the defendant?
Correct.
Are you aware that the defendant
All these
indicated
super smart
in a
people in the
statement to
chat.
troopers that she conducted a three-point turn in the area of 34 Fairview Road?
I'm going to allow that question.
Yes.
And what you observed in that triggering event is that from that mileage, is that consistent with the defendant's own statement?
Yes, it is.
Now, let me ask you a little bit, if you could, again, for the jury, clarify the difference between what you termed as an area of impact versus a point of impact.
Yes, an area impact is broader. It's a bigger area. Point to impact would mean something as a, obviously, right there. That would be the area impact.
If I could ask, the cell phone that was located under Mr. O'Keefe's body, that location, is that also consistent with the linear path that you were testifying about earlier?
Yes, it was.
And do you know whether or not that cell phone was in his hand or in his back pocket or somewhere else?
I do not know.
Now, as far as the, let me ask you this. You were shown some photographs of some taillight pieces near a fire, correct?
Yes.
And as far as the area of impact, that was, from what you determined, that was Mr. O'Keefe's sneaker, is that correct?
Yeah, it was within that. What I've had for no initial evidence, I said the area impact was a star in that area prior to the sneaker. So what I was saying was the area impact was prior to the area the sneaker was. It was in that path, just prior to that area.
And why did you determine that it was in that area?
Because that is the first point of evidence.
And first, I'm sorry, just first point of evidence in relation to what and sort of how the evidence was configured as it was evidence to you.
That was pointed to me. It was the first point of evidence away from, for the furthest point of evidence at that time that knew away from the pedestrian.
May I approach the witness, Your Honor?
Yes.
And sir, I'm showing you what's been marked as Exhibit 58. Do you recognize what's depicted in that photograph?
Yes.
And Your Honor, with the court's permission, if I publish that for the jury.
Okay, what exhibit number is it?
58.
Thank you.
And Trooper Paul, do you recognize what's up on the screen?
Yes, I do.
What do you recognize that?
There's 34 at Fairview at the left side, and there's the fire hydrant.
And as far as these photographs and the photographs shown to you by Mr. Jackson on cross-examination, do you know when those photographs were taken?
I do not know specifically at what time those were taken.
You don't know if those photographs were taken on February 3rd, 2022?
Objection.
Is the objection sustained?
How leading is that?
Now, Trooper, if you could, using the laser pointer, I know you've done this on the diagram, but if you could use the laser pointer with regard to what's on the screen as Exhibit 58, direct the jury's attention to where you believe the area of impact to be between the defendants, Lexus and Mr. O'Keefe.
It's probably somewhere out here.
And as far as that linear path that you were talking about from the area of impact, where did that go from and where did that go to?
Should I say? So from, I think it's from around like this way.
Oh, Jackson's going to get him on that. So how'd the thing go sideways to the fire hydrant? Let's just revisit that on recross, shall we?
Now, Trooper, if you could explain to the jury as far as what you were describing as Mr. O'Keefe's post-impact movement, starting sort of with the point of impact between himself and the SUV to the point where he comes to final rest on the wall.
Yes, so he was struck along the right side in the area of his arm, and then he was, post-impact with the Lexus, he rotated counterclockwise and eventually hit the ground and came to final rest.
And the ground, based on your understanding of the weather conditions, was frozen at the time, is that correct?
Objection.
Sustained. Watch the form, Mr. Lally.
Yes, sure. So as far as anything in your testimony about Mr. O'Keefe's actions, does that involve a pirouette?
Hey,
No.
no licking.
So there's a rotation, is that correct?
Correct.
And as far as 30 feet in the air, do you have any opinion as to whether or not he flew 30 feet in the air?
I do not have any evidence that he would have flown 30 feet in the air.
And so as far as from your training experience when it comes to pedestrian collisions, are you able to determine or calculate how much distance someone is in the air and how much distance someone sort of rolls or tumbles to their final resting position?
Say it again.
From your training experience,
Yes.
based on this collision, are you able to determine how far Mr. O'Keefe was traveling in the air versus how far he traveled tumbling or rolling after he hit the ground?
I do not have a calculation for this specific style of pedestrian crash due to the side swipe. So if I did, I could use the formula. It would just vastly underestimate the speed of the vehicle.
He didn't do great.
Let me ask you a little
physics.
bit about it. You were talking about the Searle pedestrian throw formula, correct?
Correct.
And that's something developed in the course of physics specific to Reconstruction by someone named Dr. Searle, correct?
Correct.
And that's S-E-A-R-L-E, is that correct?
That is correct.
And with respect to Dr. Searle's formula, why is that inapplicable in sideswipe collision versus some other type of collision?
Because it takes in, it's looking for more, not so much the formula, it's how much projection efficiency that would occur, how much percentage of the speed of the striking vehicle would have happened. In order for the formula to work, the more of the body would have struck the vehicle, the more efficient the outcome would be in the speed.
In the center of mass that you were talking about, sort of in the collision sequence, what, if any, role does that play in regard to your ability to do that calculation?
It would just, like I said, it would underestimate the speed of the striking vehicle due to the center mass not within the rear of the vehicle.
And not to twist your words or anything, but as far as when you say underestimate, that would not be an accurate reflection of the defendant's vehicle speed, correct?
Correct.
Now, you asked some questions about the glass and indicated that there are a number of reasons why the glass would travel with him, being Mr. O'Keefe. Can you explain what those are?
Yeah, the glass could have struck the vehicle also in that same way. Could have still been attached to his hand and still gone with him in the same way. It could have been attached to his body in midair. That's the multiple ways that the glass would have stayed with him.
Now,
But the taillight
and
didn't.
speaking of collision
Taillight that scratched up his arm did not
sequences,
stay with
particularly
him.
collisions involving multiple vehicles, vehicles are affixed with bumpers, correct?
Correct.
What's the purpose of a bumper on a vehicle?
To help absorb the
Scope?
Yes.
Yeah. Sustained.
Your Honor, if I may, I don't believe it is.
So why don't we come to sidebar?
Beyond the scope of the cross. He's trying to get back into that that whole thing with the taillight. Taillight could have been broken when she backed into John's car because his bumper was in the way. His bumper would have been scratched, which of course depends on the relative heights of everything and the angle at which they're approaching each other, which he didn't do any kind of reconstruction of. He just looked at a video and said, nope, couldn't be. I don't see it. So yes, that is beyond the scope because Jackson really didn't cross him about that. I mean, he doesn't have to. It doesn't matter. He just, he got him on his lack of qualifications. And just the incoherence of his whole theory. Looking through my notes to find where he asked about that, because it was literally like just a couple questions and that was it. That was it. Talked about normal wear and tear. The bumpers get scratched lots of ways. Not the same scratches as what were on the bumper.
So I'm sorry again, Trooper. If I could ask you, what is the purpose of a bumper on a vehicle?
It's there to help absorb energy from
So
the
now
collision.
she's going to let it.
And with reference to the scratches that you were asked about on the vehicle on sort of the right rear quarter panel, what, if any, relationship does bumpers or their interaction have to your opinion as it relates to that?
Sorry, say it again.
Back to what you just testified about bumpers, you were also asked some questions about scratches on the right rear quarter panel of the vehicle, correct?
Correct.
And what, if any, relationship does the bumpers on the vehicle and sort of their intended purpose have with relation to the scratches that you observed?
What the hell
So
is that
the bumpers on the
question?
side was more of this wasn't more of a direct on hit with the bumper. It was more of the side scraping of the paint of the bumper.
Now, the presence of Mr.
Kind of like you're
O'Keefe's DNA
scraping
on
past
taillight,
the
is that
bumper of his
consistent with a
car.
pedestrian collision?
Yes.
Now, as far as the glass not matching, are you aware that the lab's actual findings were that the glass on the bumper and the glass on the roadway was just not found to be consistent with each other? Is that your understanding? If you know.
I don't know.
And were you also aware that the lab's finding was that the glass on the bumper was consistent with the glass on the road?
I'm not sure what the lab said.
Now, in order to construct your diagrams, your testimony, I believe, was that you had used certain diagrams in the process of that. Is that correct?
Yes.
And if I could turn back to that 12629B, the mileage from the tech stream data.
Yes.
The 3-point turn that you observed in the 24.2 mile per hour straight line for approximately 62 feet. How far apart time-wise within that particular triggering event were those two incidents?
8 minutes.
And as far as any of the other tech stream data that you observed, was there any other triggering event that included the 3-point turn?
No.
Now, as far as the defendant's path of travel, is it your understanding that that was obtained from a multitude of different witnesses?
Yes.
Now, with reference to, you were asked some questions about the defendant's cell phone, as far as GPS locations. Were you aware that the defendant's cell phone wasn't able to be accessed until by law enforcement until 2023?
Sustained.
Were you aware that the defendant's cell phone had GPS locations turned off on the defendant's cell phone?
Objection.
I'll allow that.
I was not aware.
Now, as far as placing the vehicle during that triggering event, 12629B, did you use key cycles to put it back at that location at that time?
No, I didn't.
What did you use?
I
know he
looked at the
didn't,
odometer
'cause that
mileage
wouldn't work.
And why would you look at the odometer mileage over the key cycles?
because I can physically see the odometer mileage at the vehicle at the time of my inspection.
And why would, well, let me ask you this. In your opinion, as far as that is concerned, sort of backtracking to a specific location, which is more reliable, the odometer or the key cycles?
I would say the odometer mileage.
And why is that?
Like I said, you can physically see it when you turn the car, and I know that's the odometer mileage that it's reading on the dashboard.
And every key
It's
cycle
more
is that
reliable because
necessarily
you can
recorded
see
within
it.
the text stream data?
No,
And why not, sir?
it only records stuff that related to the triggers.
They don't what?
They only record stuff that is
Yeah,
related
it's
to the
only
triggers.
recorded if there is a trigger. So its absence tells us there was no
As far as
trigger.
counsel's hypothetical with regard to the key cycles, is it your opinion that that hypothetical is accurate or inaccurate?
Inaccurate,
And why so?
because it also be you also add the odometer mileage onto the key cycle. So those key cycles and odometer mileage are on the same trigger. And plus the data seems consistent with everything else that's going on with this collision.
Because it looks like it, therefore it must be.
Now, fair to say that you were not outside of 34 Fairview Road on January 29th, sometime around 12:20 to 12:30 a.m., is that correct?
That's correct.
And so fair to say that you don't know exactly how Mr. O'Keefe and or Glass or anything that he's holding interacted with the defendant's vehicle at that time?
Objection.
I'll allow it. Is that true?
I do not.
And so based on your training and experience and the number of pedestrian crashes that you've investigated, again, if you could, one last time, just describe to the jury how you believe the vehicle interacted with Mr. O'Keefe and why.
Objection.
Sustained. It's asked and answered.
Yes,
With
it is
reference
asked
to what
and
you've
answered.
described as far as the interaction between Mr. O'Keefe and the vehicle, why is that your opinion?
Objection.
I'll allow that.
Based on the evidence
Because
from
that's the only way it works.
the vehicle, based on the injuries to John O'Keefe, the taillight appears to be broken and it's sharp plastic pieces that could have ripped his arm. And also the dent with the scratches above it is consistent with a hand holding a glass and the glass on top, smashing on the vehicle and the hand smashing the vehicle. You can see there's a line between scratches
So
and a
his
dent
hand
there.
smashed the vehicle, not the arm? Where's the injuries on his hand?
That just told me on.
Yeah, oh yeah, we're getting
Very
recross, all
briefly, I
right.
just want to make sure I clear something up about the key cycles. You're not suggesting that every key cycle in the history of the car is on this page, correct?
That's correct.
I'm pulling up Exhibit 591.
Okay?
That indicates key cycles that have triggering events, correct?
Yes.
Triggering events are something that the manufacturer includes in basically a list of items that will be a triggering event, correct?
Yes.
It's a list of items basically for mechanics to figure out if there's some unusual driving or unusual event with the vehicle, correct?
Yes.
But the key cycles go in order. They're numerical, 1 through whatever.
Correct.
And the hypothetical that I gave you on cross-examination, with those driving incidents, each one of those would represent a key cycle, correct?
So in your hypothetical, I mean, assume that it should create a key cycle, but that you can't just say that key cycle is from that because I didn't just use key cycles. I used the odometer mileage on top of it. So you have to have key cycle and odometer.
Right. Interestingly, though, when you testified on direct examination, you said your analysis, this was on Friday, before the weekend. By the way, over the weekend, did you watch anything on, I don't know, YouTube or any social media?
No.
Nothing.
No.
No. Did you have any conversations with Mr. Lally about these key cycles and the problems?
No.
Did you have any conversations with anybody about the issues with the key cycles?
No.
Did you realize at some point between Friday and today that I was probably going to ask you some questions about key cycles?
Objection.
Did you realize that yourself?
I assumed you were going to ask me loads of information.
So on Friday, you didn't mention that your analysis was based on mileage, did you?
Objection.
Sustained.
On Friday, did you mention that your analysis was predicated on mileage?
Objection.
I'll see you at sidebar.
I don't know. This is not beyond the scope of the redirect because, yes, he was specifically saying you would use the odometer, not the key cycle, because you would add the miles onto the key cycle and then it looks okay. That's what he said on redirect. Lovey's asking him if he watched YouTube. Hey, did you watch YouTube? Did you happen to notice those taillights? Yeah, it was completely off in yours, but then the one in the driveway, really super red. Did you happen to notice that? Did you have to get out there and say, no, 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 oh no, Maureen Hartnett had already taken the taillight off at that point. Yeah, you know, if that stuff had been recorded, we would know, wouldn't we? When all this stuff happened. Where's the timestamp on your video? Does it have metadata? Because the Sallyport does. The Sallyport has a timestamp. And we could just see that. This is about what he's doing, isn't it? He's just kind of making things up.
May I inquire?
Yes.
Trooper Paul, on Friday, you indicated pretty clearly that your analysis was based on the key cycles, starting at 1164 when you started your testing, and 1162, which was the key cycle you claimed on Friday was at 34 Fairview.
It wasn't based on it. That's how I describe it. I said key cycles. I based it on they were close within proximity to each other, but I've always said it's key cycles and odometer mileage, plus all the information within the triggers themselves. So it wasn't just one of the other.
And you said on Friday.
Yes, we know that.
Once you started your testing at 1164, it was 2 cycles earlier that had the triggering events, meaning 1162, that you claimed were at 34 Fairview.
Yes.
But in the hypothetical, if there were 4 events, 4 key cycle events between 1164 and 1159, it could not have occurred at 1162, correct? 34 Fairview, in my hypothetical.
In your hypothetical, if it recorded a key cycle, then your hypothetical is correct.
Right. And last question, if you got the route of travel incorrect, if your presumption of the route of travel was incorrect on that vehicle in the days earlier, then your mileage would be incorrect also, correct?
Mileage from what? The odometer or from?
The odometer reading.
The odometer reading is the odometer reading. It's 36.
My point is, your analysis that's based on the odometer reading, 36 miles here, 12 miles there, 2 miles here, 5 miles there. If you got the route of travel wrong and the route of travel was different, your assumptions about the odometer readings would be incorrect as well, correct?
So what I'm,
You got the path of travel wrong.
so what I'm, I purposely put down a range on my Google images showing, because I couldn't tell you her definitively route of path for every single way. But I know that it's possibly a possibility that she could travel 36 miles within those locations that she traveled post leaving
But not if she
Fairview
went to
Road.
34 Fairview the
Or
next morning, huh?
If that mileage was put on at key cycle 1162, and that would mean the vehicle would already be in Massachusetts State Police custody, right? Into the proctor's custody.
Objection.
So that's beyond the scope.
That's all I have.
All right, Mr. Lally?
Just very briefly. The range that you came up with for the defendant's path of travel, does that fit with the path of travel, the odometer reading, putting the defendant's vehicle in the area of 34 Fairview Road when it does the 3-point turn, and then 8 minutes later when it travels 24.2 miles per hour in a straight line in reverse for
What the hell
approximately
is that
62
question?
feet?
Objection, leading.
Yes.
Nothing further.
All right, you are all set, Trooper.
Thank you, Your Honor.
Nobody cared about that question or what he said. This guy's already done. He's done.
All right, so jurors, we're going to take another short break to set up some things in the court, okay?
All rise for the court, please.
Oh, I'm guessing we're getting the medical examiner. Setting up some things. Setting up some things because they don't want
Hey there, Karen
all
Reed,
of
trial.
us being able to see all that. That would be my guess. Just a possibility. I don't know. Maybe not. Maybe we'll get the cell extractions. Yeah, I mean, 1162 is at or after they're taking it off that tow truck. I mean, that at the bare minimum, 1164, they did the testing. 1163, they took it off the tow truck. You had to start the car to drive it off. 1162, you had to start the car to put it on. It could not have been 1162. At the bare minimum, that's when they put it on the truck. But that wouldn't add up with the odometer mileage either, would it? Because it didn't drive 36 miles to get on the truck. So it was already in police custody. That's his point. They put it on. They put it on there. Oh, guys, we are going to have such a spicy chat about civil rights cases. The civil rights case that Karen Reed is building up here. And that's why the Commonwealth is fighting so hard. Fighting so hard to get that conviction of something, anything at all. Anything at all. Because they got a big old problem with how this stuff is coming out here. They got a big old problem. Rainman YYC, kinematics in robotics is analysis of the geometry of motion without regard to the forces involved. Add in the forces equals kinetics. Makes sense to me. Makes sense to me. One is trigonometry and one is calculus. I mean, just sort of in very simple terms. Anton Ivanov, Alexis crashed into Trooper Paul at 135,000 miles an hour. I bet he hoped it did. You know, was he praying for that this weekend? maybe that could happen and keep him from having to get back on that stand. Charles Argo, 1269 miles. What about the 0.9 to the 0.1 of the odometer? This range difference could be 900 yards. Yeah, I mean, his best case scenario still had it at 36.1 miles, 36.1. And the odometer, would that, I don't know. I mean, we don't know if this chart rounds. I guess we're assuming it rounds. I didn't notice anywhere in the odometers on the chart that the odometer readings that it had the tenths of a mile recorded, but I wasn't looking. I didn't see. So could just be that it rounds to that last, whole number. But we don't know. That would be making an assumption. Deg, this guy doesn't know kinematics. He has no idea what field of study kinematics falls under. This is the root level of physics. This is the very base for which the entire field focuses on. How is he an expert? Welcome to science in courtrooms. Welcome to science in courtrooms. I'm feeling so seen right now and so validated that the whole world is seeing what we deal with every single day in courtrooms across the country with law enforcement officers who get up on the stand and tell you that they're experts and then just spout whatever they think. They took a class and now they're experts. It is Dunning-Kruger writ large. I mean, this guy, look up Dunning-Kruger in the dictionary. You will see this man. He's right there. Completely overestimating his ability to reach these types of conclusions based on that tiny, tiny, tiny little snippet of knowledge that he got from taking a class, which was basically what he learned. He learned Dr. Searle's equation. He learned the equivalent of how to run the calculator. He doesn't understand why. He doesn't understand why you use that equation or why that equation works. He doesn't understand any of the fundamental principles that go into developing an equation like that. That would give you a sense of, well, how would this equation then be modified by something like, I don't know, a side swipe, a different angle of incidence? Yeah. This is science in the courts, guys. If it seems shocking, then be shocked. This is system wide. This is how it goes. This is how it goes. And every day, we deal with that. Teresa Kaufman, I am so pleased with these questions. He is totally ignorant about fundamental principles of physics. Completely ignorant. Completely ignorant. Doesn't know the law of conservation of momentum. Extremely fundamental thing if you're going to be purporting to reconstruct accidents. And it's still blowing my mind that Lally, who put this man on the stand, has the absolute temerity to argue that the defense witnesses are unqualified. I can't wait for this voir dire tomorrow. I really can't, because we're going to get the preview. We're going to get the preview now of how none of what this guy said works at all, and how it's just, I mean, laughable. You want to talk laughable, Mr. Lally? Let's revisit that when we get to the people who understand this stuff, the people who get the physics, know the math, know how to do this stuff. I cannot wait for that preview. Hope and kindness. Think he may require a few sirens. Lol. Well, the memo didn't go out. The memo didn't go out. He was sitting there praying for him, trying to throw up, trying to throw up word salad to confuse him. Words. Maybe if I throw words in his face, he'll get distracted and he'll have to go after those, and he'll lose track of his point. Didn't get the sirens to help him out. Hope and kindness 1.1 equals, I don't know, maybe 3. I mean, it will be anything that it needs to be in this scenario. He made it absolutely clear. If it looks like 3, if it needs to be 3 to have it work that Karen hit John with the car, then it will be 3. He made that absolutely clear. Why are you looking at this key cycle? Because that's the one that it needs to be. Not because it makes sense for it to be that one. Not because it's impossible for miles to be added to the odometer after police get custody of the car and keep it in that conflicted Canton Police Department Sallyport, where there's already some peculiar stuff going on with that surveillance footage. Already some peculiar things going on there. Rainman YYC, silly troopers, get the accident reconstruction expert involved before and during the planting of evidence, not after. Sheesh. Well, this would be rule number 1, right? Incorporate that information into your fabrication of evidence. I mean, that would be the intelligent thing to do. The problem is, I don't know that this guy could have been an effective guide, right? He doesn't know. He wouldn't know what to tell them. I don't think he would know how to make it look real, right? So it doesn't matter. You might as well just go back after the fact and try to stitch it all together into something that sounds science-y. The linear path of the debris fields. He's trying to make it sound like he's trying to use these words to make it sound technical. Isn't that what Stephen Colbert calls it? Science-y. Super science-y, that testimony. Mike, probably regretting ticking Alan off last week. If he wasn't, he should have been a little bit more careful with that. Because, yeah, Alan Jackson really got his teeth in on that one. Hope and kindness, X marks the spot. Yeah, that's the problem with having your diagram scaled like that, is that we can actually now use that, and we can use that whether it helps you or hurts you. So yeah, those 50 foot markers on the X on the diagram. Yeah. We can now figure out 30 feet. 30 feet it would have had to throw him at a minimum. You know, that's assuming that the taillight piece at the fire hydrant literally just fell straight off. You know, everything else flew all the way up to the flagpole, some of it. But that one piece just fell right there. I mean, explain this to me. It's ridiculous. It's ridiculous. The taillight pieces would be clustered. They would be clustered in the same place. They would not be scattered all over, having gone in all of these different directions. Damaris San Giuliano, Joe Paul will need a mega pint after this secondhand embarrassment. Yeah, he's having a wet lunch today. I wonder if it's sunk in yet. I wonder if he's going home and watching YouTube. Is he going home and watching YouTube? Getting a feel for how this went over? He's probably sticking with court TV. Julie Grant's probably up there talking about how impressive he was. What a thorough job he did. Very scientific. Hope and Kindness completed the analysis at Kitty's Park while consuming magic mushrooms. I didn't quite hear what Jackson was getting at with the grand jury stuff. It sounded like he was saying at the grand jury, Trooper Paul was saying, well, there's math that can be done. I just haven't done it yet. I haven't finished my report yet, implying, well, I'll still do that. But then obviously he never did. I guess what he didn't think about before the grand jury. He didn't think about how his math wouldn't work if it's a sideswipe. That only occurred to him after the fact. Convenient. WM Penguin, this is unbearable. Can someone ping me in chat with the Twitter account of whoever was doing jury reactions? This must be gold. Yeah, somebody let us know. I don't know if Fall River Reporter is in there today. I would like to know that. I'm going to check real fast just to see. And I don't know, was it Sue O'Connell? Sue O'Connell is the other person that I think occasionally has stuff in. Oh yeah, Fall River Reporter is there. So I will be going back and following that thread at the end of the day. I got to see. What's the over? Who wants to set the over under on the face palms in the jury box? Who wants to set that? I'm leaning towards, I would set it at like 5 discrete times when one or more jurors was observed placing their head in their hands. What do you think? Over or under? What you got? Horror vibes. Can we swear in the crime scene, please? Oh, the story the crime scene would tell. The story the crime scene would tell. It's the entire city of Canton is the crime scene at this point, right? By their definition. It obviously included the Sally Port. Anton Ivanov, cue sad trombone sound. Wah, wah, wah. Something like that. Wah, wah, wah. It was bad. Yeah, very sad trombone. Britt Cormier, all these troopers answer AJ questions like a 4-year-old who have been caught with both hands in the cookie jar. What jar? Cookie? Trooper Proctor tell you to say that? No. I mean, yes. The sophistication of a 4-year-old child caught red-handed. No. Your hypothetical, it would be wrong. My hypothetical, wouldn't it be right? No. No, your hypothetical's wrong. I mean, just fighting the inevitable. And it just means it's going to go on longer. At some point, you throw in the towel. You just go ahead and throw in the towel. You don't keep taking the beating because you're going to suffer permanent damage. Kept taking his beating. So, went out on his shield like a man. We'll give him that. The problem is permanent damage. Is he going to take permanent damage from this? He might. I mean, this credibility is shot. Absolutely shot. Confirmation bias. Yeah, he's heard of that. Well, he's definitely heard of it now, and he's going to hear a lot about it after this. Yeah. Stephanie L. After this painful non-expert cosplay, I can see Bev move to dismissal. Would be a shame not to hear the defense case in chief, but maybe that's part of the plan to save the Commonwealth. Is this possible? So no, it's really not. I expect the defense will move for whatever they call it in Massachusetts. Sometimes it's a directed verdict. Sometimes it's just dismissal for insufficient evidence. It depends on, you know, how they look at this context. The defense will typically make that motion at the close of the state's case, even when you know it's not going to be granted, because you just do. I don't know. You just do. But it's not going to be granted. It's not going to be granted. And the reason why is because under the legal standard, you assume that what Trooper Paul had to say here was believable, that the jury could believe it and are entitled to believe it and rely on it and decide, yes, that is in fact what happened. He nailed it. He absolutely nailed what happened in this accident. The fact that it has zero credibility doesn't get factored into that legal analysis. That's what the jury is expected to take into account when they go into deliberations. So all they're looking at is, if we shut off our brains and accept all of these words as being true, is there enough evidence to convict her? Yeah, if you shut off your brain, there's enough evidence to convict her. So it's not going to be granted. Don't worry, we will get the defense case. Hope and kindness, vodka in the drink bottle. He wishes. I bet he hopes. I bet he hopes. I don't know, the way he was gulping away on it, he probably would have shown us a little bit more indication if that was the case. Andrew Nichols, don't you need to state the reason you're objecting? I have no idea why most of these objections were made or sustained. Judge Bev specifically told the parties at the pretrial hearing, don't state the basis, just say objection and I will rule on it or not. We've talked about why this is a whole bunch of times, and yes, it leaves things very ambiguous. We are here guessing. It's opaque. Even the lawyers on some of these are going, what? Not seeing it, not seeing why that's objectionable. She's doing it for a couple reasons. One, so she doesn't have to rule specifically on the objection that Mr. Lally states, right? If you state objection hearsay and it's not hearsay, but there's a foundation problem, you have to overrule that objection. So she's not holding the parties to stating the correct basis. She is just thinking to herself, is there anything in here that could possibly justify my ruling? Then the other side of this is when it goes up on appeal, she's not so limited. If there's any basis whatsoever that would support her ruling, it would be upheld. So yeah, it's not normal. Definitely not normal to do it this way. It's not a good record. Not, frankly, just even a good judicial practice, because she's inserting herself into the process. She's not ruling on what the objection is, but what she thinks the objection should be. And that's not how the adversarial process is supposed to work. The judge isn't supposed to be substituting their judgment for that of the parties. But the short answer, we're doing it because that's how she wants it done, and specifically instructed them that way. I know a guy, if the key cycle is 3 and ignition is 4, you always have to pass 3 to get to 4. Yes, exactly. There is never going to be an ignition cycle that is not also a key cycle. It's just you can turn your key to on, right? Turn on your air conditioning, turn on your stereo, without turning it all the way to ignition to turn your engine over. But you have to go through that cycle of powering the system, accessing the battery, using a key cycle in order to get all the way over to power the ignition. So an ignition cycle will always be a key cycle, but a key cycle is not necessarily an ignition cycle. This was not rocket science. Uncivil law. Do you believe in magic? Canton PD does. Yeah, they sure seem to believe in their ability to conjure up whatever they need to make Karen Reed guilty. Is magic constitutional? What's the leading case? I don't know. I guess it depends on if it shocks the conscience or not. Does it shock the conscience? There was that case about about the exorcism. Or remember the guy tried to defend himself on the grounds that he was possessed. He was possessed. That's about the closest thing I can remember. Court didn't let it in. Court didn't let that in. That's about the closest thing I remember. Can the defense call Harry Potter as an expert? He would not be less qualified than this guy, would he? He would not be less qualified. I mean, if you can't afford Hermione, you know, then you might as well get Harry. I mean, it's fine. Why not? Fedigator. But Mr. Jackson, math is hard. Yeah, it's complicated. I know. But that's what happens when you want to sit at the big kids table. If you want to sit at the big boy table, you got to do big boy things. So if you don't want to do the hard big boy things, go back to the kids table. If you're going to be more comfortable there. All right, looks like we are coming back up. Let's see what we got here.
See the close back.
All right, your next witness, please, Mr. Lally.
Yes, Your Honor. The Commonwealth call Mr. Ian Whiffen to the stand.
Okay.
Oh, the Celebrate guy.
And Mr. Lally, you just need to tell me when I need to give that instruction.
Yes, sir.
Oh, there's going to be a special instruction now.
Okay.
So we got to go back to cell phone data.
Step right up. Step for me. May stand and face the clerk.
Just raise your right hand, please. Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God?
So I'd rather with that.
Okay. Do you solemnly affirm that the testimony you shall
No,
give to the
God,
court
he
in the
just
matter now
disclaimed
hearing shall be
God.
the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning.
Good morning.
That makes him look super sciencey, I guess.
Whenever you're ready, Mr. Lally.
Good afternoon, sir.
Good afternoon.
And if it's at all helpful, that microphone before you is adjustable. You can put it in any direction you wish. Just try to keep your voice up, okay, sir?
Thank you.
Now, sir, could you please state your name and spell your last name for the jury?
Yes, it's Ian Whiffen. So IANWHIFFIN.
And what is it that you do for work, sir?
I'm currently the decoding product manager at Cellbrite.
And what is Cellphone?
Cellbrite is one of the world leaders in mobile forensics software.
And when you say forensic software, can you explain to the jury a little bit about sort of what is forensic software and how is it used, specifically your Cellphone?
Yes, so forensic software is used to gain access to people's devices, cell phones primarily, to extract that data and to allow examiners to parse and decode that data to make sense of it in a more user-friendly way so that a report can be created for investigators.
Now, sir, if I could ask you just a few questions going back to some of your educational and prior work experience with regard, starting sort of with your undergraduate work, what, if any, where did you go to school and what, if any, degree did you receive there?
Okay, I didn't get a degree. I'm originally from the UK, where I did qualifications in computing, a higher national certificate in computing, and then joined the police in 2004.
And what department was that, sir?
That was response work. So South Yorkshire Police as a response officer.
And where did you go from there?
In 2009, I immigrated to Canada, where I was able to continue policing with the Calgary Police Service, where I spent approximately 4 or 5 years, again, working patrol before moving to the digital forensics team of Calgary Police.
And with respect to moving to that digital forensics team, what, if any, specialized training did you receive in regard to that area?
So once I had made it into the digital forensics, I was sent to Ottawa for 3 weeks to do a foundational computer forensics course, covering all manner of digital forensics to begin with. Throughout my 8 years with Calgary Police, I did constant courses each year to keep information updated, including a 2-week course, again, at the Canadian Police College in Ottawa, specifically about cell phone forensics.
And then also during that time, additional courses for extracting data for interpreting internet artifacts or any other kind of information found on a phone or computer.
And following that, where did you go from there, sir?
In 2020, I left Calgary Police Service and began working at Cellbright as the senior digital intelligence expert, where I would use my knowledge of the forensic community to assist the developers with creating and maintaining a program that examiners would want to use. And finally, about 2 years ago, I moved to the decoding product manager position.
And can you explain to the jury sort of what it is, what your role is, and what is it that you do for Cellphone?
Yep, so right now in the position that I'm in, again, I use my knowledge of the digital forensics landscape in the community. I talk with users about their daily challenges, what applications are causing them problems, what they need to get access to, what they need to understand. And I take that information, create a priority list, and then determine with our developers what we will tackle, how we will tackle it, and how it will appear to the end user.
Now, with regard to your education in this area, what, if any, certifications do you have?
No specific certifications. I've done the Cellbright coursework since joining Cellbright.
So he took some classes.
But other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa,
So he's not
I don't have
actually
the
the
SANS training
developer.
or any of that
He just
kind
talks
of
to developers.
training certifications.
And in addition to your work with Cellbright, what, if any, other areas of the field have you
So
worked?
he's not going to know anything
I'm
except
sorry,
what he's
could you
told
rephrase that?
by developers.
Have you given any presentations? Have you published any work in relation to this area?
Yes. So since working as an examiner, I identified that there were times that I needed to parse artifacts from applications that the main vendors didn't support. In response to that, I would do my own research. That research turned into a selection of digital forensics tools, and I created a website for myself to share that research, to share those tools with the community. And directly related to that, I have published articles related to accessing data on phones, related to SQL databases, related to various other artifacts, primarily locations.
Over the course of your work, have you had occasion to testify in other courts in relation to this specific field?
Yes, related to digital forensics, I've testified approximately 20 times, mainly in Canada, but also once in Michigan, once in Australia, once in the UK.
Now, as far as
So
questions
this is your
that come
second time in the
into,
U.S.?
Come into your company with relation to interpretation of data, other sort of general forensic questions. What parts of the world do these questions come in from, and how widely used is your product?
So the product is used globally. There are a select number of countries that we don't export to, but generally, if a police service is interested in digital forensics, then they're using at least some of our tools. We operate an email address which is open to any user called Stumpers. And the idea is that users, if they come across a artifact that they can't explain, they can email to myself and some of my colleagues, and we can research that artifact, and we can try and give them an answer as to say why the artifact's there and how it should be interpreted.
You used the term in there as far as an artifact. If you could please explain to the jury sort of what your understanding of that term is and how it's used within your specific industry.
Yeah, so I would refer to an artifact as essentially any piece of data which I've recovered from the phone, which is of interest. It could be a web history visit. It could be a text message. It could be a photograph, any piece of information.
Now, sir, turning your attention to September of 2023, at some point in that month, were you contacted by the Norfolk District Attorney's Office and the State Police in regard to this case?
Eventually, yes. Initially, I was contacted by a member of Cellbright.
And if you know why was that initial, as far as the initial contact or initial request from Cellbright, Can you speak about that?
Because you're the
My
service
understanding
guy
was there was an
for the
artifact
sales.
found on a device, and people were looking for an explanation as to how this particular timestamp was relevant to the case.
Now, if you could explain to the jury sort of what were you provided and what were you asked to look at?
So the original question is just basically how can we explain this 227 timestamp? I spoke to my colleague and
How can we
requested
explain it?
if he could contact the investigators and any information that they could share about where this particular timestamp was found so that I could investigate it. I was advised at that time that the case had already been uploaded to our own support network. So the full extraction of the device in question was already in Cellbright's possession. And I was able to access it from there and start to examine what the issue was that was causing the confusion.
Now, with reference to this issue, can you describe to the jury, just in general terms, sort of what this issue was?
Yes, so the issue, as I was led to believe, is there was a timestamp for a web history artifact of 2:27 and 40 seconds AM local time, which would be UTC-5, and it didn't make sense to the investigators. And the question was, is there any other interpretation for what this timestamp could mean?
And so essentially you were asked to explain the timestamp and how it came to be, correct?
Correct.
And as far as this particular issue, has this arisen in other instances? Have you been asked the same question or similar questions in regard to this type of artifact?
Yeah, several weeks later, so probably around December time last year, I was contacted by a police investigator in Austria with a very similar question, but related to obviously a different internet search. And about a week later, the defense expert in the same case also contacted me asking the same question. The defense expert in that case was able to provide the database, and I was able to provide the answer.
Now, as far as the full extraction, is that the entirety of what you looked at in this instance, or what, if anything else, were you provided with in regard to your review and your analysis in this case?
So I did work with the full extraction, but my interest was focused on just the web history artifacts.
And what, if anything, did you find with regard to the web history artifact?
So the 2:27:40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record, but the interesting thing was why the timestamp said 2:27:40. And I did some testing on this and discovered the reason why 2:27:40 was actually listed in the database, even though that's not the time, in my opinion, that the search was conducted.
And what is your opinion as to when the search was conducted?
There's plenty of other evidence on that extraction that shows what activity was occurring at 2:27 and 40 seconds. And there's plenty of evidence later on in the day that shows that that particular search was conducted at 6:23, I believe 51 seconds, and then a similar search at 6:24 and 18 seconds, I believe.
And before we get to that, Your Honor, may I approach?
Yes.
It's cumulative. I mean, could have
Wait, I'm showing you
objected.
the document actually.
So I really
Thank
don't
you.
know why. Just really making this point about Hoss long to die in cold.
Yes,
Do you recognize that, sir?
I do, yes.
What do you recognize that to be?
This was the internet history, the history.db database table showing activity from the morning of the 29th of January 2022.
May I approach again, Your Honor?
Yes.
I'll seek to introduce the next exhibit.
No objection.
Okay.
It's 14.
Now, may I return to the witness?
Yes.
Your Honor, if I may, with court permission to republish it from the jury.
Yes.
Or may I approach this to retrieve?
Yes.
No, it's my fault.
Thank you.
Now, Mr. Whitman, do you recognize what's up on the screen now as the exhibit you have before you?
I do, yes.
And Ms. Whitman, there should be a laser pointer on the desk next to you. What I'm going to ask you to do is, if you could, using that laser pointer, explain to the jury what we're looking at in this exhibit and what, if anything, of significance you observe within this exhibit.
Okay, of course. So this was a table I created based on the data from the phone. The first column shows the local time of a record that was written to the history database. This is a database which is tracking all web pages which are loaded as you use them.
So this is happening at
The second column starts with the
12:42
URL, so the Uniform Resource Locator.
AM?
So what you would type in, or how the browser knows which website you want to visit. The title is part of the website which is loaded. One of the top attributes of the website will load the title. Visit count relates to an internal counter within Safari, which just tracks how many times a particular website's visited in order to make suggestions to you down the road. And then finally, the last column shows the source of this information. So history.db is the name of the database.
He specifically said it's
History
local
underscore
time.
visits is the name of the table. And then the number is the unique identifier, which is assigned to that particular record in consecutive order. So every time you add a
Which
new
the
record,
-5
that
is
number will increase by
UTC.
1.
Hey, Mr. Whitman, probably a couple of foundational questions that I should have asked you first. My apologies. With respect to the cell phone extraction that you were provided, that was from a individual named Jennifer McCabe, is that correct?
That's my understanding, yes.
And fair to say you don't know Jennifer McCabe, never met her, don't know anything about her?
Correct.
And as far as a extraction is concerned, if you could please explain to the jury sort of what your understanding of that is. What is an extraction?
An extraction in this case, all of the files and folders had been extracted from the device, saved on a computer in a zip file container. So essentially in a way that is as close to the original from the device as possible.
And again, what is your title specifically with Cellbright?
It's decoding product manager at the moment.
And so what, if any, relation does what you do have with relation to an extraction and how that's, what's sort of the relationship between what you do and a Cellbright extraction?
Okay. So once the extraction's been extracted and we have the zip file, then Physical Analyzer is the tool that Cellbright creates to allow examiners to look at that extracted data in a meaningful way. And my role is somewhat shaping how examiners will see that data when they open up Physical Analyzer and look at the extracted data.
And how does your role play into that? What is it that you do what, if any, relationship does what you do have to do with how examiners will view something from the Cellbright tool?
Again, so after being an examiner for 10 or 11 years, I've got that kind of understanding of how examiners work. Being someone who also writes my own software and does my own research, then I can kind of cross that void that usually exists between developers and examiners and help both parties try to come to
The water was
a meaningful
cold,
conclusion.
Kyle. Ms. Gilman, if you could shrink that just a little.
Shrinkage.
Now, again, Mr. Whitman, if you could, using that laser pointer, direct the jury's attention to what, if anything, of significance you observed depicted in this particular case.
Yeah, so the lower two
Okay, so yeah, she
records,
was
which
searching
highlighted
this
in
at
green,
Fairview.
are two records which occurred at 2:27
While
and 42
she's
seconds local time. So
texting
2
and calling
seconds
John?
after the Google search had allegedly been made. And then the second record is 5 seconds after that at 2:27:47 seconds. Both those URLs relate to a website of hokamocksports.com.
Okay. If you could explain to the jury, what is a contiguous identifier?
So again, every SQLite database will assign a unique contiguous identifier number. So
then
again,
it's
the
got
very
the
first record
1033.
created will be given a record ID of 1, the second record will be 2, and so on
Where's
and so
Hoslong to
forth.
Diane Cold?
Those numbers are never reused. So if I was to delete record 3, that record number will never be reused, and I can see that there's a gap and deleted data in that database.
You used another term in there as far as the SQLite database. If you could explain to the jury what your understanding of that term is based on your training.
Yeah, a SQLite database, essentially, it's a series of tables. It's a way for data to be stored, again, in a meaningful, organized fashion that can be queried, can be examined, can be filtered, searched, etc. It can be useful for anybody who wants to get data from an organized file.
Now, with reference to the searches that you observed within this particular web history, what, if any, relationship did the contiguous identifiers, sort of the range, what if anything, did that tell you?
I'm sorry, can you rephrase that?
What, if any, observations did you make as far as those contiguous identifiers in the range they had in relation to the web history that you observed?
Okay, so within the history.db file, there were no missing numbers from the beginning of January, essentially, until early February. That told me as an examiner that no records have been deleted during that time.
Then where's Hoslong to Diane Cold?
May I approach again, Your Honor?
Yes.
It wasn't on your sheet with your contiguous numbers.
So if I could ask.
That one back.
Do
Thank you.
recognize that, sir?
I do, yes.
What do you recognize that to?
This is the browser state record, which identified a search at 2:27:40 a.m.
May I approach again, Your Honor?
Yes.
Almost. We have no objection.
Okay.
So we're getting Yannetti for this one.
Thank you.
Yannetti did the last one too.
Yes.
Position may be published to the jury.
Yes.
Jessica Hyde. Yannetti handled her.
Counselor, directing your attention to the screen, is that what you have before you as the next exhibit?
It is, yes.
And if you could explain to the jury what we're looking at in this exhibit, and what, if any, information you're able to sort of glean as a forensic examiner with relation.
Okay. So this is a searched item exhibit. It's technically a derivative of a different exhibit that we find on the device. So we found what we consider a web history record. So a web history record would just mean we have a URL that was visited and potentially a timestamp and a title. Searched items looks at all of the web history items that we've found and tries to identify were these actually searches that were conducted. So for example, if you were to do a search on Google, you'd see that the website that you're taken to is google.com query, and then it contains the query string that you've typed in. We extract that information, we extract that query and provide it to the user as a searched item. In this case, I can see that it came from the browser state.db WAL file. The search query itself was Hoslong to Diane Cold, and it shows as a deleted record.
Now, with respect, I think you've used a couple of different terms within that as far as a knowledge C database. Can you explain to the jury what that is?
I don't recall saying knowledge C, but I can explain what knowledge C is in this case. Yes, the knowledge C database is at the heart of iOS. It stores lots of information about the activity on the device at any given time. Things like when the backlight's turned on, when the device is unlocked, what application is in focus at the time and how long it's in focus for. And important to this case, which website's on screen at any given time as well.
When you say when a website is in focus, can you expound upon that as far as what exactly do you mean by when you say in focus?
So in terms of iOS itself, when it's in focus, it would be the primary item that's visible on screen. So with iOS, you can have applications in the background that you aren't using, but the one that you are currently using is considered in focus, taking up the entire screen.
I believe you had used the term as far as a browser state DB, is that correct?
Correct.
And can you explain to the jury what your understanding of that term is and how it relates to it?
Browser state DB is just the name of the database, the name that Apple gave it. It's gone through some changes over the last few years. For example, in iOS 14, it did store the state of the tabs that were open within a browser. In iOS 15, there was a significant change, and the only time that records were written to the database is when the tab was closed. So a significant difference in that it doesn't show you what's currently open, it only shows you what's previously been closed.
Now, this search here, what, if anything, did you observe as far as this record in relation to the history DB related to the search?
This record is not mentioned at all within the history.db database.
And what, if any, missing records from this time frame did you observe either?
There were no missing records in the history.db database. Within this time frame, within the browser state database, there were 3 deleted records.
When you say deleted records, as far as your self-rights tool is concerned,
So if it wasn't in the history,
what exactly does deleted mean?
how did it happen?
These are records that have been deleted, not necessarily by the user, potentially by the system, but they are considered deleted records that we're able to recover.
What are some of the ways that something might be deleted by the system, and which are you talking about, the phone, or are you talking about your tool?
The phone. Right. Our tool is designed as a forensic tool. It's not going to edit, delete, or affect the data in any way. Just present what is in the extraction. But there are multiple times on an iOS device or an Android device where cleanup essentially happens, and we start to lose data after a certain amount of time.
Now, with respect, let me just ask this for a moment. With respect to Cellphone, as far as the tools, have there been a variety of different versions of those tools as far as conducting that forensic extraction?
Yes. So Cellphone Physical Analyzer has been available for approximately 12, 13 years in various versions.
And what, if any, differences are there between, in general terms, between, say, an old version versus a newer version?
Obviously, in the digital forensics landscape, whenever a provider creates a new feature, we have to change our code to adapt to what they've now introduced. There can be research that's been done, so we now learn new things, and we add support over time. So something can be supported in this new version of Physical Analyzer that may not have been supported or even existed in a previous version.
Now, with respect to your work in this field, what, if any, tools have you designed and or created or something to conduct this type of work?
Aside from Physical Analyzer?
Yes.
Okay, so I have my own tool called Artex, which I've been working on for around 5 years. Since being an examiner myself and struggling to parse any particular application that I needed. So I started to write my own tools, and that's the one that is one that I still maintain on the side in my own time, partly for my own knowledge, but partly because I think it still introduces some fantastic features which aren't available in any other tool for research purposes.
Sell it.
So
Sell
yeah,
it, Mr.
I
Whiffen.
continue to write this tool to this day.
And could you just say the name of the tool?
Artex. A-R-T-E-X.
Thanks.
Thank you.
Now, with regard to the situation depicted in the exhibit up on the screen, what are some of the reasons why this may occur, or why this may read as it does?
Sorry, is it deleted?
Yes.
Oh. The record itself has been deleted. As I said, the reason why it's deleted, through my testing, I've only found 2 ways that kind of record can be deleted by the user. And I don't believe either of those ways was actually utilized on this device.
And what are those two ways?
The user has the option to selectively delete history items. So you can delete either one at a time, or the entire day's content, or the last 2 days' content. Or you can delete all content altogether. If all content had been deleted, we wouldn't have found any information on this phone at all related to web history, so I was able to discount that one quite quickly.
And I guess,
How did you
moving to what
discount
just said,
selective?
why is it that you don't believe that either of those two methods of user deletion?
Because
occurred
you
in this
still
context?
have numbers.
I'm sorry?
You have the unique identifiers with none missing, but you have no Hosslong to die in cold in the history database. So how do you account for that? This guy is impeaching Jessica Hyde. I walked away from Jessica Hyde thinking, yeah, I buy her explanation. It makes sense to me. This guy is is calling that into question for me. He showed us. He showed us the list. The history.db database shows the websites you visited. If she did that search at 623 and 624, shouldn't they be on there? I mean, maybe he's going to get to it. I don't know. But they should surely be there, right? On the history, unless it was selectively deleted. Yeah, now I'm not sure what I'm supposed to believe. Just more Lally here undermining his own case. I mean, he had me with Jessica. I was buying it. Gonna have to wait for the defense to come and you know, see what they have, see how they explain it. But now he puts this guy on, and now I'm really not so sure anymore. Now it sounds like she selectively deleted it because it should be in the history database. I sure hope we're going to get this from Google. We know they got Google.
Can I have one moment, John?
Sure.
Just don't know if Google is going to be location data only, or is it going to be this? I don't know.
Mr. Webb, moving on from that for a moment, may I approach the witness, John?
Yes.
Thank you.
That document I've just handed you, Mr. Whippen, you recognize that?
I do, yes.
And what do you recognize that?
It's a document that highlights both the search terms that were found in mobile safari.plist and the method of searching.
I approach again, Your Honor.
Yes.
Commonwealth seeks to introduce the minutes of the next exhibit. No objection.
Okay. Thank you.
May I return to the witness? Yes. Of course, Commissioner, may we publish it to the jury?
Okay.
The internet history searched from the 227 stuff to 10
Mr.
something
Whippen,
in the
you
morning.
recognize what's up on the screen as the next
Why
exhibit?
did it do that?
I do, yes.
You did use a term in there, I believe, called a key list, is that correct?
Correct.
Can you explain to the jury what you understand that term to mean and how it relates to what you're about to talk about up on the screen?
Yes, so a P list or a property list is Apple's way of storing serialized data. That essentially means a list of data with names and values.
And, sir, if you could, again, using that laser pointer, direct the jury's attention to explain sort of what we're looking at and what, if anything, is significant.
So those are UTCs. So you take away 5 and you get
Yeah,
624
so
and
again, this is
623.
a table I created from
I
the
get
data within the mobile Safari.p list.
But why isn't it in the history?
The term shown down the left is what the user would have typed in to the search bar. Sorry, I keep blinding somebody. The search bar in the bottom of the Safari browser window. The UTC time is the time which is actually recorded within the P list. It's recorded as a string, so just text as it's presented on the screen there. And then I converted that and subtracted 5 hours to bring it into local time around Canton.
Now, aside from this just for a moment, with regard to, you're familiar with what's termed as a private browsing mode?
Yes.
And can you explain to the jury what that is and how it relates to this?
Yeah, so private browsing mode is a setting that you can set on iOS devices, or primarily most devices, that prevents any of your browsing activity being recorded. So it won't save the searches, it won't save the navigations, it protects everything so that it can't be found later on.
And what, if any, relation did that have to what your analysis of the distraction in this case?
If these searches had been conducted while in private browsing mode, these searches would not exist within this file.
So is it your opinion that they were not conducted in any kind of private browsing mode?
Correct.
Now, you also familiar with the term as far as failure to load?
Yes.
Can you explain that to the jury and how that applies to this?
Yes, so obviously whenever you try to visit a web page, there's a stream of information coming from the web to the device, which then renders onto the screen. At the completion of the load event, there's a function effectively which runs, and that records the visit to the history database. If for some reason the page doesn't load and it shows up with an unable to load message, so for example, you don't have an internet connection at all, that unable to load will be recorded. If, however, the device stalls and it just sits kind of waiting to load, nothing gets written to the history database. And if you were to close the browsing window prior to the page completing its load event, nothing will be written to history.
Would that be written to somewhere else within the phone as far as any other storage areas?
Technically, the only place I found would be the browser state.
Now, with regard to the plist files, does this file save all sort of history items or not?
Primarily, it's used to save preferences. So you'd have a lot of information in there if it's using light mode or dark mode, or when you want tabs to auto clear, that kind of information. But it also records several days history of searches. The actual number of days searches, I actually don't know.
And what, if any, relationship does that have with regard to the search bar that's located on the bottom of this table?
In order for the search item to be saved to the mobile Safari P list, you need to actually type into this particular search bar. If you were to just visit google.com and start typing into the Google search bar, it will not be recorded within the mobile Safari.p list.
And so what, if anything, were you able to determine about those two searches with regards to what you observed?
So in these particular two searches were conducted at 6:23:51 and 6:24:18 respectively. They were searched using the search bar that's built into Safari. The fact that they didn't exist within HistoryDB and that there were no deleted records from history.db leads me to believe that they never successfully loaded.
May I approach again, Your Honor?
Yes.
So how do you explain the tab then? It would have recorded that failure to load you just said. If she opened a new tab, then that's not the browser state explanation that Jessica Hyde gave us. This is not adding up.
That new document that I just handed you, do you recognize that?
I do, yes.
What do you recognize that?
This was the additional, the items from the history.db, I believe.
May I approach, Your Honor?
Yes.
I'll proceed to introduce and admit as the next exhibit.
Okay.
Okay. Could you bring it?
That's what I'm seeing. I don't know. I don't know why we're doing this. I don't know why Lally is doing this. He's got a different explanation that she did. I do not get what is going on here, because I came in to this testimony thinking very satisfied with Jessica Hyde's explanation. Granted that I know we're going to hear from the defense. And I also understand, you know, limited scope. She was set to look at a very specific thing, but I also appreciate this is the things that they're concerned about. They're not interested in like her entire call history and, you know, everything she ever searched at any time and so forth. I didn't really have a major problem with that. Especially if she was to tell us, well, there was a gap in there, you know, because of my limited scope, there was something that I could have looked at, but I didn't have access to. But there wasn't anything like that. She said she was able to reconstruct this explanation. But now her explanation is different from this guy's explanation. I don't know what Lally is doing here.
Sure. May I return to the witness?
Yes.
I'm sorry, Mr. Whitman, if you could just repeat exactly what that is in the next exhibit.
Yeah, sorry, it's a comparison between the search terms found in the P list, so the mobile Safari P list, and the search terms found within the history.db database.
So the items contained within this table are items that were contained within the extraction that you examined, correct?
Correct.
And Your Honor, with court submission, if I could display that for the jury.
Yes. Yes.
And Mr. Whitman, if you could, again, using the laser pointer, just describe to the jury what we're looking at in this table and what, if anything, is significant between sort of the two sources of information.
She Googles herself.
Okay, so the first list, the P list term, shows the term within the mobile Safari.p list, excluding the two that we've already mentioned, which are of note. And the first timestamp column shows the timestamp according to that P list. The history item shows the search term as recorded in the history database. And then we have the timestamp as per the history database. So the purpose of this document was to show that we have a search for reigning men and a history item related to the Google search for reigning men, and they show within a second of each other. Again, the next one down, Antoinette Ock and basketball, and the associated Google search. And again, the timestamps are within a second. This list was non-exhaustive. There was hundreds of examples within the history.db, but limited examples within the mobile Safari P list. And as I mentioned, the two searches of interest, the how long to die in the Kikti and how long to die in the cold, didn't exist within the history DB at all.
Mr. Gilman, you can take that.
This does not make sense.
Now, sir, if I could ask you just a little bit now about the browser state DB. Again, can you explain to the jury sort of what that is and how it, if at all, it plays a role?
So where are those searches
analysis
in the P list?
Yep. So initially, pre and including iOS 14, the browser state database would show all tabs that you currently had opened. So as soon as I go into my browser and open a new tab, a record is created. It includes information such as the time that I opened the tab or the time I last viewed the tab, the current URL which is being displayed within that tab, it shows information whether it's in private browsing mode or not. So in that kind of case, in iOS 14 and below, we're able to see current private browsing records and subsequently recover deleted ones.
So not that private.
But in
Take
iOS
note,
15,
everybody.
things changed. The record was no longer written as soon as the tab was opened. It was only opened when the tab was closed. The record was only created when the tab was closed. That meant that our ability to recover that kind of history was significantly lower. It means that it no longer makes use of the private browsing field, because now private browsing records simply are never written to that database. So now we can only really see a list of all of the tabs that have been closed, not which are currently open.
Now, with regard to the browser state DB, is there something referred to as a last view timestamp?
There is, yes. That's one of the fields within the database.
And can you explain specifically with relation to that field, sort of what kind of information is kept there and what it means?
Yes, so from my research based on this, that timestamp relates to the time that the tab took focus. So that's either when the user creates the brand new tab, when they switch between tabs and bring a tab back into focus, when they close a tab, which automatically brings one of the background tabs into focus, or if Safari has been completely closed and reopened, that essentially acts like almost a new tab, and the timestamp gets updated at that point.
Can you explain how an earlier timestamp could be associated from, say, tab is open, something is done, tab is closed, tab is reopened, something else is done, how that earlier timestamp could then be associated data-wise with the subsequent search?
I think
opening it.
I think I followed that. Okay, so if, for example, at 12 p.m. I create a new tab, I can do a search for whatever I want, and at that point, if I close the tab, then the record that gets created will show that I opened a tab at 12 p.m. and I did a search. Excuse me. However, if I open the same tab at 12 p.m., do a search, close it, like completely close down Safari and reopen Safari, that would also update the same timestamp to show that I'd opened it up again. What I meant to say at that point is that if I create a 12 o'clock tab, minimize Safari, I can leave it for several hours, for several days, for several weeks. The time difference is not really important. When I come back to it and open up Safari again from a background state, the timestamp is not updated. So it will still show 12 p.m. today, and it will show whatever my most recent navigational event is. So I can search for something in 3 weeks' time using the same tab I opened today, and the timestamp will show today's time.
All right. I think
In
this is a
which
good place to take our
database?
break.
Yes,
Because are we talking about the 623 and 624 now?
You can file it behind.
Yeah, thank you.
Board, all rise for the jury.
This is a big mess. Lally,
And could I see counsel regarding timing, please?
yes.
Lally, it's literally your job to tell me which one of these people I'm supposed to believe. You're supposed to tell me which theory is right here, because you've given me now different explanations for why this Haas long to die in cold artifact exists associated with 2:27 a.m. And it's not in the history database. That doesn't make any sense. It doesn't exist in the history database, but she didn't delete it? Well then, how did she search it? And it wasn't in the P list? So how did she search it? It just randomly showed up in this wall file? How did it even get there to end up on this browser state history? database. I don't get it, guys. I don't get it at all. I was buying it. And now, I don't know what I'm supposed to believe. Mr. Lally is not, he's not doing his job here of telling me what I'm supposed to believe. Is he going to ask this guy? Do you agree with Ms. Hyde? Are you saying essentially the same thing as Ms. Hyde? If not, why not? I don't get it at all. I'm kind of now just in the ballpark of everybody who is saying, yeah, you just got to go server side on this. Yeah. I mean, that makes a lot more sense to me at this point. If the phone itself is this buggy and this confusing, and these two experts can't agree on what the phone data is supposed to mean, maybe we should just go to the Google server and see when these searches were run. So did the Commonwealth ever do that? Did they? I don't know. It's the defense that's got Google on their list. I have no idea if the Google witness relates to search history or not. I have no idea. I'm aware that there was stuff going on pre-trial with preservation requests sent to Google for geofence data for 34 Fairview. I just kind of caught up on that over the weekend. Not something that I had been aware of before. So apparently the defense had made this request for the 48-hour period of January 28th and January 29th, preserve all of the geofence data. The way that it had written, apparently, that it was written, however, by Michael Proctor, apparently would have excluded all Apple phones. It would have only applied to Android phones. So then there was a bit of a scramble to get that corrected and sent back off to Google. Make sure you're preserving Apple information as well. So I know that they were looking at geofence data with Google, but I don't know how that panned out.
You are unmuted.
Court, all rise. Court stands in recess. Lunch and recess, 1:40.
I didn't hear her say how long we're taking. Did she tell us? Are we taking 45 minutes, taking a full hour? I don't know. I didn't catch it. If anybody saw that, let me know. Yeah, so everybody in the chat who's like, I'm lost, we're all lost now. And literally the Commonwealth's job to unlose us, to get us out of the weeds and back on the path. And here they are, just dragging us into the deepest, murkiest. This case is the Darien Gap. Okay. The most impossible to navigate area of the world. We don't know. We can't find our way through here. What are you doing? What are you doing dumping us off in the Darien Gap? Apparently somebody has driven across the Darien Gap. It took them like 2 Range Rovers and I think about a year. Anyway. So the bailiff said it ends at 1:40. So that means we're getting about a 40-minute lunch. Okay. Well, I'll get through some of your comments before I am going to do my pause and break and check the chickens and the trees and everybody. But let's see what you guys are making of all this. I know we still got some stuff to catch up on with Trooper Paul. Horror Vibe 666. Nobody said there would be math involved, Trooper Paul. I didn't know there would be math involved when I signed on to, do applied physics. This is applied physics. Didn't cross his mind. Quite frankly, Samantha Teresa, Andrea, I don't understand how he could be considered an expert, but when pressed about the calculations, Beverly sustained the questioning under Lally's objection. Why? The only possible rationale I could see for these being sustained is that she considers them argumentative. The whole problem, though, is, again, this is cross-examination. You're allowed to lead, you're allowed to put words in their mouth, and they can accept that or reject it. That's the nature of cross-examination. So it's always a bit inherently argumentative because you are putting your theory of the case to him and asking him to explain it. But it just seems like she's kind of using it as this catch-all for any question I don't like, I'll sustain, and then she makes him rephrase it as a non-leading question, which is not required on cross. That's not required. So I don't know how to explain what her thinking is here. This is part of the problem with the rulings being so opaque. The basis for the objections being opaque, the reasoning behind them, it's entirely unclear. We don't know if they're even all thinking the same thing or if they're all three of them. You know, the prosecution, the defense, and the judge all have three entirely different things in mind when they're evaluating, you know, is this objectionable or not? It just gets worse and worse the more that this goes on because it's so unclear and just not particularly consistent. Arla 7247, frustration, Paul, greater than or less than Jackson. I think Paul was the one who was finding himself. He was the one flopping on that hook. Couldn't get that hook. That must have been a quite frustrating feeling. And Jackson, you know, he wasn't having the easiest time reeling him in, but he can feel him on that line. He knows got him. He knows he's got him. I'm giving that one to Trooper Paul. Won the frustration Olympics there. Nunzio, I almost feel sorry for Trooper Paul. Almost. Look, this is you want to rumble? You want to get in the ring? You want to get in the ring, you're going to get hit. So you better be ready for that. You're going to take some hits. Nobody is going to get in the ring and never get hit. You're going to get hit. He got hit. He got what he was asking for today. Marcelo Frias, his testimony hurts my soul as an engineer student. It's got to be on a whole next level for those of you who have some expertise in this stuff. I don't have expertise in this stuff at all. I mean, like I said, last time I took a physics class was in like 8th grade, you know, very basic stuff. We did learn Newton's laws though. So yeah, I mean, it must just make you die a little bit inside, to see this guy posturing as doing what you're doing. It's probably similar to how I feel when I see like a sovereign citizen brief. I imagine that those are kind of the equivalent types of situations there. D. Pat, please make a Looney Tunes reenactment defense. Lol. That would be fun, wouldn't it? Go ahead and give us a Roadrunner and Wile E. Coyote reconstruction of how exactly John was hit by the car. I mean, we might as well at this point. It's already enough of a joke. Czar Nick 2. He reminds me of Private First Class Downey from A Few Good Men, well-meaning and not too bright, just follows what people tell him. Yeah, he's just on the team. He's just on the team to do what he's told and to try to support the people who have more important jobs than him. You know, I don't know that he's necessarily the water boy on the bench, but he's, you know, he's like the third string. Not very bright, really not equipped for this job that he was handed. But if they never thought it was going to get to this point because they thought she was going to plead out, then anybody was good enough. Then it doesn't matter. All you need is somebody who's willing to suit up, you know, and be on the field. Hope and Kindness, live shark attack. Oof, blood in the water. Blood in the water. John Beatty Bot might be able to nest ignition cycles within key. Maybe, yeah, if you don't power it all the way off, you leave it on, you leave your lights on, you leave your defroster on, whatever, but you turn off the ignition and then turn the ignition back on. I don't know. maybe. Horror Vibe 666. Commonwealth case has been 10 times longer than Paul's courses. Yeah. Yeah. Good point. Good point. What are we at here? Week 8? Are we on week 8? It's something like that. And we are none the wiser about what happened to John O'Keefe. MeFlower66. I missed Bev's ruling on Paul as an expert for hitting J.O.'s car, assuming she rejected him, correct? No, it seemed like she let whatever he had said on Friday stand. And Lally started by just revisiting his experience and what, you know, why he would think that, because what are the kinds of things he would look for? He would be looking for paint transfer, scrapes, things like that. So I think what happened is, you know, it got elicited on Friday and it got challenged and they went to sidebar and basically they were asking to strike it. So let me see if I can go back to my notes from Friday's testimony. They just showed the ring video. Yeah, what I'm showing is just that they showed the ring video and then stopped and went to the voir dire. So it seemed like they didn't let him get to that actual ultimate conclusion, not consistent with the taillight, but then they just kind of backdoored it in anyway on redirect. What were the first things that he said on today? He's had investigated 191 crashes, including vehicles contacting each other, and there's contact damage and induced contact, and it's possible to have paint transfers, and you look at the height of the vehicles and how they relate to each other. That's all he said on his direct examination. So I don't know exactly what her ruling was. She didn't let in the ultimate opinion, but she let in all this other kind of collateral stuff. And then when they got into to Lally's redirect, then they just went ahead and kind of got into that anyway. What did he say? Vehicles have bumpers to absorb the force from collision. What about the scratches on the right rear quarter panel? That was more of a scraping than a straight collision with a bumper. Well, yeah, if you watch the video, kind of looks like more of a scraping incident than a straight collision on the bumper. I don't know. So her ruling was ambiguous at best. We didn't get him straight out saying, I don't believe that her taillight could have broken from this, but he got to kind of dance all around it and imply it anyway. So John BD Boot, I suspect 0247 and 0227 error a sign of smoke. Are you talking about codes? Are you talking about OBD codes? Maybe. I don't know. Sign of smoke. S. QWERTY, disappointed AJ didn't leave the stand with a "you cannot change the law of physics" jab. Thank you for your excellent coverage. Yeah, you can't. They are what they are, and you're kind of stuck with them. And it's literally your job is supposed to be able to navigate within them to explain to us how are what we see. How is what we are seeing consistent with how you are telling us it happened? That's what accident reconstruction is supposed to be. And you couldn't get us there with physics. You just got us there with your fever dream. Bruce West, the car would have done a 3-point turn at Parents. I'm pretty sure I saw the car do what looked a lot like a 3-point turn in John's garage. Right? Started the car. Okay, I guess it wasn't going forward in the garage, but you know, maybe it was. Sometimes you shift, you know, you overshift. You got that gear shift thing. I don't know. I have on mine, you know, you shift past, but you got the brake on so you don't go anywhere. Get it in reverse. Looked a lot like very similar to a 3-point turn. But yeah, there's a lot of places she could have done a 3-point turn. It's not really that unusual a maneuver. How do we know she didn't do that coming out of Jim McCabe's driveway to go back to John's? Stephanie L. How was the Commonwealth so-called expert qualified to testify? Experts are qualified in the discretion of the court based on their training and experience. If they have a specialized training of experience that would be expected to give them more specialized knowledge than a layperson, then they can be qualified as an expert. So he's a cop and he went to some classes and he's seen a whole bunch of car accidents. That's how he got qualified. Welcome to Science in the Courts. Welcome. Welcome, everybody. I hope you're enjoying the show. Everage. So TP basically testified J.O. could not have been hit by the car, not even by accident. And yes, after hearing him, I think we should call him TP. Yeah, Trooper Paul. TP. I mean, he's got a very specific mechanism for how it happened. Clearly, in his opinion, it was only intentional, right? That's why according to him, they didn't do their reconstruction under the same conditions, the braking, the visualization, and so forth. They didn't do that at night when this accident would have happened because according to him, well, when you're dealing with an intentional act, that type of thing wouldn't matter. So he'd already had that all figured out on February 3rd when he was going to do that testing. I'd be interested in that timeline. Did he do that testing before or after? It was well before he got all of this data, right? Because that was what he testified. He didn't even know Lexus had this system that was going to be available. He just happened to find out about it during his casework over the course of the next year. And then he realized, oh, wow, I might be able to use that in this case. So then they went and got all of these downloads from with the key cycles and the triggering events and everything. So they didn't even have this stuff when he had already made the decision on February 3rd that it was intentional. Doesn't that just tell you everything? Brenda asks, how did he end up being presented to the jury as an expert? Thank you. He says so. The state Commonwealth says he's got special training and experience. That's it. The jury is going to get an instruction on experts that basically says you can give them as much or as little weight as you want, which, is the same as any witness. They're not special just because they're an expert. They might be special in their own minds, but they're not actually special in the law. They are not more equal than other animals. The jury can decide they're full of shit, and I'm not going to pay any attention to anything that guy said. Jason Sorensen, why redirect? Just let him go. Now AJ gets to go at him again. Yeah, not. There was no rehabilitating that. I don't know what he thought he was doing or how he thought that was going to help. NJ Kathy, I think Jim McCabe prepared him to testify. LOL. Well, he was starting to get into that. Well, why don't you just show me? Could you just show me? I think he did that with the grand jury testimony. Yeah, I might have learned that from Jen. Not that he's watched any of this, of course. None of them are watching what we're talking about here on YouTube. Nick Trumer, does this guy want us to buy? She was that fast and the shrapnel went all over the yard like this picture is suggesting. Ha 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 ha. That's amazing. And he actually wants us to believe that. But, that's the whole thing. According to his diagram, there's only 3 pieces of plastic. So he can't account for the other 42. He can't account for those other 42. Still would like to get a count on how many of the pieces of plastic actually matched up with the taillight. Right? I went through, I saw there was a reconstruction that was mentioned last week. A Twitter user had done. That, in fact, let me see if I can find it real quick and pull it up. I think I bookmarked it. Here it is. Let's go ahead and take a look at that. Wait a sec, where is it? I'm in a different browser here. I need to find it. Here it is. This is the Reconstruction, where somebody went through and looked at all of the different photos of the pieces of plastic that were collected and compared them to the photographs from the crime lab, from that analyst who did the reconstruction, and, you know, painstakingly put back together, here's where each piece was, here's where it went. So if this is correct, I can't vouch for it. I don't know, but this is certainly, you know, the type of reconstruction that can be done. The defense could do something like this. Yeah, this looks kind of sus, doesn't it? These unique chunks that just all happen to be found. You know, these ones find a whole chunk in different pieces. Buchanan finds a whole chunk in different pieces, and then Proctor finds a whole chunk in different pieces. Not like a piece from here, a piece from here, a piece from there. So this in and of itself is pretty sus. But then I went back through and I tried to count, okay, how many pieces are there? It was a little hard for me to read, but I wasn't getting any more than like maybe 20 pieces went into this. So that leaves 25 pieces of taillight plastic unaccounted for. That just ended up on the grass. Where did that come from? Whose taillight was that? Yeah, sketchy stuff. But that's what they're wanting us to believe. Bass, trigonometry is outlawed from collision reconstruction training. What is a vector? I lost my mind during this testimony. Yeah, apparently we can't do vectors. I mean, in fairness, aren't vectors pre-calc? Pretty sure they were pre-calc when I was in school. So that might be that hard math that Trooper Paul doesn't really want to do. Arla 7247, glass connected to hand as hair connected to van. Yeah, isn't that the case? About as solid, yet somehow managed to stick throughout this whole process. All these external forces acting on it, yet somehow it stick. And how do we know that? Well, because it just did, according to Trooper Paul. We know that's how it happened because it just did. That's what we see. Therefore, that must be. No possible alternative explanation to rule that out. Like, I don't know, somebody went and dumped all this stuff there. Maybe. Carazola X, which officer do you think has leukemia that they're all shaving their heads in solidarity? I don't know what's with the bald head. I'm just guessing a bunch of guys that are balding. And looks better than the little like way back receded little short haircut. I don't know. Steve F. Trooper Paul said there's no evidence that John landed, so he was projected into orbit. And then he described the debris field as brie. Well, she was cute, wasn't she? That debris field. Yeah, the projection. He's not saying he flew. He's just saying he projected. Well, then how did he get there? Did he get there on his feet, or did he get there in the air? I mean, come on. You can't have it every which way. It's your job to give us an explanation of how it happened. And all we got is just the inconsistent stuff. How did he hit his head on the curb while spinning after cutting his arm on the taillight and still end up in this position on the grass? That's all your job is to just tell us how that can happen. And he can't tell us how it happened. He can just tell us he thinks it happened like that because it needs to be a vehicle pedestrian collision, and this is what they ended at. So that's the only possible way that it could be that it could be like that. Sentient Dreamer, would Judge have pressure of previous guilty verdicts being overturned on her mind if she knew Commonwealth was lying and saw in those vids she reviewed, as in an unbroken tail light, tire movement, what the heck? Yes, potentially. When cops get outed as liars, as fabricators of evidence, yes, that can undermine their previous work. It's not easy to do that. right? Because those previous convictions, you can't raise stuff outside the record of your own case in your direct appeal. So you're dealing with a post-conviction process. The standards are very difficult, and you're always going to have to show how it affected your case, right? So just because Trooper Proctor lied in all these other cases, does that mean he lied in yours? But it's going to be a concern because people are going to be looking. And so, yeah, there are going to be cases where, I don't know, if Trooper Proctor was a little sketch with what he was saying, maybe a little over the edge. Could this be new evidence that could go and open up those previous convictions? Maybe. But I think it has to do with civil rights stuff too, which is what I keep saying, and we're going to talk about as soon as we get a chance. Probably not till the end of the stream at this point, guys. I do have to take a quick break, go in and check on, make sure all of my living things are going to survive another morning without me. So I will be right back. Going to go ahead and put us on pause and try to get back before lunch is over. right, guys, I'm back. I saw over the break, Turtle Boy is reporting that our next witness is going to be Trooper Guarino. And then after that, it's going to be the medical examiner. And then, well, two of them. There's two medical examiners. And then the Commonwealth is going to rest, probably on Friday, and defense will start on Monday. So that is the time frame that we are looking at for getting the rest of this wrapped up. All those other witnesses on the Commonwealth's witness list, guess we're not getting them. Maybe in rebuttal, but definitely not in the case in chief. So that seems like a bold move to me. End with the undetermined medical examiner finding. Guess we'll see. Guess we'll see how much of a whack job she really was. Trooper Proctor might come to regret that. Once again, just be careful what you wish for. Be careful what you wish for. You want to call her a whack job? We might just believe you. Carazola X, we are rapidly approaching the jury reaching I don't care if she did do it territory. One good witness and this guy deletes all momentum she gave him. Yeah, I mean, it's just so rude to expect the jury to do the job of solving your case for you. That's what you were supposed to do. All of you law enforcement officers, all of you prosecutor presenting the case, you were supposed to solve it. The jury might even specifically be instructed, don't know for sure, but it's not uncommon to be instructed. Your job is not to solve the case. You don't have to know. You don't have to decide what actually did happen to vote not guilty. You are just there to decide if the Commonwealth has proved her guilty beyond a reasonable doubt or not. So, yeah, I can't say the Commonwealth has really given them a lot to hang their hats on there. I just can't. I mean, maybe they care, but what are they supposed to do? What are they supposed to do with this? Honestly. Mike, car could have spun out in foot of snow in driveway. Yeah, exactly. Exactly. It is like the least surprising thing in the world that a heavy SUV in deep snow, slush, all those conditions, yeah, would be spinning its tires. It would maybe be a little bit more weird if that didn't happen. Be rational and nice when in this global sandbox. Is Commonwealth using new math, old math, or any math at all? Haven't seen any math yet. Yeah, I don't know which version of math they're using here. I mean, not even so much as an abacus. We don't even get number of fingers, right? We don't even get finger counting. That little math in this case. Roubaix, he was training someone at the scene, blind leading the blind. Yeah, this was an FTO, guys. This was an FTO, training other accident reconstructionists. How does that make you feel? How does that make you feel about the Massachusetts State Police, their ability to figure out what happened in your accident? When you might have millions of dollars on the line, your future health, your medical bills, all that stuff. Because an accident happens and they're responsible for sorting out how did it happen and who's responsible. How's your confidence level in that right about now? What a hit they've taken. WM Penguin, I mean, we can hope that the stress of being a witness just got to him on the stand, right? Well, it certainly did, but I just don't think we can explain all of it that way. I mean, you can't explain stress on the stand for having a ridiculous, unfounded theory that you haven't bothered to substantiate with the normal tools that accident reconstructionists would use to substantiate their theories. That's not stress. That's just being unprepared. Quite frankly, Samantha Teresa, did Trooper Paul do the 9/11 report too? I bet, yeah, maybe he investigated the Kennedy assassination, you know, maybe. Boomher became a member. Welcome, Boomher. Appreciate having you on the team. Silvermane, modern plastic is car bumpers modern plastic in-car bumpers are for cosmetics only. Behind it, there is a metal impact beam. That's the real bumper. Plastic bumpers are almost all impact resistant. Often they are self-healing. Well, that's interesting. See, that's some of this materials stuff that you would expect. You would expect them to know, but they are not sharing any of that with us. So let's get this guy back on. How much further can he damage the Commonwealth's case
Whenever
here?
you're ready, Mr. Lally.
Your Honor, may I approach?
Yes.
Start showing you another document. You
Thank
recognize
you.
that?
I do, yes.
And what do you recognize that?
This is the entire Google URL that was found on the browser state record. So broken down into each of its important sections.
May I approach again, Your Honor?
Yes.
I'm going to take the next exhibit.
Okay.
Same objection as before, Your Honor.
Okay, there are a couple of different objections. I need to see it. I don't know what you're talking about.
Some objections from Yannetti on this one. Don't know what they are. There's a couple different objections. Well, the ones I'd expect would be authenticity, foundation, relevance, not probative. I don't know. See, and we can't know what's going on when we don't get to know what's the deal with these objections. I think this is a good point. I mean, the problem is that none of this is being explained in a way that is simple and understandable for lay people. And so they can't tell. I mean, you are supposed to have experts so that they simplify complicated things for the jury, make it easy to understand. Are these guys doing that? Are they making this simpler? Or does it seem like they're making that a lot more complicated?
You are unmuted.
That will be the next exhibit.
Exhibit 618.
Thank you. Yes.
Thank you.
Publish it for the jury.
Yes.
Now, Mr. Whitman, what's up on the screen now, is that what you have before you at Exhibit 618?
It is, yes.
And if you could, again, using the laser pointer, direct the jury's attention to what are we looking at in Exhibit 618?
Okay, so the left side of the table is the entire URL that was recovered from the browser state record. What I've done is broken it down into each of its individual components and explained what each of those components means. So the very first row is google.com/search. That just tells the browser that we're going to the Google website and that we want to run a search. The second part, the Q equals,
This does not give me
is
hope.
telling the browser what the query term is. So the query term here is host long to dying cold. The little plus symbols in between is in place of a space because spaces can't be part of a URL. Next, we have the input encoding and the output encoding. Just explains what kind of characters to use and what language to use when you're accepting the search query and giving it back to the user. And finally, the important part is the and client equals Safari. This is something that just tells Google that this query is being done using the Safari client. Again, if I was to use Safari and just visit the Google webpage and type that in, or type a search in, that part of the string wouldn't be there. That's only there because I used the Safari search bar as part of the Safari application to do that search.
Thank you, sir. Ms. Gilman, you can take that time.
I thought we did understand that already, and I'm not sure that was in dispute, but
Now, sir, with reference to that, what, if any, relationship does that have to the information you were discussing just prior to it?
Again, that confirms that this search was conducted via the Safari search bar feature that's part of the Safari browser application.
Inquiring minds
the
want
same
to
one
know.
that caused the records to be recorded in the P list.
Your Honor, may I approach the witness again?
Yes.
I thought it was not recorded in the P list. That's why it wasn't on his little P list chart. We already know it wasn't in history, which doesn't make any sense.
To another document. You recognize that, sir?
I do, yes.
And what do you recognize that?
This is the live records from the browser state.db database.
May I approach, Your Honor?
Yes.
Commonwealth is seeking to introduce the witness. Move, Judge.
All right, thank you. So that's 6 minus 1.
May I return to the witness?
Thank you.
May I publish after the jury as well, Your Honor?
Yes.
And Mr. Whitman, do you recognize what's up on the screen now is what you have before you as Exhibit 619?
I do, yes.
Now, turning back to the browser DB database for this particular device, with regard to the timestamp and the last view time, what, if anything, do you observe in reference to that depicted in this, and could you direct the jury's attention to it?
Yeah, so this timestamp is the last viewed time according to the database itself.
Where's
It's already been offset so that it's in local time. This particular table, we can see there are records missing. Between records 4025 and 4031, we have, 4025 and 4031, we have 4026, 27, 28, 29, and 30 missing. And typically the timestamps that we do have here, some of them are separated by as little as a second or two.
And where is Hostlong to Die in Cold at 627?
That was record 4028.
Or 624?
That's correct.
And so based on the records missing from this portion of the phone as far as that database, what, if anything, did you endeavor to do with respect to ascertaining what?
So first of all, the task was to try to recover the deleted messages. The deleted history records from browser state. So first of all, was reading the deleted pages, essentially, to find the records that had been deleted from this current version of the page.
May I approach again, Your Honor?
Yes.
I don't know how this is helping. I really don't know how this is helping.
Sir, I'm showing you another document. I'll ask you to do that.
So why are those records deleted? Why are they missing? You can't just drop that on us. There's a bunch of missing
And do you
stuff
recognize
here
that
at the
document,
critical
sir?
time.
I do, yes.
What do you recognize that?
And that's it?
This is the same data source. So it's still browser state.db, but now looking at it with the unique recovered records.
And what is that last term that you use? What does that mean? I'm sorry.
So typically there can be lots of different versions of a page within a WAL file. So you may have several page ones, several page twos, and so on. What I looked at is doing is recovering the data where the records that I recover are different from each other. So if I recover the same record multiple times, I can ignore it. But if I recover the same record with a slight change, then I would show it in this view.
May I approach, John?
Yes.
I'll seek to introduce the witness. No objection.
Okay.
Exhibit 620.
Thank you. Your Honor, with the court's permission, may I publish that for the jury?
Yes.
Again, Mr. Whitman, if you could, move the way the corner to find it helpful.
Oh, gee, look at that. There's those deleted ones
What, if anything, did you uncover?
that are
during
the
this
Google
portion of your analysis?
website.
So again, the very first column on the left is the unique identifying number. You'll notice that there are some numbers here which are repeated. This is, as I said, because the records are recovered from multiple versions of the same page. There was actually 16 versions of this record across 23 different versions of this particular page. These three had some difference. Primarily, it was what's called the tab order field, but that's the only difference that showed up across these three Host Long to Die in the Cold records. All the rest show the same URL, the same ID number at the beginning, or tab ID number, and the same timestamp.
So why is the search
Worth
in there?
noting, there is no title shown in this particular record. Again, that speaks to the fact that this page didn't successfully complete loading. Otherwise, there would be a title of Google search,
And why
Host Long
does
to
the
Die in the Cold, as you
timestamp
saw in
jump
some of the other
around?
examples earlier.
Now, sir, with respect to the table up here, is there any
29 is at
indication in regards to
126,
private browsing that you were
But
talking about
28 is
before?
at 129.
No, in iOS 15, as I mentioned, if you are using private browsing mode, there is no records recorded in this database at all.
So the fact that that's not listed in this table, what, if anything, does that tell you?
Everything that was recorded in this database was conducted not in private browsing mode.
Now, with respect
I don't think we
to
care
your
if it was
work
incognito
in your
or
field,
not.
you
We care if it
familiar with a term
happened.
called a session?
Yes.
And can you explain to the jury what you want to understand that term to mean and how it applies to this specific instance?
Essentially the life of the particular tab. So when I start a tab and I start to use navigation, I go to different websites. All of my navigation events would be considered part of the same browsing session, essentially.
Now, sir, if I could turn your attention to the Knowledge C database for a moment. And again, if you could, maybe bear repeating, just as far as, can you explain to the jury what you understand that term to mean as far as what is the Knowledge C database?
He
in
already
respect
did
to
this,
the other
Lally.
databases you've been talking about?
Yeah, so far the bulk of what we've
iOS,
discussed, the history.db, the
preferences.
browser state DB, and mobile Safari.plist are all particular to the Safari application on iOS. Knowledge C is much more global. It's much more ingrained within iOS. Everything is essentially recorded in there on iOS 15. So again, backlight activity, unlock activity, application state activity, and web usage activity is all recorded as part of Knowledge C.
Red Forensic, we are
Brown.
going to
Yes.
want to pick your brain. Spill all the tea. Does this make any sense? Is this making sense to you? I don't consider myself a dum-dum. I'm pretty good at understanding things if they're explained to me in terms I can understand, in common sense types of terms. But I am having a hard time following what is going on here. Why is he making this more complicated instead of easier? Doesn't want me to follow what this is supposed to mean? That's It's about the only conclusion I can reach. If you want me to get it, you would simplify it. You
Yes,
would give me the bottom
And do you
line.
recognize that document, sir?
I do, yes.
What do you recognize that?
This is a document I created based on the Knowledge C web usage records.
May I approach, Your Honor?
Yes.
I'm about to seek to introduce and admit the exhibit. No objection.
Thank you.
Exhibit 621.
Thank you.
Thank you.
And Your Honor, with the court's permission, may we publish that to the jury?
Yes.
Do we know if anybody on the jury has an IT background?
Sir, again, what's up on the screen, do you recognize that as what's before you as the next exhibit?
I do, yes.
And if you could, again, Ms. Gilman, if I could ask you to scroll down just a bit to the green tabs. Okay. Now, if you could, sir, again, using that laser pointer, if you could direct the jury's, well, first, can I ask you, what is it that we're looking at in this exhibit?
Okay, this is a particular, what's called a stream within Knowledge C. A stream is basically all like information being grouped together. So in this particular case, the stream is related to Safari, and it's telling us what web page was visible on screen, what time it started and what time it finished.
Now, with respect to this particular tab, there are portions that are highlighted in green and portions that are highlighted in blue. Is that correct?
Correct.
Can you explain to the jury what the portions highlighted in green represent?
I highlighted the sections in green due to their timestamp. So typically these items last between 2:27:37 a.m. and 2:27:53 a.m. So around the time of the Google search, if you were to believe the browser state.
And with respect to the items highlighted in blue, what if any, what are those?
The ones in blue are the actual Knowledge C records that show when the Host Long to Die in the Cold and the How Long to Die in the Kikti web pages were actually visible on screen.
Okay.
And so from this, what if anything were you able to ascertain as to the searches or the time associated with the searches from your analysis here?
At 2:27:40, the only websites that were visible on screen were related to Ozone Basketball and Hockomock Sports, and that the How Long to Die in the Kikti first appeared on screen at 6:23:56, and Host Long to Die in Cold first appeared on the screen at 10:33 a.m.
What?
Those two searches from your review of this extraction in this device never appeared on the screen prior to 6:23 in the morning, correct?
Correct.
Then why aren't they in the history database?
Now, from all this, sir, what, if anything, were you able to conclude with regard to these searches?
So essentially, ignoring the browser state timestamp is important because that is not a reliable timestamp to show when that URL was visited. We have mobile Safari.plist record searches that show 6:23 and 6:24, and we show the same searches with very similar timestamps within half a second as showing up on screen in Knowledge C for the How Long to Die in the Kikti. And the Host Long to Die in the Cold was actually several hours later, which took a little bit more explaining, looking at Knowledge C and when the applications were opened up.
Now, with respect to your view of the extraction of the device around these times, were you able to ascertain as to what time this particular device connected to a Wi-Fi sometime after 2 a.m.?
I actually didn't look at any Wi-Fi connection information.
And with respect to 2:27 in the morning, 2:27 a.m., what were the websites that the device had visible, and what were the websites the device was?
If you're reverse engineering in any way, show me.
So according to
Might
the
as
Knowledge C
well.
records, which were mostly also reflected within the history DB as well, it was the Hockomock Sports, YouTube, Ozone Basketball, and that's it for the main domains.
Now, with regard to the Wi-Fi connection, is your memory exhausted as it pertains to that?
Yeah, I don't remember looking at Wi-Fi history.
May I approach?
Yes.
I'm showing you a copy of your report.
Thank you.
Review that and look up when you finish.
Okay.
And sir, I'm sorry, in the interest of time, if I could ask you just to look at the next page as well, just briefly.
So I guess he did look at Wi-Fi. Is that what we're doing here? Is that their argument? She connected to Wi-Fi and that's when the search completed at 10:33?
Yes.
Okay.
Do you remember a refresh, sir?
I do, yes.
May I approach to retrieve?
Yes.
So, Mr. Whiffen, from your review of the extraction report in regard to this device of Ms. McCabe's, about what time was the connected to a Wi-Fi network called McCabe?
I believe it was 0207. I didn't actually remember the timestamp just then.
And with respect to the disconnection from that, do you know when that was?
I can't recall.
So she was on Wi-Fi at
Your Honor, if I may
home.
approach? I mean, if it's the time Your Honor made the witness.
Yes.
Thank you.
Sir, if you can, from looking at your report, if you can just indicate to the jury as far as the Wi-Fi connections with.
The Wi-Fi was connected at 0212 and disconnected at 0539. There was no further Wi-Fi activity until 11 a.m.
Thank you, sir.
May I approach this to retrieve, Your Honor?
Yes.
So not at 10:33.
Now, sir, are you familiar with something called a write-ahead log or a wall file?
I am, yes.
And if you could explain to the jury what your understanding of that term is and how it applies in this specific case.
Yes. So a write-ahead log is essentially a temporary store for database pages. When I'm talking about database pages, it's not something that the user ever sees. It's part of the structure of SQLite databases. Just as chapters in a book can span multiple pages, data in a database can span multiple pages also. And it's not necessarily in the expected order. It's up to the database application to find those pages and order them correctly in order to display the data to the user. The WAL file, on the other hand, it still contains pages, but they're organized in frames, essentially. And a frame is the same as a page, but with additional information at the top that identifies what page it is. So I mentioned earlier that it's possible to have multiple versions of the same page within the WAL file. That's because every time I write a record to the database, a new frame is created and the page is updated. So for example, if I was to have a new database, create a record, a new frame is created with page 1, and it adds my record. As soon as I add a second record to that database, a new frame is created again. So I now have frame 1 and frame 2. Both of those frames would contain a version of page 1. The first frame would contain only record 1. The second frame would contain records 1 and 2, and so on. Forensically, where it gets interesting is on the edit or deletion of a record, because the same process is applied. So now a new frame is created. The page number is the same as previously, so we'd still have a page 1. But now only the records that I don't want to delete are copied across. So I could end up in a situation where I have 4 versions of page 1. One has record 1, one has records 1 and 2, one has records 1, 2, and 3. But the most recent version of the page only has record 1 and 3, for example. Now, a normal piece of database software will only look for the most recent version of the page, so you would only see records 1 and 3. The forensic software can look at all previous versions of the page as well, and that's how we're able to recover record 2 in that instance. And that's essentially how we were able to recover the browser state record from WAL.
Now, sir, turning to that issue as far as deletion, what, if anything, Well, let me ask you this first, just before we leave the wall file. So with regard to the wall file, what, if any, relevance is there that certain data only exists within the wall file?
So again, if I create a record that's in the WAL and delete it before it gets committed, which means when it gets merged into the main database, then it exists only in the WAL. It could be that it's a brand new record that just hasn't been written yet, or it could be one which was deleted from the database prior to the commit occurring.
When you say commit, what exactly is, what does that mean?
Commit's a process where essentially the database looks at all of the most recent versions of each page in the WAL file, copies them out from WAL and puts it into the main database, and then deletes the WAL file altogether. So at that point, we lose the ability to recover data from WAL because the WAL doesn't exist, but we have all the most recent versions of the page.
Now, so turning to the concept of the topic of deletion of data, what, if anything, did you find with regard to deletion of data with respect to this search as applied to the P list that you discussed before?
Recovering data that's been deleted from the P list is not really possible. So all we can say is if this record exists within the P list, it hasn't been deleted.
Now, same question with regard
And strangely,
to
these
issues
searches
of
don't exist in the
deleted,
P list, huh?
data with regard to the history DB.
There was no records of any, so there's no evidence of any records being deleted from history.db since early January. I think it was like the 3rd of January up to February 2nd.
And how were you able to tell that with regard to the history DB?
Again, every record is given a unique number, and there'd be a gap in that numbering system if a file or if a record had been deleted. The fact that there was no gaps indicates that nothing had been deleted.
And with regard to deletion, what, if anything, were you able to ascertain with regard to deletion versus web usage in the Knowledge C database?
Knowledge C contains such a large amount of different type of data that's always being added and deleted for various reasons, none at the discretion of the user. It's a completely system-driven event to delete information from Knowledge C. So we can't say what was deleted from Knowledge C, but we can see that during the times of Safari usage, records exist within Knowledge C that indicate, or certainly appear to indicate, that nothing was deleted.
What, if anything, were you able to find with regard to
But there were missing
deletion,
files in Knowledge
in respect
C.
to the browser state DB database?
Browser state did have numerous records that had been deleted. Some we were able to recover. 3 records from browser state all had a timestamp very similar to 22740. These were 3 records that had been deleted at some point.
What are some of the options for deleting data from that particular, from the browser state DB?
So the first most prominent option is to delete absolutely everything from the device, or delete all history from the device, which, as I mentioned earlier, we know that didn't happen because we still have other records. So the only other real option is to delete selectively. That could mean delete one at a time, and it could mean delete either the full day, the last 2 days, or the last hour. But in all of those cases, the record must exist in history.db in order to be deleted from browser state. The fact that this record, the hoslong and the how long today and the kickd don't exist within the history database would mean that the user would never have the option to selectively delete that record.
May I approach, Sean?
Yes.
It would be so nice if you would just
Finished.
give us the bottom line. So what does this mean? Can you tell us what she did with her phone?
Yes.
Do you recognize that, sir?
This
I do,
outcome?
yes.
What do you recognize that to be?
So this is a list of the browser state DB records showing a red line where a record or more have been deleted.
And again, the term deleted, as far as it applies to this particular area of the
We know
database,
it's
what
not
exactly does that mean
user-driven
again?
necessarily.
It means the record has been marked as deleted. If you were to read this database in a regular database application, you would not see it, but it doesn't necessarily mean that we can't recover it.
May I approach again, Your Honor?
Yes.
Commonwealth will seek to introduce and admit as the next exhibit.
The exhibit,
I have no objection to the exhibit, if that was the question.
that is the question.
Okay, we're good.
Exhibit 620.
Okay.
Your Honor, with court permission, may we publish Exhibit 622 to the jury?
Yes.
I mean, we are spending hours here on a point
Again,
that
sir,
is
what's up on the
collateral
screen, is that
at
what
best.
you have before you as Exhibit 622?
It says yes.
And if you could, please, using the laser pointer, direct the jury's attention to what, if anything, of significance you observe in this.
So again, we can use the number down the left side, which will identify the unique identifier given to each of these records. And we can see that the red line between the first two records indicates that records between 3986 and 3993 have been deleted. We can see that record 4001 is deleted. Records between 4004 and 4019 have been deleted. Record 4020 was deleted. And then finally, records between 4025 and 4031 had been deleted also.
Now, sir, as far as records 4024 and 4025, what, if anything, were you able to ascertain as far as the dates and times associated with those?
Yeah, so these particular records show up at 227.31 and 227.33 respectively. And this matched records within Knowledge C that showed that at this particular time when the tab took focus, that particular website was also shown visible to the user in Safari.
Now, as far as the date and time for 4024 and 4025, what, if anything, did you observe with respect to the date and time for 4026? And what can you tell about that?
So 4026 was approximately a second or two after the record here, 227.33. I believe it was at 227.35. And then again, there was another record, 4027, which again was another 2 or 3 seconds after that time. So within a 9-second period between 227.31 and 227.40, there were 5 records within browser state DB that had a timestamp within that 9 seconds, all with completely different types of website, ranging from PayPal, banking, YouTube, and the Hoslongstein code.
Now, sir, with respect to, are you familiar with the term called spontaneous deletion?
I believe so.
And can you explain to the jury what that is?
It's not a term that I would use, but essentially a cleanup operation would occur on the device where it would look for orphaned records, records that are old enough to not be required anymore, and they would just be deleted by the system without any direction from the user.
Now, during the testing that occurred, your testing, which occurred with respect to this device, what, if anything, did you observe with regard to spontaneous deletion?
I wasn't able to replicate the spontaneous deletion. I was able to replicate completely orphaned records. So a record that existed in browser state without a corresponding record in history.db. And it meant that there was no way for me to delete that record manually without deleting everything from the device regarding history.
May I approach, Your Honor?
Yes.
May we approach, please?
Okay, could you turn the lights on, please, Tony? Thank you.
You can, but he's insisted that that couldn't happen because of the order, the numeric order. There would be missing numbers in the history files. And he's saying they're not there, therefore nothing was deleted from history. But these searches completed at some point. So where are they? They should be in the history somewhere. But it's so confusing what all of these different databases are and what they're finding and why they're not corresponding, you know, with the time frame. That's why I'm going, just give us a bottom line here. What does this mean she did with her phone to create this history? That's all anybody cares about. Do you think we're going to get that? Do you think we're going to get that? Because I'm skeptical at this point that we're going to get that.
You are unmuted.
All right, so you're introducing those 4 pages or whatever it is, Mr. Lally?
Yes, sir.
As one exhibit?
As the next 4 exhibits.
Okay.
4
All
more
right,
exhibits.
so those will be admitted.
I am trying, guys. It's starting to turn into that, you know, the Peanuts teacher, the grown-ups. Wah, 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 wah. But I'm really trying to follow this. I really am. I want to understand. But it's like they're doing everything they can to make that impossible.
Right. Were you going to publish those? Because you can go ahead and publish them while this is.
I don't think that's,
What are you doing here, Lally?
may I have just one moment, Your Honor?
Sure.
Your Honor, if I can take them just one by one, I think that might be.
Okay.
I'm showing your document. You recognize that?
I do, yes.
What do you recognize that to be?
This is a report from my Artex tool showing the history database at 21:39:34 on the 27th of January and 22:55:09 on the 27th of January.
May I approach again, Your Honor?
Yes.
I'm off to introduce the minutes of the next exhibit.
All right, so all 4 are in. Okay, so you don't need to, you already marked them?
Yes, they didn't object. Go ahead and just display them
623.
and walk us
One
through.
moment, Your Honor.
Or are you going to just dump these
Your
on
Honor,
the
court
jury?
permission if we could publish that to the jury.
Yes.
Okay, good. So here's his own tool that he made up, and it'll tell us some
Now,
stuff.
sir, with regard to this, we're looking at record number 4026, is that correct?
Yes, I believe we are.
And again, if you could direct the jury's attention to what exactly are we looking at?
So now the Hockomock Sports is happening hours earlier, the day before?
Yeah, so in the right column, we
2
see
days before.
the source of the information. So history.db is the database. History_visits would be the table. And then the unique identifying number of 31407 and 31408. We see that the start time or the time that particular website was navigated to, according to history.db, was, as I say, both on the 27th of January, one at 21:39 and 34 seconds local time, and one at 22:55:09 local time. And both of these websites are related to Hockomock Sports. We have the URL at the top, followed by the title of the page, followed by a visit count that tells us how many times that page has been visited before.
Well, Jen said she was searching this in bed at 2-something in the morning on the 29th. So how does that line up?
Sorry, one moment, Your Honor.
Yes.
How does any of this work? It's almost like Jen tried to tailor her testimony to what she thought the technical evidence was going to be. Kind of seems maybe like that, doesn't it?
That next document, you recognize that, sir?
I do, yes.
What do you recognize that to be?
This is the same kind of report. This is related to the YouTube record that was part of the browser state database related to It's Raining Men on YouTube.
Is that the record number 4027, is that correct?
It is, yes.
Your Honor, may I approach again?
Yes.
That's the remark.
Okay.
Exhibit 624.
Your Honor, very briefly, may we publish that? for the jury as
Yes.
well?
The It's Raining Men was
And
supposed
sir,
to
what's up on the screen
happen
now, is that what you have?
at the
before you as the
Alberts.
next exhibit?
It is, yes.
And again, if you could, using the laser pointer, just direct the jury's
Once
attention
again,
to,
we
what-
have
what,
a
if
couple
anything,
days
of significance
before.
you observe in this record of 4027.
Yeah, so again, we have 5 records related to the YouTube video, It's Raining Men, starting at record 31398, 31399, 31400, 31401, and 31402. These were all accessed on the afternoon of the 27th of January 2022.
May I approach again, Your Honor?
Yes.
What about at the Alberts? That's when she said she accessed it.
Another document, you recognize that?
I do.
What do you recognize that to be?
This is the same again, related to record 4029. Shows that a website was visited on the 28th of January 2021.
And Your Honor, ask that this be marked.
Okay.
Excuse me, as the next exhibit.
625.
Okay.
And Your Honor, with the court's permission, may I publish that briefly?
Yes.
Well, sir, what's up on the screen, is that what you have before you as the next exhibit in regards to record 4029?
It is, yes.
And again, if you could explain to the jury what we're looking at.
Yeah, so this URL, cantonma.org, relates to the URL that was provided in record 4029 of the browser state database. It shows that this web page was accessed at 1 p.m. And 17 minutes and 0 seconds, and 1 p.m. 17 minutes and 8 seconds on the 28th of January 2022.
May I approach again, Your Honor?
Yes.
This is not mathing.
I do.
It's not mathing.
Again, the same kind of report. Again, this type of record 4030 from browser state, and it shows access to Ozone Basketball.
And with regard to that report, as far as the same kind of report, that's from your tool, the ArtX tool, is that correct?
Correct.
And that ArtX tool, is that a widely available tool used within the field of forensic investigators?
Yeah, it's something that I say I've worked on for around 5 years.
Yeah.
I've given it away free to the digital forensics community for 5 years. There's approximately 600 users globally, and it's taught as part of the SANS digital forensics training courses.
Thank you. May I approach again just to retrieve, Your Honor?
Yes.
600 whole users.
Yes.
This does not sound like it's generally accepted in the relevant forensic community.
May we publish that for the
Yes.
Your Honor? Regard to this exhibit up on the screen, record 4030, again, if you could just draw the jury's attention or direct the jury's attention to what, if anything, of significance you observe in this exhibit.
Yeah, so again, we have records from the history database related to Ozone Basketball, and it shows that this website was accessed at 11 a.m. and 26 minutes on the 25th of January 2022.
May I approach, Your Honor?
Yes.
What's this relevant for?
Just come in.
Why are we talking about searches days before? I'm with you, Mr. Yannetti. I want to just drop my head.
Now, with respect to to sort of the totality of your analysis, Mr. Whitman, what, if any, conclusions did you come to as to the timing of the two searches in question with relation to what you observed in your analysis and testing of this device?
Yes. So in conclusion, I determined that the tab that was used was focused at 227.40. So the tab was opened at that time, at which point it was being used to show Ozone Basketball and Hockomock Sports websites. The 6:23 timestamp is when the search was first conducted. Never loaded the page, otherwise there'd be a record in the history database. And while that page was still loading, a secondary search was conducted for Hoslong to Die in the Cold. Again, that page never loaded either, although these both did show up in the Knowledge C database to show that the browser was trying to display these pages. Safari was closed prior to the Hoslong to Die in the Cold record being shown on screen at all. But when it was reopened at 10:33, in regards to whatever other Safari activity was to be conducted, it appeared on screen. So we have a 10:33 record where Hoslong to Die in the Cold was shown on screen, even though the page never successfully loaded.
And with respect to your analysis and your testing here, what, if any, opinion do you have as to whether or not any of the data marked as deleted was actually user deleted, or a user actually actively went through the process of deleting the data?
Yeah. So again, we know that she didn't, we know that nobody deleted the entire history. So that leaves the only option to be selectively deleting records. The fact that there are no missing records in HistoryDB shows that it's impossible that that record could have been deleted by the user. It would have just been orphaned in the database, and I believe would have deleted itself at some stage whenever a particular cleanup function ran. Although, as I said earlier, I haven't been able to replicate that. I was able to continue to read the various versions of the page that contained Hoslong to Die in the Cold browser state record, and found that it existed at the same time as another record that was created at least 2 days later. Therefore, I can determine that that particular record was not deleted until at the earliest 10 p.m. on the 31st of January. And that it's not possible that the user could have created or caused that deletion to occur.
Now, over the course of your analysis and testing or review of the extraction in this case, did you have occasion to review an affidavit of a Mr. Richard Green?
I did, yes.
And what, if any, opinions or conclusions do you have as to that affidavit?
I had issues with several of the statements being made as part of the affidavit.
And what issues were those?
Namely, it specified that Cellbright report identified that the search was conducted at 227.40. And as I've explained, I believe the tab took focus at 227.40, not when the search occurred. The report mentioned that Cellbright report identified it was deleted by the user. We don't do that. We'll tell you that a record is deleted, but we don't specify how the record was deleted. That's something for the examiner to determine. I forget. Oh, and then there was a mention of the purpose of the browser state database. The explanation given was correct for iOS 14 and below, but not for 15 and above, which is relevant in this case.
Now, you mentioned this issue as far as coming up, obviously, in this case and some other instances, phone calls or inquiries that you received from Austria and other places. What, if anything, have you or your company, Cellbright, done with regard to rectifying this issue?
Well,
I'll allow it.
Okay. We recognize that this timestamp could be misleading. Regardless of how we label that timestamp, the very fact that a timestamp is there, we feel would be or potentially misrepresented. So the decision was taken to remove the timestamp altogether from that information. So now we show the web page was visited, but we don't attribute a time to that purely because it could be wildly inaccurate.
Thank you. Your Honor, this may be the appropriate time for the instruction.
Okay. All right, so jurors, we're about to see a demonstration by Mr. Whiffen. It's simply a demonstration to help you to understand the evidence that you've heard. It's not evidence from this case, but it helps you understand the evidence in this case. You must decide this case based solely on a fair consideration of the evidence and nothing but the evidence. But this is a demonstration to help you understand that evidence.
Your Honor, rights are preserved, correct?
Yes.
Thank you. And so to that point, Mr. Whiffen, were you able to prepare a demonstration in regard to what you've been discussing through the course of your testimony?
I was, yes.
And that demonstration doesn't specifically reflect on the searches or the extraction report that you looked at in this case, correct?
Correct.
But as far as the overall issues that you've been discussing in your testimony, correct?
That's correct.
And with court's permission, may the witness now illustrate that.
Yes.
I want to see that because his explanation is she was
So
searching
first of all, on
and
the
it
left
didn't
there, you
load,
can
and while
see
it was still loading,
a
she
screen
searched
of
another
an
one.
iPhone,
But how would
and
you
that is
do
a
that
phone I have in front of me live.
without getting a
It's
different
just demonstrating what I can see on the phone. This is my RTX tool, and the feature which I continuously use this tool for, which is not available really in any other vendor tools, is the ability to create a live connection between my computer and the phone. The live connection is what I've just started here, and what's going to happen is all of the files and folders that exist on the phone will be mapped to my computer so that I can navigate it. I can look around and I can take a look at near enough live records on the device. Prior to the availability of this tool, I would have to test a theory on a phone, do an extraction, and then pass the extraction, which could take anywhere between 20 minutes and several hours. The reason that I'm using this tool today is because I can do those same tests within 10 or 20 seconds, typically. So I just need to wait for this section to do. So it's already mapped out all of the files and folders. It's now asking for a few important pieces of information, which it will then populate on the screen. So information such as the device, serial number, etc. What we're interested in, though, is the browser state record. So I can go to the browser state database and take a look at that and open that up. And you can see that at this moment in time, I have no records in the database at all. If I go back into the live view of the phone, you can see I have Safari open from last night. So it's been sat in the background overnight and not doing anything. But at 10 past 8 last night, I performed this search in a brand new window. So started Safari, opened up a new tab, immediately searched for new tab at 2010 on the 16th of June. If I now search for the time right now, 1442, what I can do is go back to my RTX tool and press this reload button. That's going to delete the database from my computer only and copy the most recent copy of the database and WAL file from my phone back to my computer, where it shows me I still have no records. That's expected behavior because at the moment I've not closed the tab. So if this, again, was iOS 14, there would be a record there to say what tab I had open, but iOS 15 doesn't work that way. If I now go back to my tabs and actually just close this window, I can go back into RTX and hit reload again. And we now see we have some records. I can look at this particular record and you'll see the title is 1442 Google search. You'll see the Google search record here. So I just need to change the time zone as well to Eastern time. So you see it's the most recent search which I conducted, the 1442 search. The last viewed time, though, still shows as 8:10 p.m. last night, because that's the time the tab was focused, not the time that the search was conducted.
Thanks. I may have a moment, John?
Yes.
I would have preferred seeing that done in Celebrate, right? Show me
Thank you, sir.
Celebrate
I have no
creating
further
this
questions.
artifact.
Okay, Ms. Giannetti?
Thank you, Ron.
Good afternoon, Mr. Wilson.
Good afternoon.
Sir, you had spoken a little bit about what was your assignment here in terms of the data that was sent to you. And I believe that you testified regarding that 2:27 a.m. or 2:27 and 42nd a.m. timestamp that it didn't make sense to the investigators, correct?
Correct.
Were you told that one of the investigators was Trooper Michael Proctor?
I don't recall any names being mentioned. The ticket came to me, or the request came to me via another Cellbright employee who'd been asked about this case and asked whether we could offer any help.
Okay, thank you. You would agree with me that when you're making or doing a simulation, you want it to be as close to an apples-to-apples comparison as you can get?
As best possible, yes.
And to get truly accurate research results, you want to eliminate as many variables as you can, correct?
Correct.
You wouldn't, for instance, want to use an Android operating system to try to replicate the activity from Jennifer McCabe's Apple iPhone, correct?
Correct.
What version of iOS did you use for your testing of Jennifer McCabe's data?
So this test has been undertaken on various different versions of iOS, from iOS 12, 13, 14, 15, 16, 17, and most recently on the beta version of 18 last week. This particular demonstration was on 15.8.2.
Okay. And you're aware, you said 15.8.2.
Correct. I've also tested on 15.7.
Oh, fair enough. You're aware, however, that Ms. McCabe was using iOS version 15.2.1, correct?
Correct.
And you would agree that the way that an artifact is stored would depend on the iOS version that you use, correct?
Correct.
And your simulation did not use the iOS version that Ms. McCabe was running on her iPhone, correct?
Correct. I used the closest version I could find.
So I'd like to ask you some questions about the characteristics of browserstate.db-wall and record number 4028, if I can.
Okay.
That record number, I believe you testified, was found to be deleted, correct?
Correct.
But you were able to recover the date and time associated with it, correct?
The date and time of the last viewed?
Of that record number.
Yes.
And what was that date and time?
2:27 and 40 seconds a.m.
You were also able to recover the content of that particular Google search itself?
I was able to recover the URL for it, yes.
Okay, and what was that Google search?
Hostelong to die in the cold.
And it's true, however, that the session history could not be recovered, correct?
That's correct.
Now, given those characteristics that we've just discussed, did your testing result in a WAL file record, a WAL file record, that matched the characteristics of 4028? In other words, deleted with session history not recoverable?
The issue with the session history, I was able to recover only the first page of session history. What happens is when there's a large amount of data that's split over multiple pages, if it's a live record, all those pages point to each other so that you can chain it together and get one large amount of information. Once they've been deleted, some of those pages can be overwritten and therefore the pointers don't make sense anymore. So the amount of information in this session was way larger than one page, and I wasn't able to recover anything further.
Okay, and you'd agree that the simulation was done using a different operating system, correct?
Correct.
Were you able to recreate the other deletions that appeared before and after that record 4028?
Which deletion, sorry?
Well, you had testified, and I believe there was an exhibit that was introduced that showed that there were multiple deletions both before and after, correct?
Correct.
Were you able to recreate those deletions?
When I manually deleted records from the history, then the records also were deleted from the browser state.
Interesting.
Now, I believe that you testified, and if you didn't, I believe it's in your report, that there are essentially 5 mechanisms for record deletions in the browser state database, correct?
Correct.
You ruled out 4 of them pretty quickly, correct?
Correct.
And I believe you've testified to that today, correct?
Correct.
The only remaining option was selective deletion by a user, or there's some internal mechanism for record deletion that is not fully understood, correct?
Correct.
All right. And you know of, as you testified, no internal mechanism for record deletion that's not fully understood, correct?
I've not been able to replicate that function, no.
All right. If there is no unknown internal mechanism for record deletion that's not fully understood, that would leave selective deletion by a user, correct?
Not in this case, no.
All right. Well, selective deletion, you would agree, means that a user selects what to delete, correct?
Correct.
And regarding the user, the term user, what is that? Who is that?
Whoever's using the phone at the time.
Okay, so it's actually somebody who is using the actual iPhone itself, correct?
Correct.
Not necessarily a computer expert, correct?
Correct.
Would you agree with me that somebody who had access to the data before it was extracted and sent to you could have made selective deletions of the data?
Objection.
I'll allow
No, I don't.
Are you aware of an app called MySQL?
Yes.
What is MySQL?
MySQL is just a method for viewing SQLite databases.
All right. If someone had access to the raw data, again, before it was sent to you, and used that app, they could make selective deletions of the data, couldn't they?
I assume you're talking about opening up the extraction, taking out the particular file and editing it?
I'm sorry, I interrupted you. You're right, Your Honor. I apologize. And I apologize to you.
Okay.
If you could restate your answer or give me your full answer.
Okay, so it would be possible with the extraction to take out particular databases, alter them, and put them back into the extraction. But there's something called a hash mechanism that we have in place that would, it essentially hashes the original data, and then it can be hashed again at a later date. It results in a long string of characters, and if there's any changes to the original data, then we'd see that it's been modified.
Would you agree with me that someone with access to that data and an appropriate application or program could also delete and renumber history.db and knowledge.cso so that it would appear as though there was no break in the numbering, so that it would also appear that nothing was deleted?
It's potentially possible, but would require a large amount of knowledge and skill to do in a way that can't be detected.
Thank you very much, sir.
So it's possible.
Any discrepancy between the iOS version and Ms. McCabe's phone and the iOS version in the demonstration that you did, what, if any, impact does that have on what you showed this jury?
So in this particular case, every iOS version that I tested, as I mentioned, from 12, 13, 14, 15, 16, 17, 18, the timestamp is always referring to the time that the tab took focus. So even though there are some differences with when the record's created, the meaning behind that timestamp has been consistent.
Now, what you were asking about what you were asked about in regard to selective deletion, you indicated that there's no evidence of that in this case. Is that correct?
Correct. Selective deletion would require that the record existed in the history database in order to be selected to be deleted. The fact that there's no missing records indicates it was never written into that database and therefore could not have been selectively deleted.
Now, the hash mechanism that you testified as far as detecting whether or not someone had surreptitiously gone in and deleted things, Did you see any evidence of that in your review of the extraction of Mr. McCabe's phone?
I didn't have access to the hash information to see whether any changes had been made. That's something that the original examiner would have had access to. From my point of view, there was nothing in there that would indicate that tampering had occurred. The timestamps all made sense for the files. The historical pages all made sense. So it's probably possible, but it would take a large amount of skill to do.
Now, with regard to your analysis and your testing in this case, again, what is your opinion or conclusion as to when these two Google searches were conducted?
I'm of no doubt that the only time those two searches were conducted was at 6:23 and 6:24 on the morning of the 29th.
Thank you, sir. Nothing further on.
Prior to today, have you ever heard of spontaneous deletion?
It's not a term that I'm familiar with.
Thank you.
All right, sir, you are all set. Thank you very
Thank
much.
you.
That's funny.
Do you need a couple minutes to take your stuff down?
I can probably be quite fast. Thank you.
That's Lally making up technical terms. So he gave us his bottom line, and then Yannetti explained that that could be manufactured. Somebody would be able to go into the extraction and change it, and then like basically re-upload the phone. So it would look like there wasn't any deletion from the history database.
All right, Mr. Lally, your next witness, please.
Yes, Your Honor. The Commonwealth called Trooper Nicholas Guarino to the stand.
Okay.
Trooper Nicholas Guarino.
I should give the court and jury the
He's
case
got
over.
hair. Is he in the right
Nothing but the
place?
truth, so I hope he's not. Yes, sir. Thank you.
Good afternoon. Oh, good afternoon now. Good afternoon.
He looks like Paul Ryan. Holy cow, does he look like Paul Ryan? Give us your
Good afternoon, sir.
Medicare solution.
Good afternoon, sir.
Could you please state your name and spell your last name for the jury?
Yep, Nicholas Guarino, Guarino.
And how are you employed, sir?
I work for the Massachusetts State Police.
And how long have you been a member of the Massachusetts State Police?
This is my 9th year now.
Now, prior to working with the state police, what, if any, prior experience did you have in the field of law enforcement?
I was a local police officer in Norwood for almost 11 years.
Now, with respect to your role within the state police, where is it that you work now?
I currently work at the Norfolk District Attorney's Office.
And within the detective unit, is that correct?
Yes, that's correct.
And with respect to that, what, if any, specialized role do you have within the detective unit attached to the Norfolk DA's office?
Yeah, I conduct cell phone forensics, computer forensics, and I also do sexual assault investigations.
Now, with regard to the electronic forensics, what, if any, specialized training have you received in that particular area?
I have about 300 or so hours at Cellbrite, CCO, CCPA, cell phone repair forensics, Berlin motor vehicle forensics, Axiom magnet, cell phone and computer forensics, X-Ways. These are all different programs used for cell phone and computer forensics.
Now, sir, at some point, did you become involved in the investigation involving the defendant, Karen Reed?
Yes.
And with respect to that, let me just ask you, at some point, did you become aware of an affidavit from a defense expert named Richard Green?
Yes, I have.
And sometime following that, did you have occasion to reach out to Cellbrite with regard to what had been posited by Mr. Green as in regard to two Google searches contained within Jennifer McCabe's phone?
Yes, I did.
And eventually, at some point, did you have occasion to speak with the gentleman who came in here right before you, Mr. Ian Whiffen?
Yes, I did.
And so that wasn't Trooper Proctor that had reached out to Mr. Whiffen or had any communication that you're aware of with Mr. Whiffen, correct?
No, I reached out after the defense expert's findings were released, and I read his report.
And did you also have occasion to review a report from a Miss Jessica Hyde?
Yes, I did.
And with respect to those two reports, what, if any, conclusions or opinions did you come to independently in relation to those opinions of Ms. Hyde? Objection.
Sustained.
Now, Trooper Guarino, you had mentioned that you've had specialized training in regard to something called BURLA, correct?
Yes.
Could you please explain to the jury what BURLA is and how is it used in criminal investigations in your line?
So BURLA is a specialized hardware and software used to download the infotainment and telematics modules in a vehicle. So telematics module is basically like the SIM card for the car. And the infotainment system is your radio head unit that enables you to have Apple Play, CarPlay, or Android or Google Play for the vehicle.
And at some point, were you made aware of a search warrant that was authored in regard to seizing the infotainment system from Ms. Reed's vehicle?
Yes, sir.
And just so the record is clear, can you describe Ms. Reed's vehicle as far as what type of vehicle we're talking about?
Yes, it's a Lexus LX 570 SUV.
And specifically on February 2nd, 2022, did you have occasion to remove that infotainment system from the vehicle pursuant to that search?
Yes, I did.
And once that item was removed from the defendant's vehicle, what, if anything, did you do with it?
After we removed it from the vehicle, it was brought back to Norfolk DA's office for data extraction, or attempt to.
And that data extraction, if you know, based on your training experience, sort of how is that conducted, or what is the process of extracting data using BURLA?
Yeah. So depending on the system, it's dismantled. They have the specialized hardware that actually goes on to the motherboards of these systems, and we're able to pull the data. Or the other option, if that's not viable, is to do a chip off, where we have to basically destroy the motherboard and take the memory chips off the devices to try to get the data that way.
Now, with reference to this specific device, what, if any, efforts did you undergo in order to extract the information without using the chip off?
So at the time that we pulled the system, it was not supported. I emailed BURLA and called them, see if they had a timeline of when this might be supported so we could get the data. We deemed chip off as a last resort, because it is a destructive process. So once those memory chips are taken off, the likelihood of trying to reattach them and get it to work again is very slim.
Let me stop you there for a second. When you talk about an item being supported, what does that mean?
Whether or not BURLA has the ability to pull the data from that vehicle.
And how is that sort of determined, or how are you able to ascertain whether or not a particular vehicle, make, model, manufacturer is supported by the BURLA device?
They have an app, and they also have their tech support. But if you put in the VIN of the vehicle, or if you don't have the VIN, you have the make, model, and trim level, like limited or XLE or whatever, you would be able to go in and look it up and basically say, BURLA will tell you, yes, it's supported for GPS points, or it's supported for diagnostic data, or, whatever that they're able to get out of the vehicle. And they work with the automakers to get these, get this data. So.
And approximately how many different types of if we're looking at sort of the entirety of different makes and models of manufacturers, if you know, sort of what percentage of those types of vehicles are actually supported and BURLA can actually extract information?
I don't know as of right now. It's a lot, and they're constantly updating it, so they are able to do more vehicles as time goes on.
Now, at this particular time, as you sit here today,
Don't know, lots of cars.
June 17, 2024, the vehicle that the defendant was operating on January 29, 2022, is that vehicle available or supported by Burla at this time?
The trim level that the defendant had is not still supported. There is Toyota and Lexus support now, but it's not, unfortunately, for her model.
Now, you mentioned that you had reached out to the Burla company for updates as far as the availability or when the defendant's vehicle might be supported. Is that correct?
That's correct.
And about how many times and over what time period are we talking about that you reached out to ascertain?
Immediately, when I did the extraction, I should say extraction, but when I took the system out of the vehicle, I had to reach out to Burla because where it wasn't supported, they actually had to send me tech diagrams so I could go in and, again, not destroy the whole vehicle as I just took those components out. Over the next, almost 2 years, year and a half of going back and forth with them, with their support and their sales team.
And when you say going back and forth, about how often were you reaching out to them, or how often were you getting a response in regards to the Burla?
Usually every few months, I want to say every 3 months, give or take. I forget the exact number, but phone calls or an email to them asking.
Now, beyond that, are you familiar with a National Cyber Crime Conference?
Yes.
And do you attend that on an annual basis at least?
Yes, I do.
And with respect to that, what, if any, time at those conferences did you spend dedicated to ascertaining the availability or the supportability of this vehicle with reference to Burla?
So Burla has a booth at the National Cybercrime Conference. I spoke with their sales team there. Their response was to keep calling Burla, keep pestering them, and they might actually get the support sooner than later.
Booth, and we're talking about that at this trial.
And again, were you ever able to ascertain or get the support to download the information from them?
No, unfortunately.
Now, at some point,
okay, so you couldn't
at
use
some point,
Burla.
were you able to download any information from that particular infotainment system from the defendant's vehicle?
And not from the infotainment system, but Burla released a new item similar to a mechanic scan tool. It plugs into the OBD2 port, which is underneath the dash. So we're basically, if a mechanic went in there with a scan tool to tell you why you have a check engine light, this does something similar. So you plug it in, and then it pulls the car diagnostic data from that.
And as far as the data that you received from that, what, if anything, did you observe?
Again, I got a series of 14s was the numbers. It was no readable data. I reached out to Burla and asked them, I said, is there a reason why it pulled this data, but when I put it into the software, it's not telling me anything. It's not giving me any readable data. And they said they know it is diagnostic data, but they haven't got anything from Lexus to say these 14s, these codes mean this. They only know it as emissions.
So was Burla itself able to read that information and transform that sort of binary code into any sort of readable data for you?
Other than the number 14, no.
Now,
It's emissions.
From there, what, if anything, did you do with regard to the Burla and the defendant's vehicle?
Was placed back into our digital evidence lab, and then we did eventually do a chip off to the device.
Now, with respect, to the chip off, that was done sometime in December of 2023, is that correct?
Yes, that's correct.
And again, if you could expound upon a little as far as, can you describe for the jury sort of the chip off process, why you were reluctant to do it, and what's entailed in it?
As I said before, it is a destructive process. As soon as we do it, we take those memory chips off. It's applying extreme amounts of heat to the motherboards to take the memory off. That'll heat it. You lose a lot of the soldering and capacitors, anything that's on that motherboard. So, like I said, once the memory chips are taken off, it's going to destroy the board.
And as far as that chip-off process, who, if anyone, was present with you, or who, if anyone, assisted you in removing that or conducting that chip-off process with regard to the motherboard from the infotainment system from the defendant's vehicle?
I'm sorry, at the time that we actually did the chip off?
Yes.
Yeah. It was myself, AG Speak, and Maggie Gaffney.
And who is AG Speak?
AG Speak is has his own forensic company, I guess you could call it, for Burla. I could consider an expert in the field, former California Highway Patrol officer that exclusively handled stolen cars.
And who is Ms. Gaffney?
She was the defense's expert. She's the one who actually did the chip off, applying the heat and taking the chips off in our presence. And she, I believe, works for, I'm sorry, the name of the company escapes me at the moment.
Now, with respect to the information that you, Ms. Gaffney, and Mr. Speak were able to remove pursuant to that chip-off process, what, if any, usable information were you able to glean from that?
As I was told by AG, there was no data that was recovered off the infotainment system or the telematics module from the chip-off.
And as far as Ms. Gaffney, did you have any conversation with her as far as the information that she was able to glean or read or decipher?
No, once she did the chip off, I had not spoken with her since.
Have a moment, John.
Yes.
Okay. So you destroyed the infotainment system and got no data.
Guarino, at some point in late January, early February 2020, were you provided with some a laptop and/or desktop computers from the home of Mr. O'Keefe?
Yes, I was.
And what, if anything, did you do with those?
One was a Dell laptop, the other was a HP all-in-one desktop. I removed the hard drives from both systems and used...
Objection, may you see in your honor?
Okay.
Did he have a warrant to do this? I don't know. Really? You have to destroy the entire motherboard to take off the memory chip? I don't know. I don't build motherboards. It just seems like the kind of thing. Don't you have? I mean, all these things are soldered on. Don't you have some kind of isolating tool? I don't know. What did they do? Like put it in the oven or something? I mean, extreme heat. How extreme are we talking about? I don't know. And weirdly, they got these codes, but no one can tell them what the codes mean. Lexus couldn't tell you what number 14 means other than it has something to do with emissions. Did he say? I thought he said emissions. On a new car? Bad O2 sensor? Maybe. Maybe. I mean, maybe this car was manufactured for California. I got some special emissions rules over there. I'm really confused. Like anyone can get a code reader that plugs into the Obdi port. Like they're out there on the market. Anybody can buy one. And the codes are pretty universal, I thought. I mean, if not universal, at least like, yeah, it's known what they are. You can get the same basic information that the Lexus Tech is going to have, because this is all the Lexus Tech is going to do when you have a problem with your car and you take it to the dealer. They're going to plug their code reader into the Obdi port and it's going to give them codes And then they're going to figure out what the problem is from that. And they couldn't figure that out. That just seems not right to me. Why don't you just take it to the Lexus dealer then and have them run it and tell you what the code is? I'm getting a feeling of like weaponized incompetence from the Commonwealth's experts today. I mean, not so much the Celebrate guy. Like he okay. I just didn't understand him. I didn't get this. I don't understand what he said really and how it corresponds or doesn't with what Jessica Hyde said. But these other guys, they just can't figure anything out.
All right, Mr. Lally, you can continue.
So Trooper Guarino, there was a Dell laptop and an HP Pavilion all-in-one desktop, correct?
Yes.
These were taken from Mr. O'Keefe's home, is that correct?
Yes, they were.
What, if anything, did you do with respect to those computers?
As I said, I took the hard drives out of both machines. They were imaged, and the images were loaded into Axiom to view the data that was on them.
Now, when you say something was imaged, can you explain to the jury what you mean by that?
It's a bit-for-bit copy of the hard drive. Instead of us turning it on and going through it, which would change data, by taking the hard drives out and imaging them, it creates a one-for-one copy, so that way we can view it without changing anything in the system.
Looking for nudes.
And
you do it all
you
through the
mentioned
image.
a tool called Axiom, is that correct?
Yes.
And can you explain to the jury sort of what is that Axiom tool and how does it work?
Yeah, it's another forensic tool that we use. Can do cell phones, computers. You'll use it to load the images so we can view the data.
And with respect to the imaging that was done with regard to the Dell laptop and the desktop, what, if anything, was it that you were looking for specifically on those devices?
We were looking for a Ring video to see if either computer was used by Officer O'Keefe as a login machine to handle the account.
And from your review of what was extracted or imaged from each of those two respective computers, what, if any, information were you able to glean in reference to Ring.com or anything else?
Neither computer was used. One appeared to be used mostly by the kids, and the other, I believe it was the laptop, was used mostly by O'Keefe, but there were no Ring logins.
So Karen didn't delete them that way.
As far as the Ring connection, what, if any, devices were you, throughout the course of the investigation, were you able to ascertain were actually connected to the Ring cameras at Mr. O'Keefe's house?
Officer O'Keefe's cell phone.
Now, if there were any other devices, whether they were Mr. O'Keefe's or someone else, ascertained from either the Ring footage or the information provided by Ring, whether or not there were any other devices beyond Mr. O'Keefe's cell phone that were linked to that account?
Not that I know of.
And I'm sorry, just not that there weren't any devices or not that you could tell?
Not that I could tell or that I ever heard of.
Now, Trooper Guarino, let me ask you some questions just in general about a cell phone extraction. You familiar with that term?
Yes.
And can you explain to the jury sort of what is involved in that? And,
yeah, we need to hear this for like the 8th time.
Is performed as far as your experience with regard to investigations that you've been involved in?
Yeah. So most investigations, we get the cell phones from the scene, from a suspect, from a victim. They're put into airplane mode to preserve the data, so that way remote wipe can't be sent to the phone from iTunes. If we can't put it into airplane mode, we'll put it into a Faraday bag, which blocks the cell phone signal. And then it's brought back to the lab and put into a Faraday box, which is has electrical outlets inside of it, so that way we can keep the phone charged.
And with regard to this investigation, involved in the extraction of data or the examination of extracted data from any particular phones?
Yes, I did John O'Keefe's phone, Karen Reed's phone, and we had 2 witnesses' phones, but I don't remember doing the extractions themselves.
But as far as the data from those phones, have you had opportunity to look at that data? And specifically, I'm asking about both Jennifer McCabe's phone and Ms. Carrie Roberts' phone.
Yes, I have.
Now, were you also at some point provided with some material from Brian Higgins' phone?
Yes, I saw screenshots of text messages.
And from the material that you were provided with reference to Mr. Higgins' phone, were you then able to cross-reference that eventually at some point with respect to the information in both Ms. Reed's phone and Mr. O'Keefe's phone?
Yes, I was.
From what you reviewed, was the information contained within the material provided by Mr. Higgins, was that consistent with what you observed in Ms. Reed's phone as well as Mr. O'Keefe's?
Yes, I didn't see any differences in those messages.
Now, with respect to, starting with Ms. Reed's phone, that was received by you on January 29th, 2022, is that correct?
That's correct.
And do you recall about what time it was and where you were when you received that phone?
I want to say 6 or 7 o'clock at night at the Norfolk DA's office.
And who did you receive that phone from?
Trooper Proctor.
And with reference to that phone, what condition was it in at the time as far as you referenced airplane mode, Faraday bag, things of that nature? How was it sort of when you received it?
I believe it was in airplane mode. The phone was in good working order. And it was placed downstairs in our lab plugged in to keep the phone battery charged.
Now, the same with respect to Mr. O'Keefe's phone. When and from whom did you receive that, and what kind of condition was that in when you received it?
I also got that from Trooper Proctor the same time as Miss Reed's phone. Same condition.
Now, with respect to the defendant's phone, at the time that you received it, did you have any passcode or any way to get into the phone?
I'm sorry, whose phone?
Ms. Reed's phone.
Oh, no. The software we use to try to bypass passwords to be able to extract the evidence, I should say the extraction of the data to look for evidence, her phone at that time was not supported.
Now, what, if anything, did you do with her phone in regard to that?
Again, made sure it was in airplane mode and just kept it plugged in until such time as the phone was supported, and then we could download it.
Familiar with the device called the Gray Key?
Yes.
And can you explain to the jury what that is and what, if anything, you did with regard to the defendant's phone and the Gray Key device?
Yep. So Gray Key is, again, specialized hardware and software used to plug in the phones, can do Apple or Android phones to bypass passwords.
And how does that sort of function, or how does that work as far as when you hook something, a cell phone or a cellular device up to a Gray Key tool? What is it doing and how does it work?
If I knew that, I'd be a millionaire, but it basically installs software onto it, and instead of when you put in 10 passcodes to an iPhone, on the 10th one, if it's wrong, it kills the phone forever. This has some secret software that's able to bypass that and basically keep hitting the phone with passcodes until it finds the right one.
So it essentially runs a bunch of different combinations of passcodes into the phone until it comes up with one that actually opens the phone.
Yes, that's correct.
And at some point, did the Gray Key device actually break into the defendant's phone?
Yes, it did.
Do you know about when that was in relation to when you received it?
Yeah, so we got the phone in January. It took, I believe support came out in, I want to say May or June, I don't remember the exact month, but we didn't actually get the passcode until August 16th of 2022.
And once that passcode was actually broken into by the Gray Key device, then you're able to look into the phone, is that correct?
Yes, once the passcode's obtained, we download the data, and then we're able to take that extraction data and then open it up in Cellbrite or Axiom or whatever tool we're going to use to view it.
And then you can go ahead and thumb
And the
through the
tools,
phone
as far
for
as you're referring
nudes.
to, Cellphone and Axiom, are you familiar with those tools through your course of your investigator with regard to electronic devices?
Yes.
And if you could explain to the jury sort of when you say Cellphone and Axiom, as far as then tools are concerned, how do they work and sort of what is it that you do with the device with reference to Cellphone?
So what do we do with the extractions once we go to open them?
Well, how is the information extracted, first of all, and then what, if anything, do you do with that?
So Gray Key will pull the extraction. It just, once the code's received, it again uses its software, pulls the data out, puts it into an encrypted, it's MD5 or SHA. It's a encryption key that has, it's a unique key that, so if you changed anything inside that zip file, it would change the encryption number to show that something was tampered with. We take that encrypted zip file and we open it up in the software, and that's able to say, you know, the call logs, the chats, the photos, the whole timeline of the phone.
But
Now, in
we can
addition
talk
to
about
yourself,
this
is there
some
anyone
more.
else that works in this sort of capacity within your unit at the district attorney's office?
Yes, two
They
other
can't
people.
selectively
Who are those
extract
two?
data.
The director of our lab, Samantha Vogt, and Trooper Connor Keefe.
They extract it all.
Now, beyond
and then
yourself,
pinky
Chief
swear
and Ms. Vogt,
they're only looking at the stuff in
anybody
the
else
warrant.
from the detective unit, as far as the troopers, would they have access to these devices, being defendants, Mr. O'Keefe's, Ms. McCabe's, or Ms. Roberts?
If they're in the digital evidence lab, no. Once the data is extracted from them, normally we give them back to the investigator or return to family. So that would be the only time that they would have access to the devices, or unless we kept them in the lab for just for, I don't want to say safekeeping, but just for storage reasons.
Now, with reference to your review of any of the extractions related to any of those 4 devices, at any point in time, did you observe anything in reference to any information being taken
Now
off
that is
or
very
deleted from any
interesting.
of those
I
devices
would love
at
to
any
know
point in time?
more.
No, sir.
Now, with respect to Ms. Reed's device, the defendant's device, it was sometime in August of 2022 that the Gray Key was able to break into the passcode to get into the device, correct?
That's correct.
And so then, once an extraction is done, that's then subsequently reviewed by someone within your unit, is that correct?
Yes, so again, normally the investigators for the homicides know far more information about the crime and what occurred. So if need be, I'll load the phone up for them. They can go through it because they know what they're looking for. If they ask me, I'm happy to go through. If they can say, you know, I'm looking for calls between this time period, or, you know, GPS locations, things like that.
Now,
Shouldn't the warrant
with reference
tell
to
you what
the
you're
defendant's
looking
phone, at
for?
some point were you made aware that there was some privileged information contained within her phone?
Yes, I was.
So as a result of that, what, if anything, happened with the phone from there?
We notified our supervisors, and we did not look at her extraction until the privileged communications could be removed, and then we could, again, go back and re-inspect the data.
Now, as far as that whole process that was undertaken in regard to that, how long a time period, or when was it that you were able to have the privileged information extracted and then actually get to look at the defendant's phone?
It took months. I don't think we got it back from the AG's office until later, I don't know, springtime of 2023-ish.
Now, with respect to the extraction from each of these 4 respective devices, that being the defendant's, Mr. O'Keefe's, Ms. McCabe's, and Ms. Roberts, what kind of tools were used to conduct those extractions?
Gray Key, Windows 10, and then Cellphone Physical Analyzer and Axiom, their program, Magnets program.
And so as far as, I guess my question is, as far as the different devices that are used, why are there different devices, and what is it that, say, one does versus the other?
So they both do great work with, you know, decoding the data. I've noticed that Axiom does a better job at pulling GPS spots because it gives a
the honor
speed
system.
and a estimated range of how strong the GPS signals are, as opposed to Cellbrite. They give native locations, but they don't have that extra data with it. So I like to look at both tools to make sure that I'm seeing everything that I need to.
Now, with respect to the defendant's phone, you at some points reviewed the extraction from the defendant's phone, correct?
Yes, I did.
And with respect to that phone, what, if anything, did you observe with regard to GPS locations associated with that device?
I didn't see that many, maybe a handful showing different spots in Canton, but nothing that stood out to me.
Now, with respect to your review of the phone, what, if anything, were you able to ascertain as to whether or not those GPS locations were allowed or permitted or turned off or on by a user?
I can't say. I didn't see anything, like I said, that stuck out to me. Normally, if the GPS points aren't there, then location services are probably turned off.
But what I'm asking, though, is the device itself was capable of retaining that data as far as GPS locations, correct?
Yes, if it's turned on.
And there were no real GPS locations to speak of that you observed in your review of the extraction of the defendant, correct?
But there were
Yes, that's correct.
some. So why were
Now,
there
with
some?
regard to Mr. O'Keefe's phone, what, if anything, were you able to ascertain from that as far as GPS locations were concerned?
There's quite a bit, especially on January 29th.
Now, sir, before we get into that, if I could ask you some questions in regard to Ms. McCabe's excuse me, phone extraction. You had occasion to review that, is that correct?
Yes, sir.
And so, in regard to that also, you had mentioned that you had reviewed an affidavit from a defense expert or defense witness named Mr. Richard Green, correct?
That's correct.
And based on your review of that, what, if anything, based on your review of what Mr. Green said or did, what, if anything, did you then do with regard to Ms. McCabe's phone?
So I basically went point by point through his report to confirm or deny if what he was placing in there was true.
And what, if anything, were you able to ascertain or learn from going through Ms. McCabe's phone with reference to what Mr. Green stated? Objection.
I'll allow that.
It was mostly incorrect.
And when you say mostly incorrect, what was mostly incorrect?
So he states that there's a Google search that's done at 2:27 in the morning. That immediately stuck out to me because when I went back and looked, that file that was parsed was not from the database that should have showed searches. This came from the session state tabs for Safari, which is a big red flag. It also came from a wall file, which is a dropping ground for where data is put before it's actually put into the main database itself. And then once it reaches a certain point, that data is automatically deleted by the device, not by a user, which Mr. Green had stated that a search was done and then it was purposely deleted. There was also items regarding phone calls being deleted. Again, they came from a wall file. Looking at it, again, it's stored in the knowledge seed, the main database. It's also stored in the biome, showing in the extraction, which is another storage area that Apple is using. Again, nothing.
Was it in history?
Most of the stuff that I was reading in his report was either incorrectly, I don't know, written down, or he's interpreted it incorrectly.
Now, with regard to the phone calls or the contacts that Mr. Green indicated were user deleted or deleted by the user, what, if any, information did you look in regard to that? What, if any, did you ascertain in regard to that?
Yeah, so he stated that Ms. McCabe had deleted 18 phone calls from the morning after John O'Keefe's body was found. looking at the data from her call log, those calls, while they do show marked as deleted, again, they come from the wall file and they're also located in 2 other parts of the database. Again, as a user of an iPhone, you can't go in and just delete these files. They're handled by the operating
Can't
system.
delete your call
It's
history?
impossible.
So as far as, what if any opinion do you, well, let me ask you this first. As far as a wall of a writing log file, can you explain that, what you understand that term to mean to the jury as it pertains to these particular items?
Yeah, so as I said, these files are dropping ground. So when you're using your apps, using the phone, takes that data, puts it into this wall file until you either close the app or you shut down the phone, or it reaches a certain number of data in the phone. That wall file will automatically delete from the phone. So this can be on a first in, first out basis. Again, like I said, it could be when data reaches a certain level, but those calls that are being marked as deleted, Cellbright's seeing, it doesn't mean the user deleted them. It just means they're being removed from the wall file.
You indicated that from your review of the phone extraction, there were other areas or other databases, within the phone.
Don't I remember Jen McCabe explaining at some point that she just
so the
always
main
deletes
database
call
of the
history?
iPhones
She does it all
is
the
the
time.
Knowledge C database. They're also using Biome, and then if you're using the newest software now, it's another area I won't bore you with, but depending on the iOS you're using for the phone, it's going to depend on where that data is being stored.
Now, specifically with respect to Ms. McCabe's phone, one of the contentions Mr. Green had was in regard to a contact for Brian Albert. Is that correct?
Yes, that was another one.
With respect to that, what, if anything, were you able to find within Ms. McCabe's phone in regard to contact information for Brian Albert?
Yeah, so Mr. Green's report said that he located a deleted screenshot of Brian Albert's contact. That was in her phone. The contact for Brian Albert was still in her phone, not deleted. So I don't know, maybe she just deleted the screenshot.
Yeah.
Now, with respect
So he was
to
right?
Ms. McCabe's phone, what, if anything, did you do with regard to the call log history in Ms. McCabe's phone?
I exported it all out to a PDF so I could view it. And again, like I said, there's, I think, 1,104 phone calls from going all the way back to October of 2020, I want to say. And phone calls, FaceTime, they're all, the calls are there, all the records, and they're all stored in different areas of the phone. The only ones that show the wall file deleted were the ones from the 29th going up to the end, towards the end of the day on the 29th.
So
And
those
now,
are
with
the
respect
only
to
ones that the wall
call
files
history,
deleted.
where or how is that typically stored within an iOS device?
I believe that's stored in the call stored dash SQLite database.
And with reference to what, if any, difference storage-wise is that SQLite database versus the wall file?
So again, yeah, that database where the call logs are sent, it's going to have a corresponding wall file where the data is going to be put temporarily. And then, as I said, it gets automatically deleted by the iOS, by the operating software. It's not user enabled.
And so from your review of those 1,104 phone call history records containing extraction of Mr. McCabe's phone, what, if any, opinion do you have in regards to whether or not those items were deleted by any user?
I don't believe they were. And actually, I will say one of the phone calls was from the actual main call stored database. That could have been user deleted but again, it's in 2 other spots in the operating system. So I don't know how or why the iOS stores it the way it does. And then marks what.
So you don't know, but you're sure she didn't delete them.
Now,
Why
sir,
were the
from,
wall files deleted only for those calls on the
from your
29th if
review
this is an
of,
automatic process?
Before phone extractions that you reviewed in this case, were you able to export or print certain chat reports from specific people's phones or between, from specific people's phones with other individuals?
Yes, I was able to.
And Your Honor, may I approach?
Yes. Yes.
I got a theory why we're getting into Jen McCabe, and it's because they knew. They have to, if my theory about the civil case is why they're fighting this so hard, it's because they knew her records were falsified.
Sir, I'm showing you what's been marked as Exhibit 48.
Okay.
You recognize, excuse me, do you recognize that, sir?
Yes.
And what do you recognize as?
The first page is Facebook Messenger chats between Karen Reed and John O'Keefe.
And what's contained in there, is that a fair and accurate portrayal of what you observed from the extraction from Mr. O'Keefe's phone?
Yes, it is.
And specifically with reference to those chats between Mr. O'Keefe and the defendant, you also reviewed that material from the defendant's phone as well?
Yes, I did.
Material that you reviewed from the defendant's phone, is that consistent with what you observed in Mr. O'Keefe's phone?
Yes, it is.
Did he just say kill me?
Your Honor, with the court's permission, if I could request.
Did he
certain
just whisper,
portions of
"Kill
what's
me"?
marked as Exhibit 48 being published to the jury as we go through them.
Okay.
What?
Sir,
He
if I can just
did.
start you out on
You guys
page
heard
one.
that too.
Okay.
Ms. Gilman, if I could have that up on the screen.
What is happening?
Now, with respect to what's up on the screen, the portion that you can see, do you recognize this, sir?
Yes, I do.
Now, we have before you as Exhibit 48.
Yes.
Now, within this particular, from the perspective of this is from Mr. O'Keefe's phone, is that correct?
Yes, it is.
So there will be blue bubbles and green bubbles, is that correct as well?
Yes.
And so who, as far as the blue bubbles are concerned, who is speaking in that?
The blue bubbles will be from Miss Reed, and the green bubbles are from Officer O'Keefe.
Guys, I took the timestamp
Ms. Gilman,
down.
if
We'll
you could
go
please
back to
scroll
this
down.
at the end. We'll double check that.
Now, with respect to what's contained on this page one at the bottom, if you could read the date and the time and indicate who is speaking and what is said there, sir.
Yep. So the blue bubble is Karen Reed and 1/28/2022 at 3:30 p.m. Hello. John says hi at 3:35 p.m.
Sorry, may I
Yeah.
approach now?
Yes.
Yep. Those are the Facebook ones.
I'm sorry. What's contained in Exhibit 48 is the entirety of the chat report from Mr. O'Keefe's phone, correct?
Yes, I believe so.
May I approach, Your Honor?
Yes.
I apologize. Showing you another document. Do you recognize that?
Yes.
What do you recognize that to be, sir?
These are the native chats, native messages from John O'Keefe and Karen Reed.
So these are just specifically broken down as far as the chats between Mr. O'Keefe's phone and Ms. Reed's phone, correct?
Correct.
And as far as your review of both of the extractions from both of those phones, the material contained within Mr. O'Keefe's phone is consistent with the material contained in the defendant's phone, correct?
Yes, that's correct.
Your Honor, may I approach?
Yes.
Commonwealth will seek to introduce the witness and next exhibit. Okay.
Okay.
Well, that's going to get clipped. Aussie insiders on
Yes.
that one.
That could be returned to the witness, Your Honor, if we could, with the court's permission, if we could publish that.
Yes.
Great.
Some more texts. We didn't get enough from the Higgins text. We got to get theirs too.
And now, Trooper Guarino, do you recognize what's up on the screen as the next exhibit, sir? Ms. Gilman, I'm sorry, if you could scroll down just a little bit.
Yes.
And again, from this first page, if you could, the blue bubble is from Ms. Reed, is that correct?
Yes, that's correct.
Being from Mr. O'Keefe, is that correct?
Yes.
And if you could, again, read from this first page as far as date, time, who is speaking, and what is said.
At 9:49 a.m., Karen says, "You've really hurt me this time." 10:02 a.m., "I'm sorry. This is, sorry, it's kind of hard to read. I'm sorry, this has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them, and I'm forced to always be the bad guy." At 10:09 a.m., Karen says, "I am not the same as everybody else. Most of the time I try to do what is healthy/smart for them. More importantly, I try to support you and what you need. You just lashed out at me and said terrible things. I don't know how you've gone to this point with me, but I'm just trying my hardest. You made your point and continue to beat me down. I have a lot going on too. Physically, I'm falling apart and trying to get answers and help."
If I could stop you there, sir. If I could direct your attention to my apologies. Sir, if I could direct you to page 5.
Okay.
I'm sorry, bottom of page 4.
All right.
Wait, so now we're skipping around.
And starting with the blue bubble on the bottom of page 4, again, if you could indicate as to who's speaking, what is said, and the date and times.
I thought we were just getting into motive stuff
Karen
right
says
there.
to John at 1:21 p.m. on the 28th, "Maybe you can call someone."
If you could continue on and through page 5, sir.
On the 28th at 1:46 p.m., John says, "Like who?" On 1:47 p.m., "What time are you coming here?" And then there is, at 2:05, there's a message but no content.
And the next message at 2:06, sir.
Yes, 2:06 from Karen. "I don't know what time, feel kind of out of it, just trying to clear my head." 2:06 p.m., John writes back, "Okay." 2:06 p.m. again, Karen says, "Text me later when you guys settle in later." Text me when you guys settle in later. John says, "Sure," at 2:06 p.m. again. Karen says at 2:16, "I feel pretty shitty about this, feel pretty shitty about how this morning went down. I know you said sorry, but it really stung, especially when I've been trying pretty hard lately. I feel like a loser turning around, just coming back over after everything you said."
Yeah, because he doesn't
If I
treat
could
you
ask
very
to
well,
continue
huh?
on to page 7, sir.
Okay. At 2:17 p.m., John says, "Not sure what else you want me to do." I said, "I'm sorry," and I was out of line. "If you prefer to stay home, I totally get it." Karen replies back at 2:17, "Things in my own life have been difficult too, you know." John writes back at 2:17, "I know." At 2:25 p.m., "Tell me if you're interested in someone else. Can't think of any other reason you've been like this." From Karen.
You could continue on to page 8, sir.
At 2:25, John responds back, "Nope. Things haven't been great between us for a while. Ever consider that?" That was at 2:26. At 2:29, he writes, "Kids are here, not in the mood to talk."
And how does the defendant respond to that on the bottom of page 8?
So you're not into it anymore. That's fine, but I don't want to keep trying, and you keep treating me like this.
Yeah, there's one
2:29
person in
PM.
this conversation who seems angry and hostile,
direct you
and
to,
one that
next
seems
page
hurt.
9.
Yep. Ms. Reed says, I'm trying to hug and kiss you this morning, and you whack me in the face with a pillow at 2:29. At 2:30, she says, last night you're basically like, yeah, what about? When we talk about the future, so why don't you just admit you're not into it so much anymore?
Well, Karen, because he's getting what he wants from you.
2:30.
He's using you
Oh, sorry.
Go ahead.
for the
Oh, so at
babysitter with
2:30,
benefits.
John says, not how it went down, but okay.
Now does Ms. Reed respond to that?
Can you please admit your head is out of the game with us?
If you could, sir, please continue on to the top of page 10.
Okay. At 2:32 p.m., sick of always arguing and fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently. From John. And then John again at 2:32. Oh my God, stop calling.
Okay, stop you there for just
Okay.
a moment, sir. With regard to January 28th,
She's not the one
we're
that looks
also
bad
able
in this
to
exchange.
extract a report specifically in regard to calls received by Mr. O'Keefe on that date.
Yes, I was.
I mean, on that date into the next date of January 29th.
Yes.
I approach Your Honor.
Yes.
Me too, Brittany. Me too. She is not looking like the bad guy here. I said I'm sorry. What more do you want? Ugh.
There we go.
Tell me you understand nothing about reconciliation and apologies. I want acknowledgement that you understood that you hurt me, that you had an effect on me, and you understand how that happened, and so that you will make an effort and a commitment to not do that again. That's how reconciliation works. Not, I'm sorry you got your feelings
Guarino showing the
hurt.
document. That'll help him finish.
Okay.
You recognize that, sir?
Yes, it's John O'Keefe's call log.
And that's the entirety of the call log from January 28th into 29th, is that correct?
Yes, from 20th at 9:19 a.m. to the 29th at 6:03 a.m.
May I approach, Your Honor?
Yes.
I'm about to seek to introduce the minutes on next exhibit. No objection.
Okay.
Yep, there's that whole thing about some men are incapable of seeing women as people. They can only see them as prospects. And that's a pretty good indication. Is this guy a friend? Does he treat you like he treats his friends? Or not? If he treats you like not like he treats your friends, you're probably not a person to that
Another
guy.
documents, just ask you to review that, look up when we finish. Do you recognize that, sir?
Yes, this is Karen Reed's call log from January 29th at 12:33 a.m. to January 29th at 6:03 a.m.
And those are specifically calls between the defendant and Mr. O'Keefe, correct?
Yes, that is correct.
May I approach again, Your Honor?
Yes.
I'm off to seek to introduce the minutes of next exhibit. No objection.
Oh, she blew up his phone because he's being a dick?
Thank you.
Now, Trooper Guarino, from the text messages that you were just testifying from, Mr. O'Keefe indicates OMG stopped calling at 2:32 p.m. Is that correct?
Yes, that is correct.
Now, from your review of those call logs, how many times did the defendant call Mr. O'Keefe on January 28th from approximately 9:19 a.m. to about 2:58 p.m.?
There's 18 calls from 9:19 to about 2:59 p.m.
Those calls are listed
doesn't
within
seem
those
that
records
bad.
as various, as far as rejected, or missed, or answered, or things of that nature. Is that correct?
Yes, that is correct.
How
And
many
he
of them are
rejected them all?
rejected?
11.
How many of them are missed?
4,
And how many are answered?
3.
Now, following that text message at 2:32 p.m. from Mr. O'Keefe to the defendant asking her to stop calling him, does the defendant keep calling him?
Yes, she does.
And at some point, does Mr. O'Keefe call Ms. Reed back?
Yes, at about 3 p.m. on the 28th. Double check.
Thanks.
So she's learned what she has to
approach
do to
her.
get his
Yes.
attention.
Mr. Guarino, I can take each of the call logs. I want you to keep them on a second.
Okay.
She was dying for him to be an exit ramp. And he couldn't do it.
Now, sir, if I could turn your attention back to page 10 on those text messages with respect.
Okay, so, Mr. Lally, when you put your head down and when you walk away, we can't hear you. And so there won't be a record of this, so you have to keep your voice up.
I will do, Your Honor. My apologies.
Well, you just said, you just put your head down and your voice went down. So keep your voice up. It's really important you do so.
Trooper Guarino, turning your attention back to page 10 of these text messages, let's read from Ms. Reed's response to Mr. O'Keefe at 2:32.
Yes, so 2:32 p.m., she says, why would you start with me this morning? And then followed up by 2:33, you're setting me up to fail.
If I could turn your attention to page 11 and ask you to continue from there.
Ms. Reed says, you start a number of fights from your end. John, and that's at 2:33. At 2:33, John writes back, I've explained it a few times already, not doing it again.
And how does the defendant respond to that?
So you're not into this anymore. And then John says, not into fighting all the time, correct. That's at 2:34 p.m.
Yeah, it's her fault
If I
that
could
they're
turn your
fighting all the
attention to the
time,
top.
not because he was an asshole.
Yes, 2:34, Ms. Reed says, if you tell me you're interested in someone else, you will never hear from me again. You can have all the space in the world. John writes back that there's no content at 2:34. And then at 2:34, she says, then stop starting with me.
How does Mr. O'Keefe respond to that?
At 2:34, he writes back, I'm not answering, stop calling.
And if you could, if I could turn your attention to the top of page 13.
Ms. Reed says, can you please answer after how you treated me earlier? John responds back at 2:35, Kaylee is right here. Ms. Reed says, you're starting a rager with me out of nowhere, and then you tell me you're sick of fighting with me at 2:35. She writes at 2:38, I'm going to grab a drink in a bit.
If I could direct you to the top of page 14, sir.
She says, can you answer please at 2:38? He writes back at 2:39, no, Karen, not sure why you need to announce that you're going drinking, but have fun. Karen writes back at 2:40, seeing if you want to meet me later. Can you please call me right after that?
And again, if I could direct you to the top of page 15.
John writes back at 2:40, have to take him to the doctor, he has practice. Ms. Reed writes back, yeah, 5 minutes. John writes back at 2:43, my father just walked in. Aaron writes back, okay, can you please call me for 2 minutes at 2:44.
The top of page 16, sir.
2:44, John writes back, not right now. Aaron writes back, I'm there when anyone else needs me at 2:44. At 2:46, yes, John, you gave me utter grief this morning. I'd like you to call me for a minutes.
And the last one from that page, sir.
Yeah, at 2:47, I've been trying to get over the hump with is arguing, and now you tell me you're not into things. And if you don't want to fight weekly, but fly off the handle at 8 a.m. with me, like you're setting me up to fail.
Sir, if I could draw your attention to
Yeah, she's
Page
there when
42.
they need her, but when she needs them, where are they? It's not a good time.
And sir, if I could ask you to start reading from the top of page 42.
Yep. At 7:41 p.m., Karen writes, okay, let me know if you end up leaving. John writes back at 7:42, why? Now you're not coming? Karen writes back, I'm waiting for the plumber. Actually think he's in the driveway. 7:42. John says 7:43, we're taking Mike's car, so I'm relying on you for a ride home if he leaves. Karen writes back at 7:43, he's not
So
going
did they
home
talk
after.
in the meantime?
John writes back at 7:43, 8 on a Friday. He may have to get Michael. And you have a plumber coming over at 8, knowing me and Papa could have handled it. Good luck. And that was at 7:44.
Thank you, sir.
Well, but did you?
If I could direct your attention
Are you handling
to
it?
page
No, you're
49.
out drinking with your buddies, not handling the plumbing problem.
Okay.
If I could ask you to start from the page of 49, page 49, sir.
8:29 p.m. Yeah, but he lives right down the road. John writes back at 8:30. Karen, this storm is going to be intense. Can't drive. 8:30. She writes back, okay, well, if he can't, he can't. John writes back, I'll do it Monday. Karen responds at 8:31. Ha, I better not still have this problem on Monday. John writes back, plan on being there. Karen writes back at 8:32. I'd like to know, I could take a hot shower here if I need to. John writes back, figured you'd be in Canton until Monday.
Your hot water heater went out.
If I could direct you to the top of next page, 51.
John, I'm getting off my phone. Let me know what you're doing. Karen writes back at 8:33. I think the four of us together is toxic to this relationship. Would like to limit it. And says, you've said so yourself for probably a year now. And John writes back at 8:33. Blizzard tomorrow. Nobody is going anywhere.
Sir, if I could direct you to the top of page.
Well, that's the
52.
answer for the
Okay.
toxicity. You're stuck in the snow.
Karen says, maybe I'll come back late tonight. Bad snow is in the early AM. That's at 8:35. And again, 8:35. I'll head up there in a few minutes. Let me know if you leave. John replies back, sure. And then the next one's not until 12:55 AM on the 29th. I'm going home.
And the I'm going home is from the defendant, 12:55 a.m., is that correct?
Yes, that is correct.
And if I could direct your attention to the top of page 53.
Yes, 12:55 again. See you later. At 1:02, your kids are cucking alone. 1:29, 1:04 a.m. I'm back in Mansfield. The kids are home alone.
Thank you, sir.
Which is obviously not true,
Sir, may I approach
but
the
he's
retreat?
not answering
Yes.
her.
Can I see counsel at sidebar about scheduling?
So that's where we're ending today. Yeah, she's trying to put pressure on him to get him to answer because she's learned he doesn't give a shit about whether she wants to talk to him. That's not what matters. His convenience is what matters. This was justice for John, man. This is what they wanted. She's supposed to look like the bad guy here? I ain't seeing it. No, she didn't leave the kids. She was there the whole time. That's where she was in the morning. She's just telling him this to try to get his attention so that he will get in touch with her. She's trying to put some pressure on him,
This
thinking, well,
witness, but
maybe
Can we go until 4:15? I know it's been a long day, but. does
if
that
he
work
doesn't
for you
care
all?
about me,
All right, thank you very much.
maybe he
So
cares
let me
enough
do that.
about
We'll
them.
talk about scheduling after.
You are unmuted.
May I have one moment?
Yes.
So Bev's going to get another 10 minutes out of this guy.
May I approach this retreat?
Yes.
Now, Trooper Guarino, you were also able to get some chats as well as some phone calls between the defendant and certain individuals. Is that correct?
Yes.
And may I approach, Your Honor?
Yes.
And certain individuals. I sure hope we're not going to revisit Higgins. Talk about kill me. So this is what she's supposedly texting him to cover up for the fact that she hit him with her car. That's the theory, right? This is her alibi, Not buying it.
Documents, just have to review those.
I'm going home.
Okay. Okay.
And do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
The single page is Karen Reed to Laura Sullivan phone calls, or I should say, yep, calls from Laura Sullivan to Karen Reed. And the other one is Karen Reed and Laura Sullivan's chat messages.
What's contained in those documents, is that a fair and accurate portrayal of what you were able to extract from the defendant's phone?
Yes, sir.
May I approach again, Your Honor?
Yes.
I'm about to seek to introduce the minutes and next exhibits. No objection.
Okay.
Oh, so is here where she confesses to her friend to hitting John with her car? Is that going to be in here? Let me guess, no. Kind of guessing it's not.
Thank you.
The witness said it. We're gonna go back once the day is over. We're gonna rewind to that and watch it again. It's just so unbelievable. The witness said, "Kill me." He whispered, "Kill me," into the mic. Yeah, this is what I've been saying. Yes. I'm so glad we were able to make up.
Yes,
and
these
and that
are
you've reaffirmed your commitment
Karen
to me.
Reed and Erin O'Keefe phone call.
And what is contained in that, is that fair and accurate portrayal of what you observed conducting the extraction of the defendant's phone with regard to the communications with Erin O'Keefe?
Yes.
May I approach again, Your Honor?
Yes.
I want to seek to introduce the minutes and next exhibit.
Okay. There's no objection, Ms. Giannetti, right?
No objection.
May I-
6:32.
I'm very sorry, Madam Court Reporter. Your Honor, may I approach the witness?
Yes.
I'm showing you what's previously been marked as exhibits 51 and 52. That's if you recognize those.
Yes, these are phone calls between Karen Reed and Katie Camerano. And 52 is chats between Karen Reed and Katie Camerano.
I approach this to retrieve, Your Honor.
Yes.
What's contained in those exhibits 51 and 52, is that a fair and accurate portrayal of what you observed during the extraction of the material from the defendant's phone?
Yes.
Let me guess. She's like, "What's his problem? What's the matter with him? Why is he such a piece of..." I'm just guessing. Having some girl chat with her friends about how much he sucks.
Yes.
So showing you what's marked as exhibits 94 and then 95.
Yes. Sorry. They are chats between Karen Reed and Jen McCabe, text messages. And 95 is Karen Reed and Jen McCabe phone calls.
And again, what's contained in those records before you, is that a fair and accurate portrayal of what you observed in the defendant's phone during the course of the your extraction of materials from her phone.
Yes.
I approach the retrieve, Your Honor.
Yes.
So these are already in evidence, Mr. Lally, so that you don't need the fair and accurate depiction.
You don't need to redo the foundation, even if you're just killing time till the end of the day for some reason. What, you had really wanted to end with those texts?
May I approach again, Your Honor?
Yes.
Riveting, Mr. Lally. Quite the presentation you got going here. I'm sure the jury is fascinated, hanging on every word. Yep, this is the cycle. This is the cycle. She gets that dopamine rush when he actually gives her attention and affection, and she just
Julius,
keeps
you know what? I'm
chasing
going to
it.
send you home. Okay? So
Yes, thank
I
you.
need to see
Thank you,
counsel outside
Judge.
that for just a minute to figure out the next 2 days.
You are muted.
Wow, Bev. You made him do another 15 minutes, and that's what we got out of it? Oh, yikes. Yeah, this is, you know, this is an emotional abuse cycle, is what it is. There's the honeymoon stage. You butter them up, love bomb them. Then there's the devaluation stage. You start treating them badly. Goes back and forth until you get to the discard. Abusers rarely discard, though. They don't. It's the cycle that they're invested in. The abusers rarely leave. It's the victim who finally sees the light. We hopefully, at some point, recognizes, you know what? I shouldn't take this. I deserve better. And they leave. Gets a lot more complicated when that abuse involves physical abuse too, but we don't have any indication of that here. No indication of that here. But emotional abuse, yeah, I think that's what we're seeing. I think that's what we're seeing. Lack of concern for her needs. The withholding, the withdrawing. No, I won't call you. I won't even pick up the phone.
Jurors, we will
You
be
are
in session
unmuted.
tomorrow, but you won't be. All right, so it's very important that you don't watch TV or listen to anything, or read about anything. So we will be here tomorrow. Wednesday is the federal holiday, so we're not in session. I know there's supposed to be some big heat wave this week. I really appreciate that everybody dresses respectfully for court. I suggest you come in comfortably. It's an old building. The air conditioning's been great today. I don't know that will hold up when really pushed. So feel free to dress comfortably. We'll plan on seeing you on Thursday. If that changes, the court officers have your contact information. But we're planning on seeing you on Thursday. All right, so please, those three cautions.
Back
do not
Thursday, if
discuss
that
this case with
changes.
anyone. Don't
Why?
do
Because
any
it would
independent
take-
research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. See you
Take too
Thursday.
long
All rise for the
to
court,
get through
please.
the voir dire? That's kind of what I heard. That's kind of what I heard. We appreciate you
All
dressing
right, and Trooper, you
respectfully,
can just
but
follow out behind them, okay? Thank you.
go ahead and disregard that on Thursday. I'm expecting it to be on the record. Let's see if she says anything, but it should be. The voir dires so far have all been on the record. It is an open hearing. It is part of the process of deciding if they're going to be admitted or not. So it should be. There's no court on Wednesday. Tomorrow we are scheduled for the voir dire of the defense witnesses. As far as we know, that's the last thing that we heard. Yeah, I mean, she wasn't giving it back, right? It's not like she started insulting him or abusing him. She's begging to be heard, and he's refusing. That doesn't sound so bad to me. Yeah, kind of does, doesn't it? And that's why Jen couldn't wait to get that out there. She just couldn't wait to rub that in on Karen because she knew it would hurt, because she would know it's true.
See you tomorrow.
So all we get is see you tomorrow. No information for us, the viewers. I'm going to be here tomorrow, assuming that yes, we will be able to see the voir dire.
Depending on how it goes tomorrow.
And now we go to, all right, guys, let's get back. Oh man, I'm going to have to do math in my head to where he said, kill me. Okay, that's the Celebrate guy. That was the chip. Ugh. Okay, wait a second. 7, it's about another 5 minutes ahead. Should be like somewhere right in here.
You are unmuted.
All right, Mr. Lally, you can continue.
So Trooper Guarino, there was a Dell laptop and an HP Pavilion all-in-one desktop, correct?
No,
Yes.
I have
These
to
were
find
taken
it.
from Mr. O'Keefe's just in general about a cell phone extraction. You familiar with that term?
Yes.
And can you explain to the jury sort of what is involved in that? And,
To give us a different...
how a cell phone extracted?
And then we're able to take that extraction data and then open it up in Cellbrite or Axiom or whatever tool we're going to use to view it.
And the tools, as far as you're referring to, Cellbrite and
Oh,
Action.
guys, I'm gonna have to hunt it down. I'm gonna have to hunt it down. Sorry about that, but they give us different timestamps depending on whether you're looking at from the beginning or from the end here. So that's kind of annoying. Well, I mean, we heard it. We heard it. We heard it. Yeah, it's right after he gives them the Facebook messages. But I'm going to have to see if we can pick that up with the just quick little forward right here.
Yes.
Just trying to see here. Is it here? No.
Yes.
I can't find it. Okay, Jeff's got it. Jeff's got the timestamp. Okay. Okay, let's figure this out. Let's get out of that. Okay. Jay got it. Jay got it for us. Okay. Let me pull it up. We weren't the only ones that saw it, guys. We're not crazy. We're not crazy. Let me just get it queued here. All right. All right. Here it is.
Is that consistent with what
Watch
you observed
carefully.
in Mr. O'Keefe's?
Yes, it is.
He
And
said
Is
it.
that consistent with what you observed in Mr.
He
O'Keefe's?
said it.
Yes, it is.
You can see him say it into that mic.
And phone, is that consistent with what you observed in
Unbelievable.
Mr. O'Keefe's?
Yes, it is.
One more time. Yeah, he absolutely did. I mean, crazy. Crazy. I can't believe. I just can't believe. I can't believe that a witness would do that. A law enforcement witness on the stand would... He leaned into the mic to say this, okay? This is not like an accidental hot mic moment. It's right there. It's right there. Is he sending us a message? Is Trooper Guarino sending us an SOS? I mean, maybe he doesn't like being part of this, but here he is. Here he is. You know, you could tell us a little more about Trooper Proctor and his access to things and the things that he did and so forth if you really wanted to be helpful. You could do that. Well, guys, what did we get today? What did we get? What did we get? We already talked about Trooper Paul and that absolute bloodbath. Absolute bloodbath. So then they really couldn't wait to get that in the rear view. So they gave us Ian Whiffen. And Ian Whiffen gave us a fairly technical and convoluted explanation of the Cellbrite records that was very difficult to understand and really not clear what he was looking at or how. And he spent quite a bit of time talking up his own software program. Not quite sure why. But talking up his own software program that seemed to show the internet activity at very different times then Jen McCabe was telling us the internet activity took place. She's got the Raining Men thing happening in the Albert's house, right? And very specifically, they all remember. Isn't that a coincidence? They all remember because this is a family joke. So she pulled up that video to show them. Except it happened a couple days before that, according to the search records on this guy's program. And then the Hockomock sports stuff, that was the day before. She said she was doing that in bed. That was her explanation for what she was doing in bed before she shut off her phone. Oh, I didn't get his explanation. Okay, here's what I wrote down for what he gave us for his final conclusion. His conclusion: the tab used came into focus at 2:27:40. It was opened, used to see Ozone basketball and all the Hockomock sports. The search was done then at 6:23, but never loaded. While in the page, she did a second search for Hoslong to die in cold, which also never loaded. She closed Safari before the search results completed, and then reopened it at 10:33, which is when the page successfully loaded and got us another timestamp now for Hoslong to die in cold of 10:33. I don't understand how she would have a search not loading that is continuing to not load while she is searching in the same tab for another search. She would have to open a new tab. Otherwise, that old tab would close out and then the wall file would have been written over, right? Isn't that how we explained how that works? We would have had that record for failure to load. That would have been documented. It's only if the tab stays open and continues to run that it doesn't. But you have to make that work with another search in the same tab. You can't have two searches running in the same tab at the same time. I didn't understand that at all. So he has an explanation. It's different. Seems to be different from Ms. Hyde's explanation, kind of, but also kind of the same. But there's still more timestamps, right? Still an entirely different process than she described. And then we got to cross, and he basically acknowledged, yeah, there's ways that you could do that. It would take some skill, it would take some knowledge, but you could go in and use your SQLite viewer and just rewrite the code. Renumber those history, the history database so that it would hide your deletions. His whole explanation for why is this stuff in the wall file, but it's not in the history, and it's not in the search records, is because the history could not have been deleted. But then he just conceded on direct, yeah, it could. It would take some skill, but yes, it's possible. Okay, well, then you've told me, you've told me that I may or may not be able to rely on this information that you've provided with me. And that it would show, modifications would show in the hash, but he didn't get the hash. He didn't get the hash data. He didn't get that. Now more of this selective providing of information to the experts. Why didn't he get the hashing? Is that a normal thing to withhold? I don't know. Seems like it would be important that you'd want to look at that because, yeah, you'd want to see if there's been any modifications. You would check that. So wouldn't you ask for the hashing? And then restated his conclusion on redirect to make it even more definitive. He's of no doubt the only time those searches were conducted. Absolutely no doubt was at 6:23 and 6:24. Okay. But it's just a big sell. It's just a big sell. So now everybody is just waiting to hear from Mr. Green. The stage is set for Mr. Green because they've tried so hard to sort of pre-bunk him. And what do you think the odds are that they have steel-manned Mr. Green's argument before criticizing it here to the jury? What do you think the odds are of that? Do you think that's what they did? Do you think that they were very generous and gave him every benefit of the doubt in describing what he did and what his conclusions were, and then showed how those were wrong? Or did they, I don't know, caricaturize them, draw them as an extreme, as something other than what they were, and criticize that instead? Guess we'll find out. And so now from Trooper Guarino, we have learned he couldn't read Lexis codes. He had to destroy the computer board to get the memory chips off, which apparently is something that nobody else who works on computers has to do. Couldn't read the code that it took someone in the chat 5 minutes of Googling to diagnose. It was an ignition error, code 14. That was all he was able to extract from the diagnostics. So they never got anything from the infotainment system. Got some, but not Google location data from her phone, like not comprehensive. So why does she have some and not all? I don't know. She had Google location services turned off sometimes. An explanation for that would have been good, but we didn't get it. Which locations are there and when are those locations from? That would have been nice to know, but we didn't get anything. We didn't get any clarity about that. We learned that neither of the computers in the house accessed the Ring video at any time. The only device that accessed the Ring camera was John's phone. So we are well out of the woods now of Karen maybe went in and deleted Ring camera. You know, that's why she disappeared upstairs, right? Where the computers were. That was supposed to be the implication. Well, she could have gotten on one of the computers and gone in and deleted the incriminating Ring cameras. No, it didn't happen. Those cameras didn't access Ring. Those computers, they didn't access Ring. So that didn't happen. We're back to not having any record of Karen having access to the Ring system. She didn't have John's phone, right? She didn't have John's phone. We know she didn't have John's phone because Carrie Proctor had it in her pocket until somehow it ended up with Trooper Proctor. And then somehow Trooper Proctor gave it to Mr. Guarino, Trooper Guarino, later that night. Never accessed the Ring. With the cell phone extraction, yes, thank you for confirming. You put it in airplane mode or in a Faraday bag. You don't sit and scroll through it looking for the nudes because, yeah, that creates new data. I wonder if that's what, is that some of what the defense has in their back pocket? Have they re-extracted the phone? Have they been able to see what Trooper Proctor was doing with that phone? Oh, I'll be very interested to find that out. It would create a whole new set of history, whole new bunch of activity records, all these logs we've been hearing about. All you'd have to do is just extract it. So then they broke into her phone. They assure us that they didn't look at any of that privileged information. Okay, guys, so here's the deal. I've said this a million times. Warrants have to be particularized. They have to identify specific things that you're looking for in the specific area to be searched. And so that limits the scope of the search that law enforcement is allowed to do. If you're just looking for photos, they don't get to go and look in your text files. They don't get to go look in your contacts. If you're just looking for a text message, they don't get to go into photos, that kind of thing. But there's no real way to police it, at least according to police, okay? Because what police have said around the country and courts around the nation is that there's no way to do a partial extraction. You just can't do that. You can't really do that. What you have to do is you have to extract all of the data from the phone, and then it gets organized in the physical analyzer. It parses it, creates it in a readable type of format, organizes it all for you so that you can go in and you can look at text messages, you can look at Facebook, you can look at contacts, etc. And then you can search within that. So they assure us that's how it works. They extract the whole phone, but they follow the warrant when it comes to what they actually look at in that extraction. They don't exceed the scope of what they're allowed to look at in that warrant. And how do we know that? Well, because they pinky swear. They tell us. Yeah, I swear, promise. All I look at is that stuff in the warrant. It's an honor system. And how much honor have you seen in this police force, in these law enforcement officers? How much honor have you seen there? Mm-hmm. And where are we at now? The wall files? Now this guy, a third guy talking to us about Jen McCabe's phone. And the only wall files that were deleted were the ones for the calls on the 29th. Not the other ones? Why were those special? Why were those special? And then we have Karen desperately trying to get acknowledgement, trying to be seen, trying to be heard, trying to have her pain recognized by this person that's supposed to be like a partner, right? She's parenting your children here. And he's not having it. I said I'm sorry. That's it. That's it. I said I'm sorry. That's all she's going to get. Just refusing, flat out refusing to be empathetic to her situation. Doesn't want to fight anymore, but starts a fight. Yeah, I see what she's getting at. Starts a big fight, and then is like, I'm tired of fighting all the time. You started it. What you're complaining about is her holding you to account for it. That's what you're complaining about, not the fighting. You started the fighting. You're complaining about her being upset about the fighting. How many times have we heard that? Blame somebody for their reaction. It's not your wrongdoing. Not your wrongdoing that's the problem. It's their reaction that's the problem. The longer this trial goes on, I hate to say it, but the worse John O'Keefe looks. The worse he looks. I thought he looked bad after Aruba, but now I'm getting it spelled out. Now I'm just getting it spelled out in my face. This guy was a pretty terrible boyfriend. Mm-hmm. Yeah. Yeah, I get why she would be upset. I get why she would be upset. So she calls him, and they get in a standoff. They get in this standoff. She's going to call him. He's going to refuse to talk to her, refuse to answer the phone, refuse to call her back. He's gonna make it happen on his terms, when it's convenient for him, not when she needs it. Not when she needs it. What a mess, guys. What a mess. I've been bringing this up for quite some time. And I'm going to just real quickly go ahead and talk about this whole issue with the civil case. I'm going to see if I can make this bigger here. Because I happened to find this looking around this weekend, this case over here from the Ninth Circuit. It's from about 2017, not that long ago. It was Kathleen Zellner, interestingly enough. Here she is, one of the appellant's attorneys in this particular case. So Spencer v. Krause, what was this about? It's about a civil rights case for the deliberate fabrication of evidence by a state official. can be established by circumstantial evidence, for example, evidence that they continued their investigation of a person despite the fact that they knew or should have known that he was innocent. That can raise the inference that the investigator has an unlawful motivation to frame an innocent person. Or it can be shown by direct evidence, for example, when an interviewer deliberately mischaracterizes witness statements in her investigative report. In cases involving direct evidence, the investigator's knowledge or reason to know of the plaintiff's innocence need not be proved. So this was basically a case about fabrication of evidence. This person brought a claim against the sheriff's office, the detective that made these false statements in a report against another sergeant, basically the supervisor there. So the law enforcement officers that were involved, this had gotten reversed or kind of gotten overthrown by the district court on grounds that they didn't, according to him, they didn't have evidence that they knew or should have known that the plaintiff was innocent. But if there's direct evidence, that's what this case is telling us. It's what this case stands for. Direct evidence of fabrication, then they don't have to show that. That's all they have to show is just the direct evidence of the fabrication. So does that maybe give you a little sense of what the Commonwealth is fighting here? Maybe this is what they're fighting, the deliberate fabrication. This is why they need her to be guilty. This is why they need her to be guilty. 1983 is a very, very tough. It's a tough hurdle to clear, okay? That's what this is, a civil rights action, because this is where qualified immunity comes from. This is where law enforcement officers, according to the Supreme Court, under a variety of different rationales, they have to have actual knowledge, for all intents and purposes, that what they did in that particular case, specifically, their very specific conduct, they needed to know that it was unconstitutional or they won't be held liable for it. And so the way that they figure that out is they go through and they look at the legal precedent. They look at the decisions in that circuit and they look for circumstances that are similar. And then they start parsing, how similar are they? Are they close enough? Well, if he fabricated evidence by getting in and tweaking stuff on her cell phone, that's not going to overcome qualified immunity if the case law only says deliberately fabricating evidence by putting false statements in your report. And by the way, fabricating evidence by putting false statements in your report, that's not going to be the same thing as accidentally omitting names from your report. You're going to have to show stuff like, Ring camera video that was on DeChico's notes, but it's gone now. Weird. Sallyport video, it got flipped. It got flipped. That's weird how that happened. I wonder who did that. And this is where in my view, this is all coming back. This is why they are running such a strong defense on Jen McCabe and these searches, the Haas Long to Die in Cold and all this other stuff, is because they are trying desperately to show us we didn't know. If she did this, we didn't know. Because if they did know, if they knew all this was fabricated, yeah, not good. That would be pretty good grounds that the defendant should have known of plaintiff's innocence, right? They knew that evidence was being fabricated. So I just wanted to mention that because I happened to come across that while I was, doing research over the weekend. And yeah, when I think about it, that makes some sense as far as explaining why the Commonwealth has behaved the way that it has in this particular case, why they are running this pre-Buttle case, why this seems sometimes a lot more like a defense of the Alberts and the McCabes than it does a case to prove that Karen Read is guilty. This kind of explains why they are desperately throwing that SOS involuntary manslaughter life preserver of a lesser included offense out there, desperately hoping the jury will believe at a bare least, please at least believe she hit him. Even if you don't believe she did it on purpose, please at least believe she hit him. Might have a little something to do with 1983. All right, guys, let's get to your comments. Let's see how today has landed with you guys, because boy, the Commonwealth is running out of time here. Running out of time. Thought this was going to be the good stuff, and it just keeps getting worse. It just keeps getting worse. Peter Sitchell, I despise Lally's dump strategy stray. If I'm the jury, I'm pissed. This is your job. It is not our job to put all of this together and sort it out and make sense of it and figure out what happened. It was your job to do that when you decided to file these charges and to present them to a jury. Your job. Matt K., is the judge going to give the defense enough time to put on their case, or will they get shorted on time? Well, so according to what Turtle Boy was saying today, his information, it's been good so far. He said it was going to be Whiffen and then Guarino, and then next up will be the medical examiners. So tomorrow is voir dire. Wednesday we're not in. Thursday to Friday's a half day, I'm pretty sure, right? Thursday's a full day. Friday's a half day. We've got him resting, yeah, maybe Thursday, maybe Friday. Turtle Boy said defense planning to start Monday, so that's probably the time frame we're looking at. So how much time does that give the defense then exactly if the jury is supposed to have this by the last week? If the jury is supposed to have this by the last week, yeah, that gives them that week. If the jury is going to be done before 4th of July weekend, yeah, they don't have a lot of time. So, I mean, I am assuming, fairly or unfairly, that the defense has told the judge how much time they expect to need, and that's part of how, you know, all of this is gone. This is why she told the jury they're on track for that. But I can't imagine there hasn't been pressure from the bench, get this done before July 4th. I can't imagine there hasn't been. But it doesn't seem like much of that pressure has been applied to Mr. Lally, has it? Jason Sorensen, a blog has published papers now. He said, this is back to Ian Whiffen. He said he had published papers on stuff, but he didn't say what journals or anything like that. So I don't know. I don't know if he's now referring to his website, which did kind of sound like a blog. It did. It sounded like a forensic examiner's blog. I don't know. He didn't give us those details. Dennis Jensen, sometimes I can end up wondering how the U.S. scored as high as 69 points on the Corruption Perceptions Index, tied for 24th place with Barbados. Is that global, or is that just U.S. people grading their own perception? I would be curious about that. I do wonder how our vision of our own system, our perception, how does that line up with how the rest of the world sees us? As someone who has lived abroad, you know, I can say it's not a flattering perspective that much of the rest of the world, even, I mean, I was not in, you know, I was one of our close allies in Belgium. Okay. Northern Europe, these are our friends, and they don't have a very high opinion of us and our system and stuff. This is even years ago, before, you know, long before we were concerned about things like NSA. I mean, NSA, Patriot Act wasn't a thing, didn't exist yet, you know, all that other stuff. Remember when we got caught spying on those foreign nations? Yeah, this is before all that. So even back then, I'd be very interested to know, how does Barbados see us? How does Barbados rank our system to their system? And how does that line up with how we rank ours compared to theirs? I do have to wonder. But yeah, corruption. Jason Sorensen, the investigators didn't know how it could happen equals it wasn't good for their case. They couldn't explain. They couldn't recreate some of these things, you know, never heard of spontaneous deletion before today, but, you know, we're able to go ahead and wrap that, that concept up into our analysis on the fly. Just go ahead and integrate that very quickly. Couldn't recreate it. Not entirely sure how it works internally, so we're just going to assume it works in the way that benefits our perspective, because otherwise we have a problem. Theory Neutral. This has become my favorite series. Netflix sub paused. It's yeah, we're binging, aren't we? we're binging pretty hard on this one. Theory Neutral. Question for someone who just got here. Did we learn anything new about the 227 timestamp? I mean, not really. We got a new theory of it. And we learned that Haas Long to Die in Cold now also has some artifact that's from 1033. We got a whole bunch more database information that still doesn't seem to line up, and an explanation that still doesn't quite seem to work. And all of it is acknowledged to be editable by somebody who has that kind of knowledge. And he didn't get the information that he would need to be able to see if it had been altered or not. So that's basically what we got from this guy. From my perspective, he completely undermined the ground that Jessica Hyde had made with me. She'd made great ground with me. I'm buying it. I really was. I was buying it. But now you're going to bring in somebody with a different explanation, different data. He's able to get all this from Celebrite, but she wasn't. I just am not. I'm not getting. She had to use the Sanderson. It was the Sanderson program was the one that she relied on. Just undercut her as far as I was concerned. Really thought they were doing so well, and now the waters are muddied. It was your job, Lally, to tell me, who am I supposed to believe? Which one of these people is right? Am I supposed to flip a coin? Is that where we're at? You're just going to put it on and I'm supposed to flip a coin? You're not even going to ask these guys. Can you look at the other person's work? Mr. Whiffen, can you tell me how your theory corresponds with Ms. Hyde's theory? Didn't even ask that. Just a mess. Alyssa Ramirez, I hope defense asks if this guy got John's phone for all this data extraction. For Mr. Who are we dealing with here? Trooper Guarino. He did say he got John's cell phone from Trooper Proctor. We had Trooper Proctor on the stand, but we still have that big black hole between Kerry Roberts to Trooper Proctor. It's just missing. And I suspect that defense is going to ask Trooper Guarino about that because it's in his report. He's the one that put in his report, Trooper Proctor collected it at the scene. Well, we know he doesn't know that personally. We know that's just what Trooper Proctor told him. This is why the crime scene had to become something other than 34 Fairview, because Proctor was never at 34 Fairview that day. He never went there that day. Was he trying to say he was there that day before they asked to preserve geofence data? I wonder. I just wonder. So much to still wait for. I'm hanging on that commitment from David Yannetti. Wait for us. You'll be glad you did. I am waiting, Mr. Yannetti. I really, really am. Franz Marks, how many appellate lawyers are drafting briefs upon knowledge admitted by Celebrite that their reports are not accurate? Look, this is technical parsing stuff, right? It's not going to be like a big undermining of Celebrite in general. But could this potentially apply to other cases? Yeah, seems like it could. Seems like we've learned a lot about how Celebrite for iOS 15 is going to be a lot more. It's just going to be very different than what you're going to get from iOS 14 and earlier. So that could very well be news to an awful lot of people. Bruce West, none of this proves KR hit JO, only defends JM. Well, we've talked about why they might be inclined to do that, because if they knew that JM was fabricating, that could be a problem for them. John Beatty Bott, he confirms she Safari private mode searched Haas Long at 2:27 and deleted it. Time to send cops to Jen McCabe's house. I think he said repeatedly that it was not in private mode. At least what he said was that several of those databases would not write the file if it was in a private mode, which is basically incognito mode. So I don't think that's quite what he said. And he just seems very positive it could not have been a selective deletion. Why? Because it's not in the history file, but he acknowledges that could be rewritten by somebody with knowledge. Be rational and nice when in this global sandbox. Commonwealth use one data expert to overwrite a prior. It's kind of what it seems like. I don't know why we needed the second guy. We were doing fine with the first one. I don't get it. I don't get it. Maybe when we get Mr. Green on the stand from the defense, it'll make more sense. I'm just hoping and praying somebody can make sense out of all of this. Alyssa Ramirez, when did Lally become defense attorney for McCabe? When he realized the potential liability. If it can be shown that they knew or should have known. Yeah. If these forensic experts knew or should have known that that kind of thing was going on, that could be a problem for them. Nobody special. If phones are unreliable, then Lally doesn't have to explain half his witnesses destroying theirs a day before the preservation order. Yeah. I mean, it doesn't have to be reliable for that to be a problem. You just have to think it's reliable. That's what the consciousness of guilt is about. It doesn't have to actually incriminate you, but if you think it would, and if other people would think it would, that's really all it takes. That's really all it takes. That's why you would get rid of it. Horror Vibe 666, check myactivitygoogle.com. Is that a place to get your Google search history? I'll look it up right now and see what I see. You get a My Google Activity, tells you, yeah, it does. Tells you all kinds of stuff. Interesting. Yeah, go ahead and Google all that. Tells you when you look at like your interesting. I looked at house finch identification. I'm telling you, I have not searched for little brown finch for quite some time because I know most of my little brown finches around here. Yeah, I don't know about this My Google Activity. I'm not sure. Not sure it really works or if it's been updated or something. Oh yeah, no, because this is back in 2020. That's why. Back in 2020. Well, there is a lot of stuff on there, guys, and I can definitely confirm. Yeah, 2020 is about the time frame I might have been searching for little brown finches. So, So all we would need is Jen McCabe's Google account info. Look that right up. Lauren Boborin, convinced C data should never be used to convict. If somebody can explain it in a way that is coherent and makes sense and isn't going to be torn apart by a defense expert, then I'm not against it. I mean, I recognize that technical data often needs to be used at trial. It just does. I mean, I get it. But I mean, when you have all of this kind of discrepancy, these many layers of explanations, these different data, depending on which tool you plug it into, it just becomes increasingly unreliable to me. So I definitely get that. Anton Ivanov, President Lally wants to get the third-party theory out. Well, clearly, I mean, he's wanted that from day one. He can't stand the fact that they've even been allowed to, tiptoe around it with the investigation stuff. Bellow Bear, I have missed some testimony this morning, but my Nissan Armada will automatically brake for me going forward or in reverse. There is no way her Lexus didn't have the same technology. They didn't ask about it. I don't know if we'll get it from defense expert, but that would have been something to ask Trooper Paul about. Maybe he had bled enough. You got to save something for that defense case. Maybe he had just bled enough. But yeah, I've heard about these systems, and this is, I don't know when they started being available, but yes, Lexus is a luxury. It's a luxury brand. I expect them to be on the cutting edge of these types of safety features. I would expect them to have the new and cutting edge stuff. So can you turn it off? I don't know. Can you tell if it's been turned off? I don't know. But I would definitely love to hear some more about that in the defense case. Horror Vibe 666. Compare money spent to defend Jen versus convict Karen. Well, that would be an interesting breakdown, wouldn't it? Yeah, they spent money on Ian Whiffen, spent money on Jessica Hyde, doing these extractions. The time on Trooper Guarino. Yeah, it wasn't cheap. Wasn't cheap. Michael Muddragon. What I can't get past with Paul's testimony. Taillight hits John hard enough to shatter. Taillight cuts his arm. Pieces of taillight all over. I'm fine so far until no blood on the taillight, no taillight in his arm. Yeah, and it just, how does it just puncture? It scrapes his arm. Right? Scratches up his arm, these very straight lacerations, but it creates those pulling looking punctures in the clothing. How's that work? How's that work? No blood on any of the taillight. There's DNA that's got a mix of a bunch of people though. Right? What was it? A mix of three? Mix of three on those taillight pieces? None in his arm seems to be potentially a problem too. I mean, if this material is so brittle that it will shatter like this under this type of impact, yeah, you get like splinters and stuff, don't you? It's messy. It's very messy. I mean, just the mechanics of it alone are ridiculous. Just from a common sense standpoint, you don't get hit in your arm and that, your arm just stays stiff. Completely stiff as like a steel post and just throws you, that way. No, your arm gets knocked into your body and that force gets transferred into your body. Where's the big old bruise on your torso? There's none. Hey, did anybody see Gordon Ramsay's photo? He posted it on his social media this weekend. He got in a bad bike accident and he's got a contusion on his side that like you can't even see the whole thing because he doesn't lift his shirt up high enough to show you, but it's like from his hip pretty much to his armpit. Solid nasty abrasion. That's what happens when you hit something at a high impact, when you go down like that and you hit the road or you hit something at a high impact. My dad had a bike accident. He came off his bike at a pretty high speed, but it's a bicycle. We're not talking about a whole lot faster than, this 24, 25 miles an hour, maybe 30. I don't know. If you're really bombing it downhill, yeah, you might get that fast, but 24, 25 is pretty fast on a bike. Anyway, he came off his bike, landed on the road, bounced a few times. Oh God, broke his pelvis, broke his ribs, punctured a lung. He was messed up. From that. So yeah, having a hard time seeing this line up with his injuries. But, Trooper Paul assures us his injuries were consistent with the vehicle pedestrian collision. So I guess we can just be content with that. Unhung hero, have we calculated the speed that the state case is going over the cliff? I mean, I think the state case has to have some mass for us to be able to perform any type of equation like that at all. So what is the mass of the state's case is kind of the first question we got to start with. Not sure we're there. Mitch Mitchell, great coverage. Well, thank you, Mitch. Glad you enjoyed it. Appreciate you joining us here today. Mike from Providence, I would pay big money to see the faces of the Albert and McCabe family as they watched Trooper Paul's testimony today. To be a fly on the wall. Oh, to be a fly on the wall. I mean, I can't wait to go back and read about the jury reactions. Fall Reporter, we are counting on you. Fall River Reporter, give us the goods. Give us the goods. Tell us what they thought. Cow Palace Dave, forgive me for being a simpleton, but Ian Whiffen testified the Google search was deleted, and Jessica Hyde testified the Google search was not deleted. I thought he said that it was not user deleted. That it was deleted because the wall file was deleted. I thought that part was consistent with what she said. The wall file was deleted, but that wasn't that wasn't a user thing. That was just because of this, you know, what Lally tried to call spontaneous deletion, that he's like, yeah, I've never heard of that before. But the unknown internal processes of the phone could cause that to be deleted. I don't know. My eyes are crossing even just kind of looking at my notes from that, because it was so confusing. It was so confusing. All of these different databases and file types and timestamps and this history and that history. So I thought he said it was not user deleted, but I don't know. We shouldn't even be having to ask this question. It should be crystal clear what these guys are saying, and it should be crystal clear if it's consistent with the other expert or not. Unless there's some reason why you don't want me knowing. Should I not know if these guys have the same opinion? If their opinions can be reconciled with each other? Should I not know that? Is there a reason for me not to know that? Jacob Cobberholm, he said it's not in the browser history. It's in the iOS search bar history. It never made it to the browser history because the page never loaded. The experts are in agreement. I don't know, because that would have been a very simple way for him to explain it, but he didn't explain it that way. As far as I know, it's not in the iOS search bar history. It was in the browser.db. So in the iOS search bar history, I mean, just trying to flip through here to see what he said. I mean, we looked at all these different databases and it was all incredibly confusing. He showed us the plist and history database that corresponded, except we didn't have the Haas long to die in cold. So this is where he said they got the list of the recent web searches, and we got the Haas long to die in cold, how long T dying kicked, and then John O'Keefe BPD that she Googled around 8 in the morning. He said the searches wouldn't exist here if it was in private browsing. And then he talked about the failure to load. So if it doesn't load, that will be recorded. If it stalls, nothing gets written. If you close the window, nothing gets written. So if it didn't load, wouldn't that record at some point? I mean, he just gave us this different, you know, you can say it's consistent, but the problem is he's looking at different stuff and he's giving different explanations, and they're not relating them to each other. So I can't evaluate if they're in agreement or not. It should be explicitly out there. I shouldn't have to be asking that. Timmy Sargent, you are a hoot. Best channel stream I have found. Well, thank you so much. You know, I've said many times, you know, with the legal system, sometimes you can laugh or you can cry. And I don't like crying. I don't like crying. It's not fun. It's not fun. We gotta just find the humor in this stuff where we can. Because, yeah, what's our alternative? Our alternative is kind of depressing to think about. Pine Rider, I sure hope someone on the jury is willing to speak about this circus post-trial, especially if they have FU money and are not scared of local backlash. Well, you gotta wonder, I mean, this is getting so much national attention now. Are the ranks gonna close in Canton? Is there maybe a preference cascade that we are going to see? You guys know the preference cascade? They talked about that. It comes up with like Soviet Russia, right? The way that Soviet Russia was able to keep everybody kind of quiet about what was really going on and what they really felt about it is just because they suppress everything. And so everybody thinks I'm alone. You know, if I think this system is terrible and oppressive and it sucks, I'm alone. And so it takes something to sort of tip that scale for people to realize I'm not alone. And then that's when you get the cascade, right? Because once one person is willing to speak, then other people will join in and step up. Oh yeah, I feel that way too. And then suddenly you realize actually everybody feels that way and they've just been quiet about it the whole time. I gotta wonder if we're gonna maybe see something like that in Canton. Does everybody know this is a bunch of crap? And they've known it all along. I gotta feel like that kind of thing is already starting to happen with these, you know, select meetings and audit the police department, that kind of stuff. Is that a little bit of a preference cascade happening? But I would love to hear from the jury. I definitely would love to hear from the jury. I would never blame a juror for wanting to keep their anonymity after the fact, although that's another thing I've done a lot of research into over the last couple of years, like starting with Depp v. Heard. Juror anonymity, it's an issue. It's an issue. Not entirely clear that there's a good legal basis for keeping jurors' identities completely anonymous, at least once the trial is over. But I wouldn't blame anybody who's like, no, I don't want anything to do with this, because yeah, it puts a target on you. It puts a target on you. So it takes some balls to step out there and put themselves on the line like that. I sure hope somebody does it. Frank Philippus, a 45-year IT expert. They have not connected everything yet. I pulled this up, but I don't remember when it was in the testimony. So Frank, if you're still here, did they ever connect the dots? Did they ever connect it? I don't know. I couldn't tell. I couldn't tell. Floral from Under a Rock. Don't pick on Lallygagger. He reps the po-po. Yeah. Is this is this Mad Dog's alt in here? You're running through telling me, how dare you say bad things about the cops? And then where was he for Trooper Proctor's text? Huh? What happened there? Kay became a YouTube member. Welcome, Kay. Glad to have you on the team. Duncan, Idaho, with regard to the judge not allowing AJ to cross with leading questions, would these not be considered a huge weight of improperly sustained objections on appeal? Seems like it could amount to a big deal. So the only way I really see that, the way I see that coming up is just if it relates to a cumulative error type of argument, or if they use it as an effort to try to reestablish, you know, Judge Bev had bias. She was biased. She should have granted that original motion to recuse. In and of themselves as evidentiary rulings, no, they're not going to have a lot of weight. And the reason why is because most of these they're going to just be form-based objections. That's going to be the reason for sustaining them. They're argumentative. It's the only thing wrong with them. I mean, at least as far as I can tell, I can't come up with an alternative for a lot of this stuff. So they go to form. And that means that he's not precluded from getting that information that he's looking for out in front of the jury. He just has to ask it differently. Ask it differently, Mr. Jackson. You can have the admissible part of that question. So it would be a harmless, you know, type of situation, a harmless error type of situation at best, because, you know, he could have asked the question a different way in a different form that was not argumentative, and it wouldn't be erroneous for that reason. JT, how did Trooper Paul think he was qualified to give this evidence? He doesn't know anything, and he doesn't even know how little he knows. Yes, welcome to Dunning-Kruger. That's it in a nutshell. You get a tiny little bit of training, and then suddenly you are an expert in everything, you know? I joke all the time about, oh, I'm an expert in bloody shirts, right? I'm an expert in broken taillights. I hope everybody catches that, you know, these are jokes. I'm literally not being serious when I say I'm an expert in bloody shirts. I do have a lot of them, you know? I have a lot of photos of bloody shirts. I've bled on lots of shirts in a boxing ring. Yeah, and then you assume you know everything about everything. He doesn't even know how little he knows. I mean, that's the heart of it right there. It's gonna blow his mind if he's even there to see it, what a real PhD level accident reconstructionist is going to be able to do. It's gonna blow his mind. Boston Sarah became a YouTube member. Welcome, Boston Sarah. Appreciate it. Red Forensic. Andrea, I tried to send Addie. YouTube won't allow info at obvious URL. We can set up a time to chat. I'll write you down. Red Forensic. I would love to chat. Love to chat more about this stuff. I saw Red Forensic was in the chat. He does these forensic examinations. So I would like to know what you know for sure. Anton Ivanov, spent money on experts for search, not the accident. Yeah. Yeah, this is the same as that last point. How much are they spending to defend Jen McCabe versus how much are they spending to catch John O'Keefe's killer? Steve F, MSP blue light moonlights as Blue Man Group on the weekends because of all the bald heads. Yeah, they could. I could see it. Sandra, is he there as a representative of Celebrite or his own company? Yeah, good question. I mean, ostensibly, he seemed to be there for Celebrite, right? I mean, he was an employee. That's how he got the ticket. It's a service ticket. He described that. Got it assigned from somebody else at Celebrite. So he's ostensibly there for Celebrite, but yeah, he sure was talking up his own software quite a lot, wasn't he? I wonder what they think about that. Maybe they don't care, but to me, if somebody is, developing a product that's in direct competition with my own product that you work for me for, might not be all that thrilled with that. John Beatty Bot, he's fired on Monday, but okay, new product launch. He was pitching it, wasn't he? There's all of 600 users worldwide. Don't you get it? This is the next big thing. This is gonna rapidly take over Celebrate. His big feature was that you can do the stuff live, look at it in the computer while you're doing the extraction. All right. I guess I can see how that would be a useful thing that somebody would want to do. Be rational and nice when in this global sandbox. Jen McCabe admitted to being at rear of SUV during 911 call. She saw cracked or broken light and took pieces to plant at scene. Opportunity and motive, forget PD. Could be. Could be. Yeah. I mean, that is an interesting point. Who is at the scene? I mean, she was unattended enough to be able to wander her way into the house, and nobody paid attention. If they hadn't caught her on that dash cam, would anybody know? She apparently wandered away into the house. Nancy Korinsek. Thanks, Andrea. Well, you're very welcome. Thank you, Nancy. Horror Vibe 666. Each time Ian agrees with Yannetti, it muddies this already messic forensic testimony. Yeah, because Yannetti was asking him stuff that seems pretty common sense. Your simulation should be as close to that one as possible, right? Yep. And they were different operating systems, right? Yep. It's the closest he could find, though. So that's what he did. And the session history couldn't be recovered, and his testing results didn't result in a wall file matching what they got out of 4028. And then he gave this long explanation about how he couldn't recover the session files because there's so much information. When he manually deleted history, they were also deleted from the browser state. I thought that was interesting because that was probably one of the stronger things for the Commonwealth. I thought if the argument is that she deleted it from the history, but like just overlooked this artifact that's there in the browser state, that could be an explanation for why this is never showing up in the browser history. But that explanation wouldn't work according for him. So I still don't know why that Google search wouldn't show up later once the tab was reactivated, right? Once it reconnected, she's back on Wi-Fi or whatever. It just got very confusing, though, what was what and what was being stored where. It's just not great testimony. Not great testimony. He was not able to replicate the either selective deletion or not understood internal mechanism that makes that file go away. And the MySQLite stuff, you can make selective deletions. It would be possible, but there's a hash mechanism that results in the string of characters. We'd see it as being modified, except you didn't get that data. You admitted you didn't get that data. And then he admitted, yep, you could also delete and renumber the knowledge and history databases. Possible, but would require knowledge and skill. So it's possible. And there would be hash data that could tell you if that happened or not, but you didn't have any of that. Yeah. Yeah, that was a pretty good job. Very quick and effective at taking a lot of the wind out of that testimony. WM Penguin, as someone with a only partially functioning brain, it seems plausible to me, but I have zero clue how it compares to the previous woman's reasoning. They should have told us. That's their job. If you're going to put two experts on the stand and have them give explanations about the things that they did, explain to us whether they're consistent with each other and why or why not. We shouldn't have to be sitting here once again trying to figure all this out for ourselves. Literally Mr. Lally*s job. RN, Celebrite has been used in over 5 million cases worldwide from its own website, and it has this glaring flaw where records can just be wrong. I understand this does not undermine Celebrite altogether. It doesn't undermine Celebrite altogether, right? And his explanation now is that, well, we realize that the way that this particular data gets recorded, it could be misleading. And so now we've modified Celebrite so that it doesn't do that anymore. Because we recognize that could be misleading. Well, how many people were misled, I think, is the $1 million question. How many people were misled? iOS 15, pretty much anybody in iOS 15, it's reporting as a deleted search at a certain time. And yeah, now that looks unreliable. Gotta wonder. Kyle Murphy, how many classes did he take? 300 hours. Didn't he say 300 hours at Celebrate? All those classes. Parithus with a super sticker. Thank you so much. Appreciate that. Rudoka, he literally demoed how someone can access the database and change it in real time with his own tool he is giving away for free. If eSoftware can read the database, it can also change it. That's more than I know. You know, I don't know. I don't know how you access databases to read or write them. No idea. But yeah, he's definitely showing real time how to be able to generate this stuff on the phone. I don't know what the next step would be to go in and alter that, but it certainly seems like it should be possible. I just don't know how to do it. Carazola X, Andrea, how would you react if the jury came back guilty after all this, assuming the defense doesn't somehow incriminate Karen Read by mistake? You know, it'd be extremely disappointing. It would be very disappointing because you put your faith in the jury to see things reasonably, you know? And I'm increasingly, the more time goes on, finding the view that Karen Read is guilty of a crime here just increasingly unreasonable in light of this evidence. What's the proof? What's the proof? The proof is a couple people saying she said, I hit him, I hit him, I hit him, when she was in this hysterical state the following morning. Granting all of the problems with the provenance with those statements, right? Didn't appear in any of the initial reports, only got brought up later after the fact. All these different variations of how they happened. The busted taillight, which we can see on the Ring camera video, seems like it could have happened then. We've seen all this video now of the condition of the taillight, before, after, and it does not. The Ring camera video does not look like the totally busted out red section that we see in that Canton Cellphone. It does not. We're seeing red where there should not be red if that is the condition. And then weirdly enough, that taillight that they're able to reconstruct, it's just missing those few little pieces at the top. And when you look at that dash cam video from 8 some in the morning, that's the same part that looks like, yeah, there could be something going on with that part of the taillight. It's that part, not the entire taillight. That's all smooth, wrap around, flush with the side of the car. That part looks fine, but that one little chunk right there looks an awful lot like that piece that's missing in the reconstruction. And then the pieces they found at the scene, and boy, they couldn't even just keep them in the right bag, right? Stick with 3 or 5. They couldn't even do that. They couldn't even do that. The cert pieces, we lost the chain of custody. There's none. No chain of custody there. So that's the evidence. We're supposed to just conclude, we're supposed to believe that she's guilty beyond a reasonable doubt because we're supposed to think that it's so unrealistic that anybody would have been involved in this cover-up, that anybody would have fabricated evidence or you know, been part of a deceptive type of process here. But then look what they did with the Sallyport video, right to our faces. They did it to us in open court. They put on deceptive evidence. So why am I supposed to now find this so unbelievable? They were happy for me to believe a lie. They were perfectly happy for me to believe a lie and to think that that video that they showed us first was showing us the passenger side of the car. When actually, no, it's the opposite of what you would think by just looking at it. It's the driver's side. They did it to our faces. 0041, DeChico, see the taillights, looks like she's coming home, looking at the ring camera footage, and now that's gone, and I'm supposed to believe that these guys wouldn't do anything like that? So I would be very disappointed because that's what they have. That's what they have for guilt. I did it in the taillight stuff. That's it. Oh, wait, sorry. This data from Trooper Thumb here. I mean, if that hasn't been effectively demolished already, just with the key cycles, I mean, wait till we get to the math. Wait till we get to the math. But, you know, the key cycles are already done as far as I'm concerned. You didn't calculate it by the key cycles, which would make logical sense. That would be a very logical way to be looking back, but you couldn't do that because it doesn't work. That takes you to when the car is in police custody, when they are putting it on at the very, very earliest. When they are putting it on the tow truck in Dighton. It could not have been any earlier than that. What, are they going to say they left it running on the tow truck the whole time, so it was just the one key cycle? No, that didn't happen. That didn't happen. So that's their evidence, right? And that's why, I would be very disappointed, extremely disappointed, and honestly probably a little suspicious if a jury looked at that and said, yeah, guilty beyond a reasonable doubt. No, we haven't even got to hit him with a car, let alone, you know, why she would have done that. Rainman YYC, watch a couple of videos by Louis Rossman. He shows step-by-step desoldering repairs in Apple devices, no less. Oh, and did he have to burn the entire thing to be able to do that? I'm guessing he didn't. Just going to go out on a limb and guess that he's able to do repairs and remove solder without destroying the entire motherboard. Hooligan S3, there are YouTube channels that show motherboards, memory chips, integrated circuits, etc. being replaced, repaired in non-destructive ways. Nothing special or unique that wouldn't work in the auto industry. I mean, this makes sense to me. It doesn't make sense to me that soldering something to a motherboard is like a one and done type of procedure. Like, yeah, computers, you upgrade them all the time. You have to repair them and stuff. It doesn't make sense to me that it would need to be a destructive process. It's just that I guess it has to be a destructive process for them because they probably destroyed it. So that needs to be the explanation, is that destruction is necessary. Why? Because destruction is what happened. Kind of like how, you know, the pirouette is what we're dealing with because that's just what we have. It must have happened that way because that's what we have. Unhung Hero, as a mobile app developer, this is why I suggest against iPhone. They have given too many tools to the state to access data. Android isn't much better, but makes them work a little harder. I just assume that everything is accessible. I just assume it's all accessible, you know, and especially now with all the backups and the cloud-based stuff. I mean, what I do on my computer is feeding to Google, my phone is feeding to Google, my phone connects to my car. I just assume that's all going somewhere. That's the world we live in. We're in the panopticon now, right? The panopticon is the Michel Foucault's perfect prison where you're just under 24/7 surveillance. If you're under constant surveillance, you will just go ahead and control yourself. You know, you'll be aware of those eyes, so you will substitute your judgment for the judgment of the observer. You'll just act as if you're always being watched. Kind of feel like we're getting there. Nunzio, someone said kill me for sure. Ding, TP's grilling. Someone said God. Haha, I assumed it was TP. I didn't hear that. But I sure did hear kill me. Sure did hear kill me. And yeah, it was coming from that trooper right there on the stand. Angie Hammond, this is how me and my husband talk when we're being petty mad. Lol, she loved him. I'm just not seeing those texts being that bad. It shows me someone who's trying and someone who's pushing away. You know, that's what I saw. Trying so badly to be seen, and he just was refusing to do it. But Dial Brian, great name. As a man, I completely agree with you, Andrea. John is not being sensitive to her needs. He's actually playing with her emotions. It's narcissistic. I agree it's narcissistic in that kind of colloquial, use of narcissistic. I would go ahead and take it a step further and say it's emotionally abusive. Like there's a lot of overlap with how a lot of these things get discussed sometimes. But you can look at that with the abuse cycle and how it works in terms of the love bombing stage, and then there's a buildup. You're on eggshells. Is everything going to be okay? And then you have an explosion, something that puts you into that negative state, and then you just repeat the cycle, right? Because you got to repair that damage. So then you go back into love bombing. Seemed like we were past the point of John, doing more love bombing to repair the cycle, or maybe they just hadn't reached that point yet because they sure did look lovey-dovey at the bar, huh? They looked lovey-dovey at the bar. So, yeah. Appreciate you seeing things that way, like I said. I'm not a man hater at all. I love me. I love men. I love me some men. I love masculinity. It's like good stuff, really good stuff. I'm not a man hater at all. But there are definitely some men that have a hard time relating to women as women, just as people, as human beings, people with their own internal lives, their own feelings, their own experiences. And they have a hard time then respecting that part of the experience because they look at the woman and all they see is what they want from her. There's men like that out there. Patricia McLean, Lally Fail didn't end the day with advertised bad voicemails, 3 days to think about it, the last thing. Instead, the texts that don't show KR in bad light. Well, the last thing they're left with is him flailing around trying to find whatever he's trying to put into evidence that then he's not even going to show us, right? He's just doing an evidence dump. And then Bev's like, this is already in evidence. You don't have to go through that. Why don't you ask him a question about it? Put it on the projector, something. No. Yeah, just such a bad call. I mean, consistently with the time management. The only good time management I can remember Lally having so far is the day that he ended. I'm pretty sure it was a Friday where he ended with that dash cam video of the taillight. That was the only time he's had a good moment like that, where that's where we end the day, and then you have the whole time to think about that and stare at it. And well, did that show it? It looked like it showed a busted taillight. Problem, of course, we hadn't seen the Sallyport version of the busted taillight yet, so that we can look at those and go, one of these things is not like the other. His timing is just absolutely terrible. And you can tell that's why he wanted to end earlier. And Bev was like, no, we're going to 4:15. And then he didn't know what to do. But he seems to think these texts are bad. Why else would we even be looking at them? He seems to think they're bad. He's playing into that description we've already gotten so far. We already know where they were going, right? Karen's the whack job. She's a whack job. She's the psycho jealous ex. Jen McCabe set this story all up in motion, and Carrie Roberts, took it and ran with it. Jealousy over the ex-girlfriends. Who's she? Would he be at her house? All this crazy stuff about the ex-girlfriends. They're trying to set her up as like she's some lunatic, jealous, psycho ex-girlfriend, right? Doesn't look like that in the text. It really doesn't look like that in the text. The only thing I think they can try to get that from is her calling, blowing up his phone. She's blowing up his phone. There's a lot of people who would blow up a phone under the right circumstances they're not psycho X's. They're not psychos. They're not whack jobs. You're trying to be heard. You're trying to get somebody's attention. The text the next morning, what's that supposed to show? That she lied to him about being gone? I mean, we understand why. Because she's trying to get him to answer. And maybe if he doesn't care about answering me, maybe he'll care about the kids. Because we know she didn't leave. We know she didn't leave. She was there all night. She stayed with the kids in spite of all that. Is that what you would be texting if you just murdered him and left him to die? When everybody at the bar saw you guys getting along and having a good time, why would you now? Why would you now be creating evidence of a fight? Just doesn't make a lot of sense. Mama Carter, why not send the infotainment system to the FBI to extract? Maybe the FBI wasn't, or they didn't seem all that interested maybe in using the FBI, other than Brian Higgins, of course. Brian Higgins, he had access to those FBI services. But yeah, it's very common for local law enforcement when they have they just have limitations in their own resources and their ability to get stuff done. Yes, you can go ahead and reach out. I don't know what the relationship is between Canton PD and the FBI. I mean, that can be part of the issue, right? You burn a bridge at some point. Maybe they're not going to be so eager to help you. You don't have the contacts over there that you would need to be able to get something like this done. But usually that type of thing, you could do it at the high level. If nothing else, have Chief Berkowitz go ahead and call somebody that he knows. Surely he knows some people. Yeah, why didn't they do that? Who knows? Charles Argo, maybe an FBI friend could alter the phone records. Yeah, maybe. Would it even take somebody that sophisticated, or would, some IT professional in the McCabe family be able to do that? I don't know. Really don't know what's involved or how sophisticated that type of thing would be. All I heard was that it would take someone with knowledge and skill. Well, I assume an IT professional has knowledge and skill. Red Forensic, I pride myself in speaking plain English to judges and juries. Then you, sir, are a gem because that's like the main skill set that an expert needs. I would rather you be able to explain what it is that you're doing than that you be able to do all of the newest cutting edge, super technological stuff. If you can't explain any of that to anybody, it doesn't do them any good. They're not going to be able to make sense out of it. I also pride myself in speaking plain English to judges and juries. How else are you going to get them to vote for you, to side with you, to agree with your case? You got to be able to lay it out to people in terms that they understand. And the experts in this case have just fallen so incredibly short on that standard. Track worker, bet that is logged at 2:27 on the Google servers. Well, I sure hope we find out. We got that Google witness on the defense witness list. I sure hope that is one of the things that we find out from them. Eric Wolfrick, the human body isn't solid enough to set off the airbag, but an arm is solid enough to shatter that tail light, according to the Commonwealth. Yeah, not enough of an impact to create an event in the airbag control module, the ACM, but enough to shatter that plastic tail light. But he didn't know anything about the forces that would be required to shatter the convex tail light. That came up in the voir dire. I'm not sure he knows what convex is. Van Helsing with just a super chat. Thank you so much, sir. Appreciate your support. Red Forensic. Hyde and Whiffen agreed on the key point. 0227 search did not happen. Aside from that, they simply got wonky in different areas. Yeah. I mean, that's, I guess, the bottom line. They agree on the conclusion. What they looked at was different. How they got there was different. Me, yes, I'd like to see those reconciled because I'm picky like that. You know, I want to see things lined up. I don't like loose ends, particularly when there's a burden of proof here, you know, serious conviction on the line. But that is technically, yeah, the bottom line that they did both agree on, not at 0227. Pure jealousy. Her hub Matt is in IT. Is that knowledge? Yeah, you read my mind. My thoughts exactly. That's all they said. Knowledge and skill. I assume a person in IT has some knowledge and skill. I don't know if it's the kind of knowledge and skill that would translate into this, but I also don't know that it wouldn't be. Anton Ivanov. Jen was looking at State versus Peter T. Cupaza. Now, I don't know that, so should I look it up? There it is. It is an actual case. Wisconsin Court of Appeals. Peter Cupaza was convicted of first-degree intentional homicide and hiding a corpse with intent to conceal a crime. The prosecutor presented evidence that Cupaza killed his cousin, whose name I cannot pronounce, Muivano, I'm going to go with Muivano Cupaza, cut up her body and disposed of the body parts in the Wisconsin River. Cupaza argues that the trial evidence was insufficient to sustain his convictions and that evidence relating to a trained dog, which allegedly detected large amounts of human blood residue in Cupaza's apartment, was improperly admitted. We conclude that the evidence was sufficient to support Cupaza's convictions and that any error in admitting evidence relating to the dog was harmless error. We affirm the convictions. So is this a dog joke? Is this a dog joke? I'm not sure. I'll have to read through the rest of the opinion, but that was the intro. So trying to hide the body. It's always the cover up, never the crime, always the cover up. Britt Cormier, IR a simple jarhead. However, if key cycle 1164 equals Paul, 63 equals drive into Sallyport, 62 is her looking for him in the morning, 6-2 cannot be her hitting him. Even if put onto the flatbed with a winch, his math does not math. We know they didn't put it on the flatbed with a winch because we have that on video with the camera, right? The ring camera of Karen's dad. So we know they turned it on to be able to get it on there. But yeah, even if they didn't and you took that one out, it's still... You got to work this back. You have you have the flatbed at Dighton. You have Dighton getting to Dighton from Meadows, getting to Meadows from Jen McCabe's, getting to Jen McCabe's from Meadows and wherever else she went over the course of that morning. Those are all key cycles that would have happened after. I mean, they didn't leave the car running in John's driveway the entire time. We know that because we saw when she got there. The vehicle was off. They turned it on and they left. So yeah, there's a lot of key cycles in there that don't math the math. And it's just bizarre to me. That seems like such an obvious challenge. Like how did they not notice that? Or did they just not care because they never thought this was going to get to trial? Never thought it was going to get to trial. They were going to be able to point to that and say, well, that looks close enough. Let's call that it. That point that it would have been after the vehicle was in law enforcement custody, such a good point. Because now we're back to that fabricating evidence, aren't we? Now we're back to that fabricating evidence. Who took it out on the joyride and tried to make it look like there was data in the car? Who did that? Would love to know. Brian Alleman, I heard one of the witnesses describe hash values as encryption. I instantly knew he knows nothing. If you heard that, you heard more detail than I heard. I just caught that the hash values were a series of unique numbers that they would be able to look at and see if there had been modification. And he didn't have any of that data to be able to check and see. So they don't know. They don't know if it's been modified. They have no idea. Just because I just like that instead of looking for Burla competitors and places that use those, he just kept butting heads with Burla. Or why not check with Toyota? Why not check with Toyota? Why not just ask Lexus? Go to the manufacturer. Hey, how do we get this information? You got anything? No, he goes to the crime conference. He goes to the conference and goes to their booth. Those poor booth people. They're like, this is just a day job, sir. Like they're going to be able to answer his question? I mean, God, those poor people. Why wouldn't you just go to the manufacturer? Great question. I don't know. You know, it's all begging the question of, you know, I keep coming back to this weaponized incompetence. Was it that you couldn't, or was it that you wouldn't because you didn't want to? Did you not really want that information from that sat nav? And that's why it became so difficult to be able to get it. That's why you had to destroy the motherboard, trying to do this this chip pull thing that you described. Did you not actually want to know? Genty7, sorry, I was wrong about the curb Friday. Genty7, that is okay. It's not a problem. There's a lot of details in this case, a lot of things to keep track of, and they are expecting us to take a lot of things on faith here. So it should be easier for us to track what the Commonwealth is saying and why and what it's based on. That's the prosecutor's job. And when he's not doing that, I can't really hold anybody that responsible for not being able to keep track of it. Massage Girl, why does the Commonwealth keep asking their witnesses to opine on the defense's experts' opinions before they even testify? Shouldn't they save that for rebuttal? Yeah, they should. Yeah, they should, because they're not even rebutting it yet. So all I can conclude is that the defense didn't object to it. So this is being done for basically efficiency's sake. They already know what the expert's going to say. They've already got this guy on the stand. And so rather than going through that song and dance of making the expert come back on, you know, a week from today to say the new stuff, they're going to just let him go ahead and get it all out right now. And I can see the defense being okay with that, because that means they get the last word, right? They've already pre-butted it. They don't get to come back and answer now. So he's going to be able to answer their answer. If that's what's going on here, I think that's kind of a good move by the defense, honestly. Do we think Richard Green has just heard all of this and that's that? No response? Nothing like that? He's not going to come in and explain why he characterized it this way? He's just going to allow this depiction that he's the dum-dum here that just looked at the report and misunderstood it? Oh no, we're going to get an explanation. I got to assume we're going to get an explanation. Because why would they call him otherwise? You would just abandon ship. So if that's what's going on, yeah, not a bad strategy from the defense. Get the last word there. Allie, was the DNA from the other males on J.O.'s jeans also blood? I wasn't clear from the witness. So it was not clear. All we know is that it was the samples from the genes were taken from the spots that had been identified, the red-brown spots that she circled because you think those are blood. I talked about this a little bit last week because when I'm dealing with cases that involve mixed samples, I am used to seeing this major contributor versus minor contributor language. It has to do with the signal strength that they are getting from the different alleles that they find in the sample. And so a big difference in signal strength will tell you really strong source of DNA from one person, much weaker source of DNA from another person. It can get a little bit hard to interpret because people can have the same allele that can affect the peak height, right? It would increase the signal strength. If it's just this guy's, it would be this high, but you add in the same allele from this other guy, now it's going to shoot up. So I'm used to hearing that type of language in these analyses, and I didn't hear any of that here. And so I don't know what that means. I don't know if that means that they just don't do that type of analysis. They don't use that type of language for some reason that I'm accustomed to when I see these types of samples being discussed. Or are you not able to tell because they're all relatively the same size? Now, if they're all relatively the same size, that's going to create a big discrepancy in my mind with the source of this DNA, because human blood, very rich source of DNA. As the expert testified for many, many years, that was all. Like you needed blood, you needed semen to be able to get a DNA extraction, and you needed a fairly good amount of it too. They make a point always of pointing out red blood cells don't contain any DNA, which is true, but the other components of blood contain, they're, again, rich source of human DNA in the plasma and in the white blood cells. So you expect good, strong signal from John because it's his blood, right? That's what we assume, and that's what we expect to see. If it's just trace DNA, touch DNA, residual something from being on the hospital floor, you expect that to be a very, very weak signal because it's just a few cells. It may not even be cells. I mean, they can pick up trace DNA that's just literally like a fragment of the protein that's still there. Like it's so degraded, the cellular material may not even be there, but you have the pieces of DNA left. But you're not talking about a high quantity, something that is going to give a strong signal. And even when you amplify it relative to the other DNA that's in your source, that's getting amplified too. So the relationship between them, the proportion, it's going to stay the same. It's going to be a very dramatic difference between a very rich source of DNA like blood and a very poor source of DNA like a few skin cells, like trace DNA. So I don't know what to make of that. You're right, they didn't tell us. It wasn't clear. I don't know if we're going to hear anything about that from the defense, but it seems to me like it's the kind of thing that should be able to be stated pretty clearly if we have a minor contributor here. You know, at the very least, we can say that and rule out the possibility that these are both relatively strong signals because, I don't know, they're both coming from relatively rich sources of DNA like blood. Would have really been good for that to be ruled out, but it wasn't. The closest they got was, I think they said some of the samples were not suitable for comparison. That can mean low quality, but it typically means not enough alleles. Like you can identify that there's another person here, but you only have like maybe four loci or something like that. It's not enough to get a strong statistical, correlation to anybody. So you wouldn't be able to independently match that DNA to another person. There just isn't enough to be able to work with. Too many people would share 4 alleles for it to be something that is useful for comparison. But yeah, none of that major contributor, minor contributor. Would have expected to hear that. Didn't hear any of it. So I don't know. It's not clear from the witness, and we don't know. They can also do tests for other types of biological samples. So, for example, like saliva, semen. They can do different tests to see if it's a source from another biological sample like that. But skin, trace DNA kind of thing, they really can't. Not as far as I know. Really not aware of anything like that they could do to identify like this cellular material that contain that DNA. Just not aware of it. So we're left with blood and a mixture, and we don't know if that means it's a mixture of blood or if it's a mixture of blood and some other source. They didn't tell us. Mick of Time, search Craig, Casey, Canton. I think they might have been going for this. Remember, if they don't ask, it's on them. I definitely have not forgotten. If they don't ask, it's on them. Let's go ahead and look up Craig, Casey, Canton. In the Patriot Ledger is my top source. Oh, I've heard about this story. I'll go ahead and share this one real fast. Here we go. Oops, let me get that. Oops. Hours after police clear crash scene, body discovered in Canton Yard. Yeah, I heard about this. They went looking. There was an accident. More than an hour after police cleared the scene of a violent car crash in the early morning hours of Christmas Eve, a passerby spotted the body of a dead man in a nearby yard. The victim was Craig Casey, a 30-year-old Dedham man. So all of these people, the tow truck driver, the DPW workers, saw him. They didn't see him because it was dark. It was very dark. Although we wish we had located him earlier, we do not believe it would have changed the outcome at all. Oh, good Lord. So he still would have died. It just would have, maybe saved the people who found him some trauma. Might have saved him some trauma. Police were first called to the scene at 5:15 a.m. Monday for a violent car crash in a residential area near the intersection of Pleasant Street and Meadows Ave. Okay, so we know that neighborhood. When our officers arrived, they found a vehicle unoccupied that had sustained heavy damage. Officers searched the area on foot and in their cruisers for the driver, she said, and thought he may have fled the scene. Canton's Department of Public Works was also called in to clear a tree that had fallen down in the crash. According to police radio traffic, the scene was cleared at 5:51 a.m. So what? They spent less than 40 minutes at the scene. All right, we're all going to be clear from down here, an officer says over the radio. We searched the areas pretty good without finding any operator, another officer tells dispatch. Just over 1 hour later at 7:02 a.m., police were called back to the scene. Let me guess, getting close to sunrise now? They believe they have the operator on their front lawn, the dispatcher says. Look, if they can't find an entire dead body on the grass at the scene of a motor vehicle accident, then clearly we can't hold them responsible for not finding the pieces of, 45 pieces of plastic and the hat and the shoe when they were using the snowblower to take it down to the bare ground. That would be unreasonable because they can't even find a dead body. Rafferty said the department received a call from a passing motorist that there was a person sleeping on a lawn of a home near the accident scene. Officers returned to find the deceased Casey with major trauma, she said. Oh. I would like to know how far he was from the car. How far did they find him from the car? Yeah, how hard did these guys look? Here's the intersection. Where? Where was he? If they don't ask, it's on them. Because they sure aren't going to go look very hard, are they? They are not going to go looking very hard. McRae, how is John planning to get home that night? Oh, it's there in his text messages. He was expecting Karen to go get him. He was expecting Karen to go get him. I assume they talked about that over the phone because they didn't mention it in the text unless Lally skipped those over for us. Yeah, he expected her to go get him because she's waiting for the plumber. She's got the plumber going out to her house. Whatever town her house is. I can't even remember now. It's been too long since I remember that. But she lives in a different town. She needed the plumber out, something about being able to take a hot shower. So kind of sounds like her hot water heater went out. Yeah, I know what that one's like. We just had that one here not all that long ago. That's a pain. And yeah, you want to get the plumber out there so you can get that sorted. And I mean, I would think especially with a blizzard coming, if you don't have hot water, you get a little concerned about the pipes, the condition of the pipes. Maybe if you got an older house, you don't have frost-free stuff on the outside, I don't know. But you want to be assured that you have hot water. So she's waiting for the plumber. And he's like, why would you be doing that? I'm not going to have a ride home. I'll just do it on Monday. Just go ahead and not have hot water for the whole weekend. And that's how they got into the discussion about how, she hadn't been planning to stay in Canton the entire weekend because she's there playing mommy. And I thought we were going to scale that back. No, he was just expecting her to come pick him up, stay in Canton all weekend, and then he'd deal with her plumbing on Monday. I hate to say it, but I'm not sure I have all that much confidence that he was going to deal with her plumbing on Monday. The home run 3412. If she hit John O'Keefe at 25 miles an hour, how did car magically just stop? Tire tracks in snow. J.O. didn't roll. Are they forcing AJ to call them abrasions? Where is Chloe? Yeah, they're definitely not forcing him to call them abrasions. His whole theory is that the reason why you can tell from the vehicle data that this is when the accident happened is because it didn't magically just stop. It slowed. It just slowed, right? And we don't see where that ended, but yeah, we're supposed to have Brian Higgins' car, right? Brian Higgins has been insisting, and a lot of these witnesses have been insisting. His Jeep with the plow was out there in front when she was there. All these other cars in the driveway, and she just missed it all. She missed the curb. I don't know. They didn't do any kind of reconstruction. They didn't show me visually what would this look like? How exactly did this happen? Oh, we're going to get visual reconstructions from the defense. I already know we're going to get those. But we're not going to get anything like that from the Commonwealth. Where is Chloe? It was rehomed. That's what Nicole told us. It was rehomed. I just saw this, so I'm going to pull it up. The shoe was a rich source, but was never tested. The shoe was a mixture of at least 5 individuals. At least 5. On the shoe. On the shoe. The instep of the shoe. Now, what John's blood is doing on the instep of the shoe in the first place is a big, big problem for me. Big problem for me. Because gravity is the explanation for how blood gets on your shoe. Who's touching his shoe after they're getting their hands all bloody? I don't think anybody. How much DNA are they picking up? 5 people's DNA on the shoe. I can understand with a shirt, you walk past people, you hug people, you shake their hand, pat them on the back, you walk too close to somebody, you brush them, that's where. I can see, a lot of foreign DNA ending up on your shirt. A lot harder for me to see it in your shoes. You just don't have that kind of casual contact between random people out in the world and your shoes. And the insole of your shoe, It's like where you would grab it to take it on and put it off. Who's doing that? Who's doing that? Really, really, really hard for me to make sense of that. That DNA evidence did not help the Commonwealth at all. Did not help the Commonwealth at all. Did not do anything to rule out the defense theory that this was a fight. There's a reason why there's a whole bunch of people's DNA all over John, where you would expect his blood on his shirt would overpower like all of the other incidental signals that you might get from, sitting at a bar with people. Really does not make a lot of sense. All we heard about any of the DNA is that it includes male, and so that's really all that they can tell you if they don't go in and do more specific analysis. Because what all they're looking for, since every male and female both have X, right? So they're looking for Y chromosomes. The presence of Y chromosomes tells you that there's males. But you have to get more detailed than with the samples that you do have to break down, individually, would this be male, would this be female? And they didn't do that. They didn't do comparisons of those unrelated samples other than just comparing to Trooper Proctor and Trooper Buchanan. Those were the only people that they ruled out. And those were the taillight samples. Those were the only ones that they did any comparison on. So yes, exactly. Instep, drip, drip, drip. Uh-huh. Uh-huh. Yeah, if you're tumbling through the air, where's your blood going? Centrifugal force. I wonder if he's heard of that. Or is this technically centripetal? I forget which one is which. Yeah, I wonder if he's heard of that. It would be flying away from him, right? He's turning, it's flying away from him. None of this makes sense. None of this makes sense. Well, tomorrow we get a preview. We get a preview of the defense experts. We get a preview of their reconstruction. And we should be getting a preview of their injury, their forensic pathologist. We should be getting a preview of all of this stuff. And I'm very, very excited. I can't wait to see it. I can't wait to see it. If Lally is thinking this is going to give him an edge because he's going to get some kind of preview that he didn't already have, he's going to get a shot at him or something like that, I don't think that's going to pay off, because they're going to see what he asks. And then they're going to be attuned to, where is he trying to go with all this? I'm not really concerned about these people not being as smart as Lally, not being able to figure that out, him being able to outwit them, the battle of the wits. I don't see him winning that. So I don't know that this is going to work out well for Mr. Lally, because they're just going to see where he's going, and then when he's got him live on the stand, they're going to already know that, and they're going to be able to answer knowing that that's what he's thinking about and that's what his concern is. You lose a lot of that power if you've got something to challenge them on. You lose that power of the surprise. They're not going to be surprised anymore once you've already gone and taken these swings at them. Now they see your stuff. And they're going to know, wow, does this guy have a heater? Is this guy going to leave it out over the plate? They're going to see, they're going to know. They got a much better idea the more they see from you. These experts, professional experts testify. Okay. Professional experts, they testify. That's their job. That's what they do. They have seen a lot of prosecutors. They have been asked a lot of questions. They know this game. I don't think he's going to be outplaying them. Lorraine H. So initially I thought J.O. might have confronted B.H. because of the kiss, but now I see J.O. didn't really care that much about Karen. So what could be the reason for the fight? He didn't care about Karen, but that doesn't necessarily mean he was okay with his property, you know, being sniffed around on by this other dog. He didn't care about her, but he wasn't willing to let her go, was he? No, he wanted to keep her on the hook. He wanted to keep her on the hook. So I don't see these things as being mutually exclusive at all. You know, your ego with the dude, your masculinity, because that's your woman, you know. I don't see that being any less, even if you don't really care about her. It's not that he's concerned because, oh my gosh, she doesn't love me. No, it's you're coming into my turf. You're coming into my territory, and I'm going to police that. I think that's far more what that type of dynamic is about than it is about, you know, oh my gosh, I love this woman and I'm hurt. I don't think that's what's driving it. I could be wrong, but I think that still makes sense to me as far as a possible motive. So what do we make of today, guys? What do we make of today? I mean, just a mess. It's just another mess. Just another mess. I feel like once again we left today on a weaker position for the Commonwealth than we started. Because I don't know how to reconcile Mr. Whiffen and Ms. Hyde. I don't know how to reconcile these things. I understand the bottom line is the same, but I really want to know how they get there. I kind of need to understand how they get there and how come they seem to have such different pathways. Whiffen seems to get there through Celebrite, and she can't do that. She's got to go through Sanderson or whatever that other app was. Looking at different things. Why didn't she get the 1033 timestamp on the search? That didn't get factored into her explanation. Her explanation was the next morning when Jen ran the Google search and closed out the tab. Then that's when it finalized that 227, wrote that wall file. But he's got it. No, it had to have been in some type of suspended state or something until 1033. I mean, these are not the same events, even if the same conclusion that you're reaching, you know, they can be compared. You didn't get there the same way, and so that's a little bit of a problem for me. Paul, bloodbath for Trooper Paul. And everything that we've gotten so far from Trooper Guarino, kill me. Our takeaway is kill me. Because nothing bad. I mean, really hasn't been anything bad. She blew up his phone. That's the worst thing we got. They were fighting that morning. She blew up his phone. He was ignoring her, saying no, he's not going to talk to her. Didn't care what she needed. He's not doing this anymore. Once again, the person who comes away looking worse is John. It's not Karen. It's John. And that's so sad. It really is. It really is. I mean, a person doesn't have to be a saint to be a victim of a crime. Definitely not in that camp. Most victims of crime, you know, they are close to other criminals, like crime clusters. You know, you're a criminal yourself, or you're a parent of a criminal, or a sibling of a criminal, or a significant other of a criminal, you know, A lot of crime victims are, you know, not people that you would look at as like angels in any sort of sense of the word. So I don't expect that. But it's just crazy to me that to try to generate this narrative for a motive, to try to generate a motive here. They're willing to put all this out here and really tarnish him. We didn't need to hear any of this. We really didn't. We could have left this at John was the great guy who, you know, took up the parenting role for his niece and nephew at their time in need. What a stand-up guy, stepped up, changed his job at the Boston Police Department so that he could be a better parent. You know, wanted that responsibility. We could have left it at that. That could be how we are remembering John O'Keefe. But no, they had to try to gin up a motive here, and that's what they got. That's what they got. The relationship problems. Well, we can look at these relationship problems and see that John has a lot of responsibility for them. Like maybe just don't be such a dick. You wouldn't fight so much. Are we starting to see why this man was in his 40s? And didn't have a long-term committed relationship, just these short-term girlfriends? Are we starting to see that? I'm starting to see that. That was a red flag for me from the start. I said it. Red flag for me when a man in his 30s to 40s, heterosexual, in relationships, apparently straight, you know, but doesn't have long-term bonded relationships. This is somebody who has problems being able to maintain a consistent relationship with somebody. Didn't need to know all the details though. Really didn't need to know why. The home run 3412. How does glass fly with him but hair stays on car? It would have been a good thing to ask. How exactly do those forces work? The glass stuck to him. Didn't you hear Trooper Paul say it was attached? It was attached to his hand or to his clothes. You know, because something getting knocked out of your hand, if you hit your hand with a glass against the back of the car hard enough to gouge it out like that, you're trying to tell me you're not going to drop the glass? It doesn't work. It doesn't work. Try it. Try even just like kind of softly, you know, hold something in your hand and no, you're gonna drop it. Of course you're gonna drop it. How would it be attached to his clothes if it was in his hand? It just, of course, it's ridiculous. It makes absolutely no sense, and everybody in that room knew that. Cat's Pajamas, when you were calculating how much time the defense has to put on their case in the last week of June, I'm curious if you think there will be a rebuttal and how long you think that might be. I am thinking at this point that there is not likely to be much, if any, rebuttal because they're doing it now. They're doing it now. They are doing their pre-buttal. And I have to feel like this is kind of part of the deal from Judge Bev. When we're calculating how much time do we have left, how much time, you know, are we telling the jury before they get this case? She's got to be thinking about that too. So I don't know how they're calculating it. It's not going to be these experts. I mean, they would just be repeating what they already said, right? So we're not calling these experts back. Wouldn't think it's going to be the lay witnesses because all of this defense case stuff is already out there. House Long to Die in Cold, it's already out there. I mean, The only real possibility I see here is if the defense does in fact have something that these witnesses don't know about, they haven't seen yet, they haven't heard about, it didn't come up in the federal grand jury or whatever. But Lally's going to know about it. You have to produce that in discovery. So Lally's going to know about it. And that's why he's having these prep sessions with them so that they can know and they can be prepared to answer that type of stuff. So I just don't think there's going to be any big surprises in that sense. That's part of what Lally was doing here was trying to get out ahead of all of that because he knows what's coming. So just go ahead and have him address it now. And the idea then is, well, then the defense doesn't get a gotcha moment, an aha moment, when they have this. If the first time we were hearing about Haas Long to die in cold was in the defense case, it would be different. It would be different. It would leave a different impression. So I think he's done the pre-buttal, the pre-buttal already. I just can't see there being a lot. And it just may come down to how long does the defense take? I feel like they are going to be entitled to take as much of the remaining time as they want, given how much time the Commonwealth has spent. The Commonwealth has spent, let's just count them. This will be 1, 2, 3, 4, 5, 6, 7, 8, 9. We're at like 9 weeks here. 10 weeks maybe. I mean, they've had so much time, and the defense gets 1 is not too much to ask at all. And the defense has plenty of their own witnesses on their list. So, yeah, I think if they take up the time that's left, they're entitled to that. And then, sorry, Lally, too bad, so sad. If you wanted rebuttal time, you should have used your time in your case in chief better. If they finish with maybe a day to go, I don't know, maybe Bev would let him have some then if he's got something he wants to offer. And would he not try to get the last word? I just have to feel like he would try to get the last word. I mean, he does it with these redirects that are pointless, they're not helpful, but you just kind of look at it from a structural standpoint. Well, he's getting the last word. So what, did he win that round? No. No, he did not rehabilitate Trooper Paul with those questions. There was no point in doing that. So bottom line, I don't think there is going to be much of a rebuttal at all. I think the defense is going to get their last week, and they're going to use as much of that as they feel like they need. And then if there's any time left, then maybe that will go to the Commonwealth. But, Judge Bev could put a stop to it too. Nope, you got your time. It's time for the jury to get it. If they go the entire next week, that's the 28th. That's when the jury, okay, if they actually took evidence for an entire week, that means we're coming back on July 1st for the jury to get instructed and for closing arguments. And that's when the jury is going to get the case. So, yeah, not real long for them to avoid that 4th of July weekend. I just don't see it. I just don't see even Bev. I really just don't see her giving the Commonwealth that much leeway. She's been extremely generous with them already. And if they haven't been able to manage it effectively, it's just at some point that's on them. That's on them. So, all right, guys, I am looking forward to tomorrow. I cannot wait to hear from these experts. Yes, I am assuming it's going to be live streamed. It should be part of the public record. All of the voir dires so far have been. So don't see any particular reason why this one would not be, even if nobody explicitly told me that. I'm assuming it is. So I'm going to be here bright and early, and I am so ready for it. A preview of the defense case. What is not to like? The technical stuff. This isn't even the defense case of the good stuff. right? The things that I can see in that witness list and think, what are the Beatties going to say? And why are they on that list? Weren't they Jen McCabe's friends? Weren't they the ones she was calling in the morning? Why are they on the defense list? What's that all about? Lucky Loughran? Not even this stuff. Not even this stuff. The technical stuff. Okay, there's just, David Yannetti told me. He told me. You'll be glad. You'll be glad you waited. I'm ready. I'm ready for it. Please give it to me. Can't wait to see it tomorrow. So guys, I hope you will join me bright and early. It'll be a good one. I'm looking forward to it. I am excited. Thank you all for joining me again today. We had a big crowd today. A lot of people here waiting to see that trooper. Waiting to see that bloodbath. Very, very, very exciting stuff. Last little super chat to come up from Cat's Pajamas, asking for Richard Johnson in chat. Speaking of jury instructions, when do we find out if Lally won or lost his effort to get his instructions in? So what usually happens, they will wait until the close of the defense case, and then they will have an instructions conference. Because the defense has the opportunity to propose their own as well. And often that is not final until your case is closed, because there are things like instructions that need to be given if the defendant chooses not to testify, for example. Just a lot of things that can affect it. One of the ones I've been thinking about in the back of my head, because I have heard, there's a lot of rumors about this case. I don't really know what's true and what's not true, but I've certainly seen some of the evidence of like what's, been going on Facebook with like old Lizzie Proctor and that kind of stuff. So there have been hints that people have been intimidated. People have been threatened. Sort of wonder if maybe that's something the Beatties are going to talk about. Don't know, but I certainly do wonder. Anyway, we had that consciousness of guilt instruction that the Commonwealth proposed. Well, one possibility is that the defense might be like, yeah, we agree we need a consciousness of guilt instruction there, but it should be written in a way that accommodates witnesses also. It should potentially accommodate witnesses. If they hear evidence that witnesses have engaged in intimidation, that's the type of thing that might require a modification to that instruction. So you got to wait until the defense case is done before you can make the final call on what the instructions are going to be. So that's typically how it works. You finish the case. You have a conference where you go through all of them. The defense has now proposed theirs. The Commonwealth has proposed theirs, and you just go through them and establish, which ones are objected to, which ones are not. And the judge makes the call on what she's going to give and what she's not going to give. And then that's basically the last thing you do before they go ahead and decide what the instructions are, read them to the jury, and then go to closings. I assume that Massachusetts does instructions and then closings. They don't always. They didn't in Virginia. They did it backwards, and it was so strange to me. It was very bizarre. But the normal order of things, as I'm used to them, is you do instructions and then you do closing. So that's what I expect. There'll be a final instructions conference, and that's when we will find out all of those details about what he gets and what he doesn't. So do go check out my Substack piece if you haven't seen that. It's just my sort of quick take on what the Commonwealth proposed, what I saw in there. Not looking good for him. Really not looking good for him. So thank you all again for being here. Thank you for keeping the chat lively and interesting. So many of you so smart in there. You know so many things. I love it. I love having this font of knowledge like right here in the chat. It's fantastic. So thank you all very much for contributing to that. Just the good vibes we got going on in here. Love the vibes. So, you might as well have a good time. If you're gonna be putting in the time with a trial like this, there's this kind of attitude sometimes like, oh, it needs to be all somber and grim and funereal. No, it doesn't. You're allowed to have fun. You're allowed to have fun. It's part of the critique of the process. If the Commonwealth was doing a better job, maybe it wouldn't be so amusing. But here we are. So I will look forward to seeing you guys tomorrow, getting those defense experts, getting that preview. I can't wait. I can't wait. This is our first glimpse of that David Yannetti promise, and I am here for it. So guys, with that, I am heading out. Take care, all of you. Hope to see you back tomorrow.